Good afternoon. And welcome to the House Judiciary Committee. Today is February 24th. The first bill we are going to hear is Delegate Simpson's bill. Now, Delegate Simpson, you have two. Are we starting with House Bill 329? The witness panel that I have for you is Joyce King, who I see, County Executive Fitzwater, who I see, and Lisa Jordan. Will she be joining us?
She's in the Senate.
She's in the Senate.
She's in the Senate.
My condolences.
Yeah.
Okay. Delegate Simpson, whenever you're ready. Thank you.
All right. Thank you, Chair and Vice Chair, and all of my wonderful family on the Judiciary Committee. So I am here to present House Bill 329 because for school resource officers, prohibition on sexual activity with students. I think that says it all. Vote favorable.
All right, well, it's hard to beat that. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. Thank you so much for the opportunity to speak in support of HB 329, and thank you, Delegate Simpson, for sponsoring this important bill. For the record, I am Frederick County Executive Jessica Fitzwater, and as you heard, this legislation aims to close a critical loophole in current law, which allows school resource officers to have sexual contact with students at their assigned schools if the student is 18 years or older. Unfortunately, communities across Maryland and the U.S., including Frederick County, have faced this serious issue. Current law prohibits law enforcement officers generally from having sexual contact with victims, witnesses, suspects, individuals in custody, and individuals requesting assistance from the law enforcement officers. However, while Maryland recognizes the unique vulnerability of these individuals, the current law does not provide the same protections for students in our schools. Closing this loophole is crucial to ensuring that every student has access to a healthy and safe learning environment where they enter a Maryland school ready to learn. And just personally, for myself as a mother of two public school students right now and a former teacher, I'm deeply committed to the safety and well-being of our students and ensuring that every student has access to a safe and comfortable learning environment when they enter Maryland schools. I would also like to thank Joyce King and the Frederick County State's Attorney's Office for their assistance with advocating for this legislation as part of our Frederick County legislative package. And I urge you pass House Bill 329 with a favorable report. Thank you so much.
Thank you.
Good afternoon, Madam Chair, distinguished committee members. My name is Joyce King. I am Deputy State's Attorney in Frederick County. I co-chair the Special Victims Subcommittee for the Maryland State's Attorneys Association. On behalf of the MSAA, the Commission for Women, we asked for a favorable report. This is a straightforward bill, so I'm not going to belabor it. This does fill a necessary gap in 3307 and 3314 with regards to protecting students. Sadly, in Frederick County, we did have a school resource officer that groomed a child until she was the age of consent, age of maturity of 18 years old, and on prom night had sexual intercourse, and we were unable to prosecute that. In consultation with both the Office of State Prosecutor and well as our other colleagues throughout the state and the country, many other states have moved in the direction of codifying this to ensure that it does not happen. So with that, I ask for a favorable report.
Thank you. Lisa Jordan.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. Thank you for the aerobic activity. I am here in support of House Bill 329 about school resource officers. You know, school resource officers are sworn officers. These are people who can have guns. These are people who are police officers, and they help us in our schools, but they should be held to the same standard as other police officers and not have sex with the people that they are caring for, in particular students. For these reasons, and because students really view sexual assault resource officers as law enforcement, as people in authority, we ask for a favorable report on House Bill 329.
Thank you, and I commend you for being able to run across the street so fast.
Thank you, Madam Chair.
Members, do we have any questions? You dazzled them. So there are no questions, and that concludes the bill for House Bill 329. We'll move on to the next Delegate Simpson bill, which is House Bill 688. And whenever you're ready, Delegate.
Okay, so once again, good to see you all. Thank you, Madam Chair, Madam Vice Chair, appreciate it, and also all my wonderful members of the committee. Not all of you have been here each and every year. I know we have some new members, but this is a bill that's been introduced in 2022, 2023, 2024, 2025. It is one of those wonderful one-word bills. It changes from a felony to a misdemeanor for intercepted communications. So reclassifies it. Primarily, let's face it, I know we can't use, we all have cell phones. My primary reason for sponsoring this every single year, year after year, is it tends to be used against victims of intimate partner violence, young people who may have actually recorded a crime against them, and then when they go to report it and say they have documentation of this, they are told they actually committed a greater crime than the individual, whether it's rape or assault or whatever it is. So that is why I continue to support this. If you have any questions, please let me know. I hope we will once again get another favorable report, send this across the street and see what happens.
Thank you. Ms. King?
Again, Joyce King, Deputy State's Attorney, Frederick County, on behalf of the Maryland State's Attorneys Association. And I know that there are several wiretap bills scheduled for today, and my testimony will be somewhat redundant because our position is the same in standing up for the special victims units, that something needs to change, and that there are lots of cases with regards to rape, human trafficking, child abuse, and really outside of that, where the best evidence are recordings produced by the victim. And we are unable to utilize it in court. And as Delegate Simpson stated, not only are we unable to use it in court and prosecute those cases and hold those offenders accountable, but more importantly, they're subjected to felony crimes if not given immunity from the state's attorney's office. I'm in no way advocating for changing our all-party consent, but I do believe that this moving it to a misdemeanor, in addition to the other bills that we'll be testifying on today in regards to admissibility, are a direction that Maryland should and needs to move to update our wiretap statute, which is grossly outdated in comparison to a 50-state study in other states with regards to exceptions. We need to move the needle, so we ask for a favorable report again.
Thank you very much. And I neglected to call the rest of your panel, Timothy Bradford, and if Lisa Jordan is still here, and Amanda Rodriguez.
Mr. Mayor.
Laurie Ruth is here.
Yes, and I just didn't have her as a member of your panel, but Ms. Ruth, come on up. You are favorable, and I'll tell you.
We feel favorable towards Ms. Ruth.
Is Scott Schellenberger here?
He's in the Senate.
Okay. All righty. So Mr. Bradford, whenever you're ready.
Certainly, thank you. Chair, Vice Chair, members of the House Judiciary Committee, my name is Tim Bradford, Public Defender from Caroline County, and I am in favor of House Bill 688. First, when the statute was written in 2006, technology was a different place and the public's expectation of privacy has changed since then. Second, a felony conviction causes a litany of collateral consequences affecting employment, housing, public benefits, attending college, obtaining professional license, and serving on a jury here in the state of Maryland. Finally, by making this crime a misdemeanor, more of these cases be tried in the district court instead of tying up the already burdened circuit courts. Also, as a practical matter, most of the people charged have little or no record at all in these as well. The Office of Public Defender asked for a favorable report as to House Bill 688. Thank you.
Thank you. And Scott Schellenberger, you can come on up. In the meantime, Ms. Rodriguez, if you'd ready.
Madam Chair, Madam Vice Chair, members of the committee, my name is Amanda Rodriguez. I am the CEO of Turnaround. We're the designated rape crisis comprehensive domestic violence provider for Baltimore County and City. I'm also the co-chair of the Maryland Human Trafficking Task Force. So we are absolutely bringing forward some positive testimony on this bill. There was just a case that came across my desk in the last week in which a woman was being, it was a survivor of domestic violence. She was suffering from dating violence, and the individual, as often happens, there were cross-filed protective orders. He was also attempting to charge her with a variety of crimes. In doing so, he had a defense attorney himself, and the defense attorney called her and threatened her, telling her that he would, in fact, have her charged with recording, because one of the things that she did to protect herself was to record an incident involving the two of them. This is a real thing that happens in our cases almost every day, and we have a lot of young people, especially, who are recording these incidents on their phones. For that reason, Turnaround and the Maryland Human Trafficking Task Force request a favorable report. Thank you.
Thank you. Ms. Ruth?
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. We are the coalition that represents the domestic violence service providers such as Turnaround and other across the state. We are also strongly in favor of this bill. To echo Ms. King, our written testimony urges you to adopt this bill along with either HB 802 or HB 132 for all the reasons that you've heard. It's just really hard when you're dealing with clients to say to them, I know you have evidence of your own abuse, of your own victimization, and you can't use it. And not only that, if you try to, you could be charged with a felony. So this bill goes a long way towards moving it at least from the felony to the misdemeanor. I would suggest that the penalty is still too high under the bill. It's not altered. But if you're not willing to reduce that in order to that they, I'm not a criminal law attorney, but I think that helps them stay in district court and whatnot, then at least pass this bill, and we'll talk later about the other ones. For those reasons, we ask for a favorable report. Thank you very much.
Thank you. State's Attorney Schellenberger.
Thank you so much. Scott Schellenberger, State's Attorney for Baltimore County. You've probably seen me down here for at least 15 years saying, get rid of the wiretap statute. I understand this bill doesn't do that, but we're getting a little closer, so I think it's a baby step that we need to take. I think I've picked on them before, if Delegate Cardin and I started fighting right here, more than half the people in this room would pull out their phones and start recording. More than half.
Ready.
And she's ready. So, you know, this thing that we do all the time in this modern society is being hampered by this statute. And I understand that this isn't a repeal statute, but it's a baby step that I think is very, very necessary. To think that somebody could be charged with a felony for pulling out their phone to record audio and video or audio of crime, and that could be that's against the law. And it's not only against the law, but it's a felony. So at least I believe this is a good approach. House Bill 688, we should take this baby step forward and make it a misdemeanor so that it's not a felony.
That's right, folks. You heard it here first. We have a state's attorney saying to lower the penalty.
Absolutely, and most people never thought they'd ever hear me say that.
That's right.
And look at who's at the table together.
That's right. We got Office of Public Defender, State's Attorney. Okay. Do we have any questions, members? Delegate McComas.
I'm sorry, I just got to ask this question. A state's attorney has discretion on what to charge. I'm just, let's say we wouldn't pass this law and you had a really egregious situation where the woman taped the horrible message that she got, you know, I'm gonna, you know, cut your head off, blah, blah, blah. And you had that case in your jurisdiction, would you consider just not dealing with that and saying we're not gonna prosecute her for that?
Yeah, yes, I would consider that. But here's the part that got me started on this. When I was a young prosecutor with more hair and very dark, I'm sorry. I had a case where a grandfather was sexually abusing his granddaughter. And she had one of those old plug and plays. Y'all remember those recorders? She actually had recorded put it under the bed and put it on record because she knew the grandfather was coming in. And you could hear on the audio her saying, "No, Grandpa, no, Grandpa." And then, "I'm very sorry, but this case stuck with me for 20 years. You then hear the creaking of the bed. Everybody knew what was happening, and it sat in my office, and I could not play that in court. I could not play that in court. And that makes no sense in this modern society we live in right now today. So at least take the baby step and pass HB 688, and then I'll come back next year and ask you to get rid of it.
Thank you.
Members, do we have any other questions? Delegate Mangione.
Thank you, Madam Chair. And just so I understand correctly, and thank you for being here, Mr. State's Attorney, the example, though, you gave with Delegate Cardin would be in a public hearing in, obviously, a political establishment, whatever you want to call it, a public. So how does it work? Just so I can understand better, because I've never had this
So
before.
you are more correct than I was completely correct. It would literally have to be, and I think that's the story I did before, we would have to be back in his office. Because you're right, with all these microphones, everybody who walks in here is being put on notice that you're being recorded. We would have to change my hypothetical a little bit by being back in the office where it would not be presumed that somebody would be recording something.
Yeah, I'm just trying to understand to make sure I can grasp that, like, I guess somebody, not necessarily hacking, but somebody actually setting maybe their phone, I don't know, behind the sofa so they can hear what's going on in my office during a private meeting. And then they might have access to my office. You know, somebody just sabotaged me and come in when I'm not looking, grab the phone that was recording that I was unaware of. That would still be illegal? Well, nothing. You see what I'm saying? That's what
that would be if it was in a private place. But I'm sure it's just a hypothetical because you would never say anything inappropriate.
That's fair. Okay, I'll just look more into it, but thank you.
I love it. Delegate Mangione is new to the committee, but we already got him thinking in the judiciary way. All right, any other questions, members? Seeing none, that concludes the testimony for House Bill 688.
Thank you very much.
Thank you. Now, I'm going to step aside, and my vice chair will preside. Thank you. All right, thank you, Madam Chair. You may bring up your first panel on HB 802. I wonder if they're here, if everybody's here. If you're on this bill, and if you identify yourself, that would be great. Because I don't have my computer, and I'm at a loss. Okay, you may proceed. Thank you very much. So, members of the committee, we are here to present House Bill 802. I'm here to present House Bill 802, Sandy Bartlett, Anne Arundel County. So 802 is a measured update to Maryland's wiretapping statute. It allows courts in limited circumstances to consider highly probative recorded evidence to best serve the interests of justice. Under current law, as you all know and you've heard already today, if a communication is recorded without the consent of all parties, the recording is generally inadmissible to court, even when it clearly captures evidence of a crime or wrongdoing. So what House Bill 802 is intended to do is to create a narrow circumstance where a judge would be allowed to admit this type of evidence if 4 conditions are met. And so now we're getting to Delegate Mangione's question. So the evidence has to be material, meaning the recording has to contain material evidence that is material to a material fact. Sorry. The interception is not being made as part of a law enforcement investigation, because we already have laws for that. The evidence is more probative than any other reasonably available evidence, and admitting it serves the interests of justice. The bill also requires advance notice to the opposing party that you intend to introduce that evidence. It's important also to emphasize what this bill does not do. So it doesn't change Maryland's two-party consent, doesn't make Maryland outside of a two-party consent. It doesn't make Maryland a one-party consent. What it does is simply allow the recording to be admitted, and it gives the best evidence. So in the circumstance that State's Attorney Schellenberger just gave with the play, and what is it called? The plug and play. Plug and play, thank you. That evidence would be admitted because it was relevant, it went to a material fact, and it was probative. So this merely allows for us who already, we already, like he said, already have phones in front of us. We already have this material, and this evidence is out there but couldn't be entered. Maryland's wiretap statute was written decades ago when there were no cell phones or any recording technology. So today, nearly everybody has a cell phone, a smartphone that is capable of recording interactions instantly. And people record for various reasons, including documenting threats, protecting themselves, or preserving evidence. This issue is especially relevant to victims of domestic violence and other situations involving power imbalances, when recordings may be the clearest evidence available. So House Bill 802 has strong safeguards for application. Judges make the final determination on whether or not the evidence could be admitted. And law enforcement would not be allowed to bypass any current warrant requirements. And like I said, notice requirements are given to the opposing party. So ultimately, the bill strikes a nice, careful balance between protecting privacy and ensuring justice. For these reasons, I respectfully ask for a favorable report on House Bill 802. Thank you.
Thank you. Who would like to go next?
All right. Good afternoon, Joyce King on behalf of the Maryland State's Attorneys Association. And many of you were here for the 3-hour briefing that we had prior to session, academically walking through the history of the wiretap statute as well as what was being done throughout the country. And I think the most beneficial piece of testimony was from Professor Gray, who academically looked at the balancing act of balancing our privacy rights with the interests of justice. And his actual independent recommendation was to adopt exactly what this bill is purporting, which is maintaining our two-party consent, however, adopting our exclusionary rule to allow this type of evidence into trials. And I would highly suggest, if you're new to the committee and you weren't part of that briefing, to watch it or have your intern brief it, because it really was, in some summation, everything that we are here testifying on today. In addition to that, I did want to highlight, because there are so many new committee members, the other types of cases. I know State's Attorney Schellenberger talked about that rape, but we have these instances with regards to child abuse in daycare centers. We had it in an attempted murder case where there was a confession obtained by a victim's mother, and her abuser was intending to kill her, and while he was holding her hostage, and the judge found that was inadmissible, and the jury acquitted on the attempted murder count. We had it on firearms and assault cases, in extortion cases. If you think about it, if any of you were to be extorted by a bad actor or a criminal, the best evidence of that extortion are what they're saying to you. And how do you capture that but for recording it? But that would be illegal. Elder abuse, which we see an increase of in this day and age, where nanny cams are with audio are capturing the abuse of people's parents in facilities or in their own homes by their caretakers, and we are unable to utilize that evidence. So yes, to Delegate Mangioni's point, there are instances where wiretap is a crime and we do not want to encourage the illegal recording, but there are many instances where it's capturing the victimization and we want it to be admitted into evidence.
Good afternoon, Madam Vice Chair, members of the committee. Laurie Ruth from the Maryland Network Against Domestic Violence. I'm also here in support of House Bill 802. I think actually Ms. Rodriguez's story about her client is relevant to this. This is what happens in protective order cases, is that you have the recording of your own victimization and you can't use it. But the problem is that the other side is going to weaponize that against you and threaten charges. So I really, really like this bill, but I do have a concern about allowing it in civil cases because of that threat. I can't get immunity from a state's attorney. And I mean, if my client's represented, maybe I can call the state's attorney in the jurisdiction and say, look, we want to use this evidence. Will you please promise not to prosecute? But they're not really involved in protective orders. So I do have a concern about that. I still prefer it over the one you're going to hear later today, HB 132. But I do think it puts people who represent people in protective orders, like me and others, at least in my past, at risk because we don't know how to counsel our clients. Like, I've got this great evidence for my protective order, can I use it? Well, yes, you can, but he might walk right out of this courtroom and walk right over and file a statement of charges for you violating the wiretap law. So it is a problem that I urge this committee to talk through. There may be a way of building in some immunity here, I don't know. But mostly I've been testifying for years on these wiretap laws now. We need to do something. And I think Ms. King in both hearings has really identified why very successfully. So for that reason, we urge a favorable report on 802. Thank you.
Madam Vice Chair, members of the committee, Amanda Rodriguez from Turnaround and the Maryland Human Trafficking Task Force. This is an incredibly important piece of legislation for survivors of violence in Maryland. At Turnaround, we see dozens of cases each year where survivors did exactly what we tell them to do, to document what happened to them, only to later learn that the evidence they risked their safety to preserve is not admissible in court. These are survivors who recorded their abuse because they were afraid. They believed that their phone was their only witness, and they laid it down in moments of terror, hoping that if they did not survive, that somebody would know the truth. And that happened in one of the cases that we had in the last year. It was a college student who was at a party, began to feel herself getting woozy, believed she possibly could have been drugged, so she hit record on her phone, and what was captured was multiple rapes, not picture, but audio that you could hear. Only later did she learn that evidence could not be admitted and her case could not move forward. She told us that the lack of prosecution felt like she was being violated all over again. We also have a young man who recorded an abusive incident between his parents through a closed door. He was trying to protect his family. He was trying to tell the truth, and yet that recording too could not be used to keep them safe. So few cases of sexual assault and human trafficking ever reach prosecution. Survivors already face enormous barriers: fear, shame, disbelief, and retaliation. When the very evidence that they risk their lives to obtain is excluded, it sends a devastating message. Their truth does not matter. This legislation gives survivors a fair chance to be heard. It recognizes that evidence captured in moments of fear and survival should not be dismissed simply because of how it was recorded, and it moves us closer to justice, accountability, and safety. On behalf of the survivors that we serve at Turnaround and through the Maryland Human Trafficking Task Force, we request a favorable report. Thank you.
Good afternoon, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. Madam Chair, thank you for your continued leadership on this issue. We are also here in support of House Bill 802. In the Senate Judicial Proceedings Committee merely moments ago, they heard a very similar bill, and I just wanted to share two of the questions that came up there with the committee here. One, there was a concern stated by the Judiciary informing us, in case we didn't know, that it was a felony to make these these recordings. Of course, Delegate Simpson's bill would address this, and CASA very much supports that bill as well. The second issue that was raised is on House Bill 802 on page 2, lines 26 to 29, talking about how the evidence has to be more probative on the point than any other evidence. And there was concern expressed about this. So I just wanted to remind the committee that this is already in the rules of evidence. We have a long list of hearsay exceptions in the rules of evidence, and then there is what's called the catch-all exception that will cover the things that just don't quite fit into one of the other categories. It's exactly the same language. It's exactly the same process. And yes, there might be incidents where we would have a motion in limine. I can tell you from practice experience that I've also met this burden just through a proffer to the judge. So this is a very workable, very practicable method and something that fits well within the current law. For those reasons and the reasons expressed by my fellow witnesses here, the Maryland Coalition Against Sexual Assault strongly supports House Bill 802. This is an ongoing problem. People are getting raped, they are recording their rapes, and we are unable to use the best evidence. We need to at least give the judge the ability to make a determination that this should be heard by a jury or by the bench. Thank you.
All right, questions for this panel? I'm going to start with Delegate Arakan.
Thank you, Madam Chair, and thank you, Madam Chair. So you guys had briefly mentioned another bill that you're also on, HB 132. Can you just go over what exactly the differences are again?
I believe, I'm sorry. Is that all right? I believe, thank you, Delegate. I believe the only difference is that 802 includes civil cases, while 132 is only for criminal cases.
Okay, that's the main difference between them.
Other than that, I believe the language is identical.
Okay. And you said that you didn't like the...
I want the opportunity to use this evidence in civil cases such as protective orders, but I have concerns about retaliatory filing by the person who was recorded committing the violence, because I can't, Ms. King's not going to be there to give my client immunity. So in a civil case, that's the problem. I genuinely prefer this bill with that caveat.
And I will say that I did write down a note that I want to talk to Ms. Ruth, because I'm willing to enter an amendment to some, I just couldn't put it in my head. I couldn't visualize what could possibly be the amendment, but I did write down that I wanted to make a note to talk to her, and I said something like, maybe we can do some level of immunity if you bring the evidence of a recording in civil cases. I just have to think it through a little bit, because I also don't, everything we do, we have to make sure we're deterring bad actors.
Right.
So I have to balance that, but I think we could possibly come up with an amendment where we could do something to allow in civil cases, but also protect the person who's brave enough to bring it forward.
Okay, yeah, that makes sense. And the other bill doesn't touch on civil, it's just criminal. Okay, gotcha. All right, thank you.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you very much for the bill. And just going back to the civil, I see the civil in the line, I think it's line like 18 on page 1 of the bill. It's that's a criminal or civil trial. I'm wondering, so if we're going to take this step, wouldn't it make sense to just focus on the criminal right now, and if it works, and if it's working? My issue with the civil would be, maybe Ms. Ruth can talk about this. It's not just protective orders. It could be any civil trial whatsoever. So you are, if the Judicial Conference decides to take a liberal look at this legislation, it could, for all intents and purposes, decide that by policy that we're getting rid of the two-party consent.
And I understand that, but I strongly want to keep the civil in because of my next bill, quite frankly, that you're going to hear on fair housing testing. But I think that if someone has the recording of a tort, of a tortfeasor, you want to be able to also introduce that evidence. And I think that the goal is that, in rules of evidence, it says that all evidence is admissible, and then we get to exceptions, right? It doesn't say you can't get anything in, it's a blanket, all evidence is admissible, and then we start to narrow it down. So under the premise that all evidence is admissible, and then we get into whether it's probative, whether it's material, I think we need to focus, this is what this bill does. It focuses on whether or not it is probative, whether or not it is material. And because of that, I think it should remain in civil cases. If we need to, like I said, make some parameters, then, I'm willing to talk about that. But I just think that it's a shame to have the evidence out there and either the jury can't see it or the judge can't see it.
Well, I mean, the question is really, why don't we just have the discussion about two-party consent?
Because I will tell you honestly, we will not get anywhere that way. Because we're just not, no one's ready to have that conversation. This is a step in that direction, but not all the way there.
All right, thank you.
So Delegate Cardin, if I could just add, there are members of judicial proceedings in the Senate who are vocally on the record said, I am very, very protective of our two-party consent law. So I do think there's an obstacle there, but I would take the baby step if that was the only thing this committee was willing to do. If I were looking at an amendment, I might try and use person eligible for relief in a protective order as the smaller version of all civil cases, because I do take your point. But for these crimes that are against an individual in such a way that they are identified in the protective order statute, that would be reasonable to me, along with a little immunity on the side, as a side dish.
I am one of those people who's concerned about getting rid of the two-party consent, but I think that I don't want to bite it off and then realize, we just did what we knew that we needed to have a larger discussion on it. That's really the question. So, thank you.
Thank you. Any further questions for this panel? Sorry.
I'll make it.
Delegate McComas.
Quick, Madam Chair. Ms. King, do you know where, if you have the recording of that evidence seminar, because I wasn't around for that, that would be helpful.
Oh, that was a committee briefing.
Was it?
And it is available. We'll make it available.
Okay, all right, thank you, thank you.
That's good.
This concludes this panel, and it concludes the hearing on HB 802. We're going to move on now to HB 213. Madam Chair, you can call up your panel, or you would like me to?
If you could, I'm not sure who's here.
Susie McClanahan, David Wheaton, Albert Turner, Marceline White. That's the favorable panel. Thank you.
That's all we want.
Okay, you may proceed.
Great, thank you so much, and thank you, committee, for having me here to present to you testimony for House Bill 213. For the record, Sandy Bartlett, Anne Arundel County. So this bill actually allows for fair housing testers to be able to record. So now we're narrowing, just take your mind and just shift it just a little bit, and we're talking about one particular circumstance. And so the evidence, again, we start again with all evidence may be entered. And then we start to narrow it down to the type of situation. And in this circumstance, the type of situation is someone who's a fair housing tester. This person is someone who is doing fair housing testing based on the fair housing laws to find out if there's been an element of if there's been discrimination. Okay, so we want to allow for these individuals to be able to record because as you will hear, this is often the best evidence. You will hear how the fair housing testing folks are trying to remember the conversation, and they get back in their car and they, well, I hope you're going to hear that. If you don't hear it, I'm telling you now. They get back in their car and they have to write down all the notes of what they just heard. That is not the best evidence. The best evidence is the recording. So what we want to do is allow for that recording to be admitted into evidence without the running afoul of the two-party consent rule. So that's what this bill does, and I ask for a favorable report. Thank you.
Right, thank you. Who wants to go first?
Hi, my name is Susie McClanahan, and I'm the Fair Housing Director at the Equal Rights Center. Thank you for this opportunity to testify in front of the Judiciary Committee. The Equal Rights Center identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in our home community of Greater Washington, D.C. and nationwide. For 4 decades, the ERC has used civil rights testing as a tool to pursue enforcement of federal, state, and local fair housing laws in our service area, which includes Maryland, the District of Columbia, Northern Virginia, and Jefferson County, West Virginia. The Equal Rights Center encourages committee members to provide a favorable report. Civil rights testing is an effective, objective, and credible investigative tool to collect data about discrimination. Fair housing testing includes 1 or more people covertly engaging in a housing-related interaction, such as renting or buying a home. It may be used to identify potential discrimination by a property manager, leasing agent, or other real estate professional. The ERC is unable to record tests in Maryland, so testers must write detailed narratives of their experiences, relying on memory and notes taken during the test. Though our testers are trained extensively in accurate and objective report writing, we know there is always the potential that someone will question a report's credibility in a way that a recording would not be. On the other hand, DC, Virginia, and West Virginia only require the consent of one party to record. Testers in these jurisdictions typically record their interactions, and ERC staff later listen to the recordings to determine if there is evidence of discrimination. Human rights offices and one-party consent jurisdictions report to the ERC that test recordings significantly aid with their investigations of fair housing complaints. Individual clients have also shared that they feel more prepared to navigate the administrative complaint process if there is testing evidence that substantiates their allegations. Given the crucial role testing serves in meaningful enforcement of civil rights laws, we urge the delegates on the Judiciary Committee to move HB 213 out of committee and hopefully pass this legislation. Thank you.
Thank you. Next.
Madam Chair, members of the Judiciary Committee, my name is Albert Turner. I'm an attorney with the Public Justice Center. Public Justice Center litigates fair housing violations in the state of Maryland. To be clear, we do not do testing, but we do very regularly deal with these type of discrimination cases. So in 2020, this general body passed the HOME Act, which was a restriction on landlords from denying people because of their voucher status or because of any other sources of their income. Obviously, that is that's tantamount to typically what is called a bypass of racial discrimination. Overwhelming amount of individuals who are black, who are brown, have vouchers, and instead of denying a person because of their race, they were saying, well, we don't want to rent to you because of your voucher. And so in 2020, this body restricted landlords from denying a person for their source of income. However, this type of discrimination is still very pervasive in the state. We get calls from individuals throughout the whole state saying, I have a voucher, this voucher pays full share of the rent, this voucher pays 80% of the rent. However, I'm being denied based on the voucher status, and I'm being told on the phone, I'm being told in person that this landlord does not take their voucher. And as we are talking about this type of bringing suit against these type of landlords for this clear violation, obviously the best evidence is a recording of that interaction, because as the tenant who's calling might not be aware of their actual rights when they're actually having this phone call. The person on the phone might be, be giving some type of unclear advice or denial of this type of discrimination. So it's very, very important that when we bring these type of cases that we have the best evidence showing the person is violating the source of income law that was passed in 2020. For that, we ask for a favorable report.
Good afternoon, Vice Chair, members of the committee. For the record, my name is Marceline White. I am Executive Director of Economic Action Maryland Fund. We're here in strong support of House Bill 213, and I want to thank Chair Bartlett for sponsoring the bill. We all want Marylanders to live and be able to rent or purchase housing free of discrimination. And HB 213 will make this much more likely. I just want to raise a couple points. First, my organization does not have a fair housing testing program, so we will not financially benefit if HB 213 passes, but we're here in support of the legislation because it's good public policy. It is a HUD recommended best practice, and it brings us in line with 39 other states who allow this kind of testing. The need to pass this legislation is greater than ever. As HUD funding and enforcement has been slashed at the federal level, we're seeing complaints rising across the country. We're seeing, first of all, disability-related discrimination complaints rise, followed by discriminations based on race and place of origin. So we need in Maryland now to take action and stand up stronger regulation to protect people from unfair housing. I also just want to make a couple other points. Other colleagues will talk more about qualified for housing and the chain of custody, but I want to clarify this is a civil law, and so discussions about criminal procedure and police chain of custody are really a red herring and kind of muddy the waters. Many of these cases are resolved before they go to trial. They're resolved by educating the property owner that they may be violating a law they did not know about, or they're resolved by going to settlements. They aren't all going to trial. I also want to be clear that testing does not invade housing providers or others' privacy. Courts have been consistent on this point. There's no reasonable expectation of privacy when a tester is, in effect, a landlord's, in effect, consenting to show a tester a property and discussing it with the tester. That's business. And for these reasons, we ask for a favorable report.
All right, good afternoon, Chair, Vice Chair, members of the committee. My name is David Wheaton. I'm an attorney with the NAACP Legal Defense Fund, and I'm here to testify in favor of House Bill 213. Black people have long been systematically deprived of sufficient quality housing because they were routinely and openly excluded from living in certain areas. Fair housing testing is an important way to limit discrimination in housing. Fair housing testing is rooted in the fight for racial justice and is continuing to be used today to enforce and strengthen the Fair Housing Act. We urge a favorable report on House Bill 213. Fair housing testing is an important enforcement mechanism for the Fair Housing Act. Since 1992, the Department of Justice has resolved 111 pattern and practice testing cases with evidence directly generated from fair housing testing, leading to the recovery of over $15 million in civil penalties. Unfortunately, in Maryland, because of the two-party consent system, fair housing testers in Maryland are not allowed to record their fair housing tests. We support the authority that would be given by in-House Bill 213 to permit single-party consent for recording fair housing testing communications. There are significant advantages to recording testing transactions that strengthen fair housing enforcement and increase the efficacy of testing evidence. First, recording assures that details of a transaction are accurately captured. It can be difficult for a tester to recall everything that happens during the course of a test. A recording assures that all of the details are documented and that any concern that discrimination has occurred can be verified. When a recording is admissible in court proceedings, it is valuable and reliable evidence about discrimination, and it may be available when a tester has moved out of town or is otherwise no longer available to testify. Over 40 states have a single-person consent laws that permit recording communications related to fair housing testing. Fair housing testers in those jurisdictions routinely use various electronic recording strategies to document telephone and in-person tests. With reports of housing discrimination rising faster ever than before, every tool available should be used to ensure enforcement and fair housing laws needs to be put to use. We ask a favorable report for House Bill 213. Thank you.
Thank you. Questions, colleagues? Delegate Arkan.
Thank you, Madam Chair. Our previous discussion about the DV recording was making me think about what opportunities or risks could be run by recording these conversations. So I was just thinking about what is the anticipated recording devices that folks are using to do this? That's my first question.
Hi, like I said, my name is Susie McClanahan. I'm the Fair Housing Director at the Equal Rights Center. We are a testing organization that does fair housing work. We purchase our recorders from a reliable source. We follow strict protocol. Testers are not allowed to use their own devices for recording. They are strictly required to use ERC devices. We have a strict chain of custody protocol where testers receive the recording device prior to conducting a test. Upon finishing the test, they are required to immediately return that device to the ERC where it is kept in a secured location. And we also make copies of the recordings onto hard files and we put them in sealed envelopes so that we have untampered, sealed, secured files within a secure location.
Okay, and what actually are the devices? What are they?
We generally use audio recorders.
Okay, just regular audio recorders?
Yes, commercial grade audio recorders.
Okay, and do we know, like, for example, I'm trying to think of like if it's not been that long since I lived in an apartment. Like if I went into one office with somebody, there are paper thin walls, there's 5 other offices. So do we know what is the recording sort of general size area that you can record those conversations in?
Sure. So we are not law enforcement. We are not national security. They might have incredible audio recording devices. We are using audio devices that essentially would only capture a conversation within earshot and probably actually even less than within the average human's earshot. And for audio, like phone recordings, we are only capturing the information that anyone on the phone would hear during a call.
Oh, okay. So that would be a different device maybe if you were doing a phone recording, or is it the same
I'm not sure if the recorders themselves are different, but essentially we could be recording in person during, like, for instance, an individual doing an apartment tour. That is really only going to catch what that person could just generally hear.
Okay.
And then an audio recording is only going to capture what the tester who is on the phone can hear on their end of the conversation.
Okay.
We've never had a case in our 4 decades of doing testing where we have captured sensitive information that another, like, prospective tenant, for instance, would disclose. Like, we're not capturing side conversations in any way. Were we to, for any reason, capture sensitive information that was unrelated to the test, we have ability to redact the testing file, so such information would not be shared with any other party.
Okay, because that was going to be my next question. Like, we've had some horrible cases where there's been people that have worked for some of these companies who were committing DV, and so people might be coming in and complaining about somebody, and I would hate for that to be recorded and then saved somewhere. So you're telling me that does not occur, that would be immediately redacted? How is it redacted?
So,
is it just deleted?
To clarify, we are only recording tests as, for instance, a prospective tenant. So if there were an HR matter, for instance, domestic violence is occurring within two employees at a housing provider, unless they are having that conversation in the leasing office in front of prospective tenants, that conversation would never be captured at all during a test. If, for instance, somebody reveals, I don't know, a prospective tenant comes in and gives their social security number out loud, right? Everyone hears it in the leasing office. We record the test. That test is downloaded to a CD, sealed, stored. If we were needing to provide that copy of a test in some sort of proceeding, whether it was an administrative complaint or a court proceeding, we can redact that information, or recordings can also be provided under a protective order in court so that information does not become public.
Oh, okay, so that was my other question. So when this testing happens, how does everybody that was tested end up finding out, or only if it's flagged for a problem? Like, would I, if I was working in one of those offices, would I, like a couple weeks later, at least receive notice that I had been recorded?
So we do some of our testing actually on behalf of housing providers, in which case they are trying to do quality control, find out if, their training is working, their policies are being correctly implemented by their staff. When we identify, so those tests are provided categorically to those housing providers, and they then make the decision, if a problem is identified with a particular staff member, they might bring it to the particular staff member to address through additional training, clarification about their policies, things like that. We had a recent case where our testing revealed that a company's AI chatbot was actually engaging in discriminatory language unknowns to the company. They were horrified when they learned that and immediately corrected the issue, right? So they took that information to their team, got it rectified.
Oh my gosh, there's gonna be so much more of that.
Yeah.
Those things are out of control already.
Yes, we are deeply concerned about the use of AI in housing and the possible consequences to renters.
Okay.
But in the case where, for instance, we're not doing the test on behalf of a housing provider, we could be doing the test on behalf of a local government. So various Maryland governments in the last couple of years, including Anne Arundel County, Baltimore County, City of Baltimore, Harford County, Howard County, and Montgomery County have all paid the ERC to do testing to understand what is going on in their jurisdictions. So for instance, Anne Arundel County did fair housing testing, and then based on those results, designed education and outreach to housing providers and the public to just generally address the largest concerns.
Okay.
So in that case, no particular housing provider necessarily received the results of a test.
Okay.
But in the case where we are bringing enforcement actions, so say the ERC encounters discrimination, we end up filing a complaint. In one-party jurisdictions, frequently the first thing a housing provider asks for in the complaint process is, would you provide a copy of the recording? We'd like to listen to it.
Right.
We're happy to oblige, and we find that really helps addressing the issue early, getting the issue resolved, moving towards settling, and having the complaint fully resolved.
Okay.
In Maryland, we would provide the test report to the investigator, or in a court process, in which case the housing provider could theoretically read the report, but they're not going to have access to the actual conversation, right? Because it's not recorded.
Okay, what about if I was being tested and I didn't like the behavior of the person that had tested me? Could I get access to that recording? How would I do that?
So if you are a housing provider, and for instance, the ERC has filed a complaint, we have a recording, right? You can listen to the recording and also explain what was going on based on your end.
Okay, okay, only in the case where you have filed something, though, would I even know that I had been
Yes, and we are not publicly sharing any recordings as a general practice, to be clear.
Is there any laws about that? Or no, it's just your policy, but there's no actual laws that prevent that?
Well, it would not be in our, we consider fair housing testing to be a really valuable investigative tool, and we consider our methodology to be proprietary and confidential in order to preserve that. So I'm not aware of any fair housing organization, which this law limits only to fair housing organizations that would publicly releases testing information.
Maybe
like that.
an amendment could make sure that couldn't happen, something like that. Thank you very much.
Yeah.
All right, we're going to make this a last question on this panel because Madam Chair has to leave, so Delegate Cart.
I can direct this to somebody else if she wants to leave, but thank you. Thank you very much, Madam Chair, for bringing the bill. Ms. White, were you suggesting that chain of custody is, you said it's a red herring. Is it unimportant to have adequate chain of custody?
No, Delegate, I'm sorry if there was confusion. I was saying that this is a civil law, so discussions of criminal chain of custody, there's very important chain of custody, as you've heard Ms. McClanahan explain, and it's very important to the process. I was talking about criminal chain of custody and civil chain of custody, these are different instances.
Okay, so going back to the chain of custody and the other issues that you raised, the bill doesn't require your protocols and the standards that you guys raise, and the law doesn't require it to be the way that you described it, right?
So the law requires that the only organizations that can do testing are a qualified fair housing organization, which requires that the agency have at least 2 years of experience doing fair housing testing. Okay. We are following best practices from ISTEP, which is the Investigative Support for Testing and Enforcement Programs, a nationally funded program by HUD. Pretty much every qualified fair housing organization in the nation goes.
Okay, but if it's another organization and they don't use the same devices, there's no requirement in law as to what type of device you use. You said the device that you guys use would only pick up the conversation right in front of them. It wouldn't pick up, it's not really sophisticated. So there's no requirement to use those devices, would there be?
Not as a law is currently written, but to my understanding, there are only 2 organizations that currently conduct testing in the state of Maryland, right, which is the Equal Rights Center National Fair Housing Alliance.
But there's nothing stopping other groups from qualifying for this and being able to use their own policies, as long as it meets the law.
That's correct. That's correct.
Okay. So, and then they're listed on page 3 of the bill. You guys know this better than I do. Federal government is one of the entities that is involved. I am concerned, given some of the stuff that we've been dealing with recently, about the federal government's responsibility to keep information or to share information. Is there anything that stops, for example, another government entity like ICE from requesting and getting this information and being able to use it for nefarious purposes.
I'm sorry. So they would be using, actually, I'm sure your answer is going to be better than mine. You go ahead.
So to be clear, we are testing housing providers, not their tenants. We are not collecting any information about tenants and their, whether they're documented or things like that. We are simply seeking to determine whether a housing provider is complying with the Fair Housing Act, Maryland State Fair Housing Law, and other local laws.
I'm totally, I understand, and I'm only thinking about this, trying to think about the larger context. Just because you're not necessarily getting or looking for that information doesn't mean that that information is not going to become available. And given that ICE is now trying to solicit information from, for example, the IRS to figure things out, to use multiple points of information from fair housing, just something to think about, Madam Chair.
Delegate, I would just add, there is legislation before a different committee right now in the General Assembly about making sure that any kind of personally identified information, none of which fair housing testers have, is not shared for these very privacy concerns. So I know that this is something the General Assembly broadly is looking at in other committees.
But if it is a federal agency that has access to this, we lose control once that happens. That's just something to think about.
Okay, thank you. I appreciate that.
Yep.
Thank you. This concludes the favorable panel. We're going to call up the unfavorable panel now. I have Aaron Greenfield, James Johnson virtually, and Hugo Cantu. Is he virtual? Okay, you may proceed.
Thank you, Madam Chair. Thank you, Madam Chair. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in opposition to this bill. We've heard this bill the last several years. And with me, I should note, virtually is James Johnson, the former Baltimore County Police Chief, who's here virtually to testify and answer any technical questions. I do want to refute a couple of the points that were raised by the proponents. First of all, Ms. White had mentioned 39 other states do it, but the vast majority of those states are not two-party consent states. And there's nuance in every statute associated with those 39 states. We are a two-party consent state. We are indeed in the minority. The bill is indeed silent on devices used. The bill is also indeed silent, and we think handling of evidence is important. We think the chain of custody is important. It's not, this may not be a criminal issue, but we think the chain of custody is critical. The bill is silent on chain of custody. We heard in an earlier panel that instead of addressing two-party consent as a whole, we should take baby steps. Well, this is not a baby step. You're going right into the housing industry and you're recording conversations that could be overheard pertaining to a domestic abuse survivor as a way of example. So there is additionally no similar criminal requirement of reasonable suspicion or even mere suspicion of a pattern or a practice by a housing provider that would authorize such a recording. This is a slippery slope. Who's next? Bankers, journalists, elected officials. Housing providers would like an exception ourselves in recording code enforcement officers. Sometimes we get information we don't like, and we think it's wrong. This bill fundamentally erodes any reasonable expectation of privacy, and for those reasons, I respectfully request an unfavorable report.
Good afternoon, Madam Chair and members of the committee. My name is Hugo Cantu, representing the Apartment and Office Building Association, where we represent around 23 million square feet of commercial office space and about 167,000 apartment rental units between Montgomery and Prince George's County. And as my colleague mentioned, HB 213 creates the first of its kind exception to the two-party consent rule. Again, these are not baby steps. This will create the broadest exception in the country. And while the 40 other one, as my colleague mentioned, they're not authorizing the fair housing testers in this in their exceptions. Secondly, as MMHA noted, and what we're going to hear from Mr. Johnson, it's completely silent on the safeguards. It's completely silent on chain of custody, standards of secure storage, penalties for misuse or alteration, right, with AI. The absence of these protections is going to undermine the evidence itself and its integrity. And we'll concede that recordings are better evidence, but this isn't an argument about what's better evidence or not. This is an argument on recording authorization, that's an argument for admissibility. Thirdly, the other states that do not broadly authorize secret recordings, even California, their domestic violence exemption is limited to the recordings tied to serious criminal conduct. Lastly, many property owners, managers might have a centralized leasing office. So that means that if you're a leasing office, you may or may not be actually at the property. So you may not, in this case, be in Maryland. So if a leasing agent picks up the phone, they're not in the state of Maryland, a fair housing tester is recording, which wiretap governs? Maryland right now, I think, touches 4 other jurisdictions that have a differing two-party consent rule. Which law are we going to use? We asked for an unfavorable report on HB 213.
Okay, thank you. And lastly, Mr. Johnson.
Well, good afternoon, Madam Chair and members of the committee. My name is Jim Johnson with the Maryland Multi-Housing Association. I think relevant for today's discussion, I have 45 years of public safety experience, including chief of one of the largest police departments in the state of Maryland, and I'm very familiar with intercepting wire communications. I request an unfavorable vote on HB 213. This bill does not require probable cause. Why, this bill doesn't even require mere suspicion to conduct such an intrusion of recording another individual in a private conversation. There is no judicial review. There's no independent assessment or cause for that interception. Gathering evidence is a very serious pursuit. It's a serious matter. Unlike law enforcement, this bill does not require a chain of custody rules and procedures to ensure the evidence is not tampered with or manipulated intentionally or otherwise. In addition, this particular bill, there's no requirements for any safekeeping at all. In fact, I've heard testimony in the Senate that cell phones could be used. They're personal cell phones. There's no evidence vaults. There's no memorialization of who touches the evidence or moves it, listens to it, shares it. This bill just has none of that language at all. One of the most important things I think I need to stress is to get across an understanding of the leasing center where these recordings are going to take place. Oftentimes they're a living room of one of the apartments that represent what the tenant may be looking at. Why, they're 12 foot by 18 foot, sometimes with 2 and 3 desks, with multiple leasing agents, multiple customers or prospective tenants talking back and forth. The tester is not a party to that communication. They are a party to their conversation with a particular leasing agent they are testing, but they will pick up those conversations.
Thank you,
So I think it's really
Mr.
important
Johnson.
to
Could
point
you wrap
out,
up, please?
under Maryland's Safe Home Address Confidentiality Program, there are certain protections that Maryland affords individuals seeking refuge from domestic violence, human trafficking.
Thank you,
and other
Mr.
crimes.
Johnson. Can you wrap up, please?
That's all I have, ma'am.
Thank you. Thank you. Any questions for this panel? I'll start to my left again. Delegate Arakan.
Thank you, Madam Chair. You mentioned something very interesting about how we're kind of like carving certain groups out, and you had mentioned that you guys had wanted a carve out for code enforcement. What do you think if we added that into the bill?
I'd be all for it. Although I got to tell you, from a philosophical standpoint, we're against the bill in total. I mean,
Right.
I think it's very dangerous to start carving out exceptions to two-party consent law philosophically. But what's going to happen is if you pass this bill, you're going to see every year in session, you're going to have a wiretap day where everyone's going to come in and ask for exceptions to the two-party consent law. And so that's what you're framing going forward.
Right, I appreciate you guys, thanks.
Thank you.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you, Chief Johnson, for testifying. It's good to see my former police chief, who always did a great job. So you touched on a couple of issues dealing with both chain of custody and probable cause that you dealt with in the collection of criminal evidence and how you handled it. It was mentioned by a number of the proponents of the bill. This is a civil matter, not a criminal matter, so it's a red herring to talk about the criminal standards. However, we are gathering evidence, and we are trying to make sure that the evidence is used properly. Can you just describe to me and perhaps the rest of the committee some of the issues that you faced and why you dealt with such a high standard on collection of evidence, and why it would be important in a civil matter as well?
It's critical to handle evidence used for criminal or civil actions to ensure that the credibility of that evidence is not impeached. There's a preponderance of evidence that will be discussed in a civil process. The burden of proof in most civil cases, from what I understand, it's absolutely critical to document that chain of custody, the security of that evidence. Who touched it? Who manipulated it? We've heard testimony today that there's a way to extract the conversations of others. Well, that begs the question, what else was extracted, intentionally or otherwise, from that recording? So I think it's critical to rethink this issue of evidence when we begin to discuss the use of recordings to test, leasing agents. It's very important to follow the same rules. The equipment used, it's very important to have a set of standards, to have dedicated, certified equipment that a defendant can go back, request that information, and try to impeach the credibility of those recordings, for example.
Thank you.
Thank you. Delegate Moon.
Thank you, Madam Chair. Just on the question of judicial oversight in other jurisdictions, are there other places that have a model set up with judicial oversight?
I'm not aware of any. In fact, California, which is also a two-party consent state in 2023, the sponsor ultimately withdrew the bill. So I'm not aware of any. There could be, and I can do some more research on that.
Thank you.
Thank you. This concludes the unfavorable panel, and this also concludes the hearing of HB 213. Thank you so much. Now we're looking for takers. Delegate Conaway is on his way down from his office. I don't see Delegate Kaufman. Delegate Hornberger is not in the room. Are you ready? Delegate Phillips it is. Okay. Thank you, Art. I got it. I got Phillips.
Let's see what we got on the panel.
I'm sorry.
Around. Here we go. There we go. Join me.
Okay, we have Natasha Dartique, Kelly McConney Moore, Deborah Levi, Chris Burbank, Heather Warnken, and Theo Schmidt.
And Theo is in my office. Hopefully he will know that we're here and will come down and join us.
Okay, and Kelly is virtual. Okay, she's in a meeting.
Everybody good?
So I'm Carrie Williams.
Are you good, Delegate Phillips?
1 second. Okay.
Okay.
Okay. I'm sorry. Thank you, Madam Chair. Good afternoon to the best and the hardest working committee in Annapolis. Colleagues, bear with me. I'm having challenges, as you know, with my eyes. So I'm going to try to read this, and then I'll go from there. To Madam Chair, and in her absence, Madam Chair, I represent the 10th Legislative District, and that's relevant for this bill. I'm here before you to request a favorable report on House Bill 81. I'm calling it Safer Stops 2026. It's a priority bill for the Legislative Black Caucus. House Bill 81 is straightforward in its purpose. It reclassifies certain non-dangerous administrative traffic violations as secondary offenses. It does not eliminate enforcement. It does not prohibit citations. It simply requires that a stop be based on a primary safety violation, speeding, reckless driving, dangerous lane changes, or other conduct truly threatens public safety before a vehicle is pulled over. This year, we're guided not only by lived experience, but by Maryland-based research. Dr. Umar Usman, and I believe that's his testimony in our files, of the University of Maryland, Baltimore County, analyzed Maryland traffic stop data and found persistent racial disparities in equipment and registration stops that are not explained by public safety outcomes. His findings confirmed that low-level, non-safety stops disproportionately impact Black drivers while producing minimal public safety benefit. The data in Baltimore County reflects this pattern.
Excuse me. I apologize. We rushed through this docket, and we just realized that it's jointly assigned with ENT, and they're not in the row.
Sorry, Madam Vice Chair. You want me to start over?
My apologies.
Yeah, we got to get them.
You were ready, and
We have to wait. I get it. You want us to come back up? We can start.
I'm trying to figure it out. Is Delegate Conaway ready? Delegate Conaway's always ready, but hold on 1 second. It may be quicker to get ENT down. No, it's not. Do you guys mind?
No, it's okay.
Starting over?
Thank you.
I appreciate it.
All right, Delegate Conaway.
Delegate, you have your panel, Delegate Conaway? Are you ready? Well, I don't want you to be inconvenienced either, because you're not inconvenienced, on the record. No, I want you to take your seat over there. Thank you. Now go back. Thank you. Thank you, Delegate Conway, for coming to present HB 756. You may proceed, sir.
Oh, thank you, Chair. I appreciate you today. Thank you, committee. I'm Delegate Conway, here to introduce House Bill 756. We heard about some of this last year in the committee, and basically what this does is it says that if you use a video camera in your security system, the footage can be used for facial recognition if someone does something inside of your dwelling. And that's basically what that does. It's expanding the facial recognition usage to the interior of a dwelling only. So that's step one. And with that, I'd be glad to answer any questions if I could. With that, I would ask for a favorable. I appreciate you. Thank you.
Thank you, sir. We have one unfavorable on this bill. Are we good? One unfavorable, and it's Deborah Levi. Am I saying that correctly?
Thank you. It's Deborah Levy.
Levy.
That's okay. It's still funny, so.
Okay. What do you want? I think I'd like to.
May I begin? Thank you very much. Debbie Levy from the Office of the Public Defender. The Maryland Office of the Public Defender strongly urges you to issue an unfavorable report on House Bill 756. This bill represents a significant step backwards, expanding the number of crimes for which facial recognition technology, or FRT, can be used without a compelling reason. Just 2 years ago, this General Assembly, recognizing the profound risks of misuse, thoughtfully passed legislation placing strict guardrails on FRT. We limited its use to the most serious of offenses, a carefully crafted list determined with input from all stakeholders. House Bill 756 seeks to undermine that decision by making an arbitrary distinction, expanding FRT use only for images captured in a dwelling's interior. This distinction makes no sense. Interior dwelling cameras are largely maintained by private individuals, meaning the quality of images can vary greatly based on camera quality, lighting, and placement. The effectiveness of FRT is entirely dependent on image quality. By expanding its use to the least uniform images, we are creating a recipe for frequent misidentification. Furthermore, these digital images are vulnerable to manipulation, including the creation of undetectable deepfakes. Our current law already permits the use of FRT for serious crimes like first-degree arson and home evasion. However, the legislature wisely decided that the immense privacy implications and the potential for misidentification meant this technology should not be used for less serious offenses, regardless of the camera source. House Bill 756 is the wrong vehicle to revisit this critical policy. Expanding the use of FRT to a set of cameras with minimal quality control and oversight is a dangerous idea that undermines the safe and sensible use of this powerful technology. For these reasons, the Maryland Office of the Public Defender urges this committee to issue an unfavorable report on House Bill 756.
Thank you. Are there any questions? All right, this concludes the unfavorable testimony. Wait, was there another? Give me 1 second. Yes, that concludes the unfavorable testimony, and that concludes the hearing on HB 756. We have HB 762 next.
Thank you, Chair and members of the committee. I'm Delegate Conaway, here to introduce House Bill 762. It's a use of facial recognition technology bill, images captured by camera affixed to the dwelling's exterior. What the bill is trying to do is allow you to use something like your doorbell camera or some other type of recording device to take the image and to have that used by law enforcement, but for a limited amount of things, not for things that are going on across the street from your dwelling or down the street from your dwelling, things that are directly affecting your dwelling, such as arson, burglary, breaking and entering of your vehicle, not of your neighbor's vehicle, not of the people up the street, but your vehicle. So this is attached basically to your house, and this is one step at a time. First, we're trying to get the interior. Next, we're trying to get the exterior to protect your property and to use all the tools that we have. With that, I'll be glad to answer any questions if I can.
All right, thank you, Delegate Conaway. Delegate Taylor.
Thank you, Madam Chair. Thank you, Delegate Conaway, for this bill and the previous bill. And I kind of want to ask the same question on both of them. What's prompted you to bring this bill? What's the problem we're trying to fix here?
Oh, the problem, what prompted me to, I'm not going to get smarty with you, but what made me bring this bill was we worked on it last year. Yeah. And we were dealing with the facial recognition, and the question was interior, exterior. So this committee is very sensitive to these type of issues, so I decided to separate the issues so we could look to see if we're in agreement that you could use your camera, the footage that's taken in your dwelling, and that's separate, that's a separate bill than using the footage that's taken outside of your dwelling, because it's different kind of questions that'll be asked. Like, did you see something, or did the camera capture something that happened across the street or down the street? And that's not really what the intent of this bill, our bill, my bill is.
Thank you. So right now, any image that's captured by an outside camera affixed to your dwelling cannot be used as evidence in any of the offenses that you've listed.
What we're going to use this for is the facial recognition.
For facial recognition.
So yes. Okay. So if somebody does something to your house, if they burn your house down, you have the images of it, then you can't run it through facial recognition to find out who this person is. That doesn't seem technologically advanced to me, so.
Thank you, Delegate.
Thank you.
All right, any questions for this panel?
With that, I thank the committee, and I would ask for a favorable.
Thank you, sir. And now we're going to move on to the unfavorable panel, and we have Deborah Levy.
apologize if this is repetitive. Debbie Levy from the Office of the Public Defender. I'm here to urge an unfavorable report for House Bill 762. Just 2 years ago, this General Assembly responsibly enacted legislation to place strict necessary guardrails on the use of facial recognition technology, limiting it only to the most serious crimes, which would include, in the previous example, arson in the first degree. House Bill 762 seeks to dismantle that critical safeguard. This legislation proposes to turn privately owned doorbell cameras and similar devices into a sprawling, crowdsourced surveillance network. It expands the use of powerful FRT to investigate very minor crimes, enabling the continuous monitoring of entire communities for infractions as trivial as wanton trespass. Why are these private cameras being singled out? These cameras suffer from uneven image quality, dramatically increasing the risk of misidentification and wrongful charges. Furthermore, putting the collection of this sensitive evidence into the hands of private actors raises the specter of tampering and deepfake evidence that is difficult to detect. House Bill 762 is a profound overreach of state authority. The current statutory framework already allows for the appropriate use of facial recognition technology to investigate serious crimes. Extending its use to far less serious offenses unnecessarily infringes on the fundamental privacy rights of Maryland residents while doing little to actually keep the public safer. And to answer Madam Taylor's question, that first-degree arson, there's no current prohibition on using facial recognition technology to investigate a crime of violence. This would just allow private individuals to provide uncontrolled images.
All right, thank you. This concludes the hearing on HB 762. Thank you, Delegate Conaway. I don't see Delegate Kaufman. We have a phone call out, and Delegate Hornberger, and ENT is not in the room, so Delegate Williams says she's ready. Is your panel here? I wouldn't want you to. Yeah, we're going to be here so late tonight that I really need to fill in this space.
So I'm looking for Eric Wilkins, Lorraine Shaw, or both virtual. Lorraine Shaw is at the meeting, Eric Wilkins not. Okay.
It's up to you. Because if you don't, I don't want you to. Delegate Simmons, how are you? Are you ready? Yes, ma'am. Your panel's here?
So I have
your choice.
most of, not everyone. Only person that's listening is Eric.
Okay.
But I don't want to type the committee.
Okay, let's move ahead to the next one.
Okay.
And that'll buy us some time. There are two with Delegate Simmons. Oh. I don't see two. 11 and 32. Yeah. Thank you. Where's the third one? He's great. Thank you, Delegate Simmons. We're going to call HB 11 first.
HB 11.
Sorry. But these people aren't here.
Thank you, Madam Chair. Delegate Simmons, representing District 12B on House Bill 11, Anne Arundel County Sheriff, appointments of majors. Anne Arundel County Sheriff's Department is looking to add additional of 3 majors. This is a local bill that was heard in our committee on Friday and will be voted on this upcoming Friday. Unfortunately, the hearing got in between the committee vote. Anne Arundel County Sheriff's Department obviously is looking for supervisory officers in the command structure to fill these gaps for specialized units for the Sheriff Department. As a result of it, the Anne Arundel County Sheriff have submitted in his fiscal year budget of 2026 for an additional 3 majors. This is a local bill that will be coming out of the county council once moved forward by this committee. I'm asking for a favorable at this time. Thank you, Madam Chair. Once again, Delegate Simmons representing District 12B, coming to you once again for House Bill 32, dealing with external law enforcement vehicles, equipment, automatic external defibrillators as well. This bill comes out of an increased demand for law enforcement agencies throughout our state in response to their call as a first responder on calls dealing with cardiac-related issues. As you know, throughout our state, that police arrive at least 2 to 4 minutes earlier than a paramedic or EMS once a call has been dispatched due to the fact that they are already out on the road moving around in local communities. Although automatic defibrillators are something that is being deployed throughout our state currently in schools and hospitals, correctional facilities, here in this building, things of that nature, this becomes a critical resource for our police agencies, especially those in suburban or rural communities as well. I know there has been some opposition in reference to the fiscal note. I know that we've been trying to work, put a letter into GOCAP to look at some of the grant funding around the automatic defibrillators to make up for the needs of these departments. We're also asking for a favorable on House Bill 32.
Thank you, Delegate Simmons. This concludes the favorable panel on HB 32, and we have one unfavorable. And that is Iris Ibegulum. Did I do that?
No, but it's fine.
Okay, I tried. It's okay. Could you first say your name? And
Yes.
then you may proceed.
So good afternoon, Madam Chair. My name is Iris E. Babelum. Good afternoon, Madam Chair and members of the committee. Like I said, my name is Iris E. Babelum, and I'm here on behalf of the Maryland Municipal League. The League represents about 88 municipal police agencies across the state, which is about approximately 4,000 police officers. We greatly appreciate the intent of House Bill 32. We recognize the value of expanding AED access in emergency response situations. But as the bill is currently drafted, we must oppose it. The bill requires every law enforcement vehicle to be equipped with an AED, but it does not provide a dedicated funding source. So as written, this creates an unfunded mandate on municipalities and produces immediate and reoccurring costs. The upfront procurement cost for an AED typically ranges from $1,200 to $2,500. For jurisdictions with very large fleets, this can become quickly a substantial expenditure. In addition, AEDs carry ongoing operational costs. Battery replacements is every two to 4 years, which is about $150 to $300 per AED. The electropad replacement, which is every 1 to 2 years, is approximately $50 to $100 per set. Then there's also routine testing and oversight to ensure device readiness. There's also, or there could be training costs and administrative expenses associated with inventory tracking, maintenance schedules, expiration dates, and compliance documentation. Municipal budgets are limited, and this will require every local government or many local governments to redirect resources from other public safety priorities, or they'll have to delay necessary investments, or they'll have to absorb service impacts. This is not a disagreement about the pricing or value of an AED, but instead a matter of fiscal structure and sustainability. Because we have an absent funding stream here, this legislation would shift fiscal responsibility to local governments and their residents. So we're happy to work with Delegate Simmons to find meaningful and sustainable funding mechanisms, but for now, we respectfully oppose House Bill 32 in its current form. Thank you.
Thank you. Any questions for this witness? Seeing none, this concludes the, Excuse me.
Just real quick. Some of the municipalities have their own fire departments. Some of them are volunteers. They're half volunteers and half paid, and some of them are full paid. I was wondering if it would be possible if, let's say, I mean, for us, Bel Air, the town of Bel Air, the local police department is very close to the fire department. I mean, they're just like 2 blocks away. So would there be a way that you could kind of work with some of the fire companies to see if there was sort of like a certain boundary that in other words, not everybody would have to get the defibrillators? It would be just, you know, I guess, are there any studies as far as the locality where you can get one and how fast you have to get to the person to help them?
That's a good question. In terms of collaborating with fire departments, I'm not sure, I don't have the answer with me, but I can do some research and then reach out to you and send you an email about it.
Okay, all right, thank you, Madam Chair.
Thank you. All right. The hearing for HB 32. All right, Delegate Simmons, HB 349. Do you have your entire panel?
Yes, we're ready.
Okay, thank you. Then I'll be back, that's good. Michael Shear, Elliot Cohen, Ari Platt, Clyde Boatwright, and virtually Dr. Kashina Cross.
349.
All right, you may proceed, Delegate.
Thank you. Just get myself together here. Yes. Thank you, Madam Chair. Once again, Delegate Gary Simmons on House Bill 349, public safety, law enforcement, use of body-worn cameras. We'll be asking for a favorable on this bill. So as you know, with law enforcement agencies and command structure, right now we have great legislation that has been put forth by the good delegate to make sure that officers, law enforcement agencies have body-worn cameras. This is about senior staff, superior staff, kind of at the major level, captain, chiefs, things of that nature, making sure that there's accountability across the board for law enforcement agencies and the command staff of those agencies, that when they're out in uniform and on scene, that they also have body-worn cameras to be accountable for what they say and what they do while in the field. I'm joined here by an expert panel of law enforcement officers that are current in that duty and responsibility, and look forward to hearing from them on the testimony. So with that, I ask for a favorable.
Thank you. How would you like to proceed?
Mr. Boatwright.
Good afternoon, Madam Chair and members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order Police. We represent 21,000 members across the state of Maryland. We stand here with Delegate Simmons in support of this piece of legislation. This was an idea that we came up with a few years ago, and we felt as though it was best for our profession to ensure that everyone that is public-facing, that has a firearm and a badge and charged with the responsibility of enforcing laws, have their body-worn camera footage captured when they have an interaction with a member of the public. If you guys can recall, there was a few years ago when we went through the Maryland Police Accountability Act, there was some hesitation from law enforcement to go to body cameras, but we have found in the last few years that it's one of the best tools. Body cameras have helped and saved more careers than they have harmed, and we think that anyone that has interaction with the public should have that that footage captured. And so we stand in full support. And I know we have some other great members of our panels that can give you some more insight, but we just want to say that we stand in support of this piece of legislation. Thank you.
Thank you, sir. Who would like to go next?
I can go next. Yeah, okay. Slide it down.
Good afternoon, Madam Chair and committee members. I'm Lieutenant Elliot Cohen. I'm here on behalf of Baltimore City Police FOP Lodge Number 3. This bill is pretty simple. It just applies the body-worn camera requirements already in place for rank and file members to members of all sworn members of an agency, regardless of rank. I don't need to tell you all about the virtues of body-worn cameras. Our members are true converts to the technology and would not hit the street without them. We believe it's hypocritical for commanders who have espoused the benefits of cameras to now oppose those standards for themselves and their handpicked staff. It's something we see pretty often is that higher you up in authority, the less accountable you become. I do want to address two concerns regarding recording the public and cost. One is nothing in this bill requires commanders to record community members or their discussions with the community. The bill only applies the same standards that officers have, and officers are not required to record the community members or discussing, giving somebody directions. That's just not a part of what goes into being recorded by body-worn camera. And then on the cost, if the commanders feel that they are going to have to pay so much for footage and storage and cameras of what they're going to be recording, all the more reason they should be wearing cameras today. It means all of those incidents are not being captured now, and there's a complete lack of transparency on those events. As far as costs go, cameras are pretty prevalent right now. The costing is pretty competitive. Many of these agencies already provide $50,000 SUVs to their commanders for, driving to and from work. I'm sure they can afford the $200 camera to wear on a daily basis. Again, the cameras are popular. Public likes them. Officers like them. There's no reason any commander of any rank shouldn't wear them. So thank you.
Thank you.
Good afternoon. I'm Mike Shire with the Anne Arundel County Fraternal Order of Police here with the Maryland Fraternal Order of Police. I've been in police work for about 22 years, and I'm an attorney here barred in the state of Maryland. I can't say it much better than Lieutenant Cohen just said. We have many high-level officers throughout the state in various size agencies, from the small agencies where some of those higher-level chiefs are actively out on patrol up to the large agencies. They're taking police action. They're doing law enforcement. That means they're making traffic stops. They're responding to emergency calls for service because they are police officers. They are carrying a badge and a gun. They have the authority to do so, but they are not required to wear body-worn cameras. It's a little bit baffling to hear arguments that they should be exempted from the requirements of body-worn cameras. They are specifically there for accountability and transparency. We demand it from our officers. Our officers, as has been said, have accepted it and embraced it. Why would those police chiefs not want the same for themselves? There is no requirement for the chiefs to be recording community meetings, interactions with their elected officials, or anything that would be out of the ordinary. It is specifically for when law enforcement activities are going on, the actual law enforcement activities. The public deserves to see what's going on with all of their police officers, not just those of the lower ranks. And hiding that from the public does not seem to be appropriate. Why would we hold our chiefs to any less of a standard than we do our rank and file police officers? And with that, we request a favorable report.
Thank you. Next.
Madam Vice Chair, members of the committee, my name is Ari Plout, and I'm here on behalf of the Maryland State Fraternal Order of Police in full support of House Bill 349. Thank you, Delegate Simmons, for sponsoring this piece of legislation. We've heard all the arguments. I don't need to belabor the point, but transparency obviously is very important. Transparency should not depend on rank. This is a fairness bill. We all should be held to the same standard. Why should we have to wear the cameras but others shouldn't? We have some amendments that we think would address some of the issues, even though we think the way the bill is written is satisfactory. But it would spell out, it would clarify exactly which conditions the cameras would not have to be on. Current law, the local agencies have the ability to do that, but our concern is that if we give the power to the local agencies, they would just create the rules that would basically say chiefs don't have to wear the body cameras, and that's one of our main concerns about that. And with that, we would ask for a favorable report. Thank you.
All right, thank you. We have one favorable virtual. Yes.
I'm sorry, did you say favorable?
I'm sorry, excuse me. Yes. Dr. Kashina Cross, you may proceed.
Thank you, Madam Chair, and thank you to the committee for this awesome opportunity to speak favorably on behalf of House Bill 349, Public Safety Law Enforcement Use of Body-Worn Cameras. I respectfully submit a testimony in support. Requiring sworn officers to utilize body-worn cameras while in uniform in public and conducting law enforcement duties creates a consistent statewide expectation. This consistency matters, and residents should not expect different layers of accountability. I do acknowledge that this bill has an opportunity here to create state funding assistance and reimbursement mechanisms for economic as well as equipment acquisition, storage, maintenance, and long-term data retention. The state itself has a standard for activation as well as deactivation, and data retention should establish and prevent inconsistency in policy and interpretation across our agencies. This House bill moves Maryland forward by reinforcing accountability while supporting the professionalism of our law enforcement officers. And as a local government official myself, this is a thoughtful opportunity to address not only funding and implementation clarities. This legislation should enhance public trust without placing the unintended strain on local jurisdictions. I repeat, without the unintended strain on local jurisdictions. And for this reason, I respectfully urge a favorable report.
All right, thank you. I'm going to start with Delegate Boucher.
Thank you, Madam Chair, and thank you, gentlemen, for being here, and thank you, Delegate, for introducing this bill. Would the expansion of this coverage have a positive impact upon the liability insurance of municipalities?
I'm not an insurance attorney, but I think that any measure of accountability and transparency is beneficial to the public. And when you're showing what's actually going on, what we have seen is that more often than not, we are seeing that our police officers are doing it right. They're doing a good job. That could positively affect insurance rates, I would assume, when they can see that, look, everybody in the agency up through the rank of chief is doing a good job. So perhaps it would have a positive effect.
Thank you very much.
Thank you. Delegate Phillips.
Thank you, Madam Chair, and thank you, panel. And I love the idea. Everybody needs to be accountable. But I do have some practical kind of thought processes. In many instances, particularly like chief, he's called at all hours of the night to appear in all kinds of scenarios. I get a phone call and I'm out with my wife for dinner and I have to show up at a crime scene and I'm interacting. I'm not going to have my uniform on. I'm probably not going to have a camera. So are there exceptions for that built into this?
Yes. Yeah, so there's already an exception for people that are in plainclothes units who are not interacting with members of the public. So like a police chief that's going to a crime scene, he's there for supervision and oversight and probably not going to have an encounter with a member of the public outside of speaking to the media. And so there's no expectation that you would respond back to the headquarters to retrieve your camera and then go out to the scene because you're in plain clothes. And so, yeah, there's an exception for that.
Okay, and is there any requirement that a chief be in uniform?
No. It's the preference of the chief.
So how do we do that if the chief generally does not wear uniform?
So I think that will be handled similarly to the way our detective units are handled. So detective units, if they're in a suit, dressed like we are dressed today, there's no requirement to have a body camera on during that time.
Okay, thank you.
Yes, sir.
All right, Delegate Arkan.
Thank you, Madam Chair. Okay, that opened up a whole, so right now detectives are not included. They don't have to wear body cams because they wear plain clothes a lot. How does that work?
Yeah, so some of it does depend on the specific agency, but for most agencies, it's when the member is in an official police uniform. Sometimes it might be modified a little bit where it says police, but if a detective is in a suit and tie, maybe interviewing a witness or something, they're generally not wearing a body-worn camera at that time.
Huh, okay.
Keep in mind, the original body-worn camera bill was designed to show what was going on the daily street-type encounters. It gets very different when you're having an interview or something like that between a detective and a witness or suspect. There's most often going to be other recording mechanisms in place. We have interview rooms that have recording mechanisms built in place to handle that type of recording, so there doesn't need to be a body-worn camera.
Yeah, I see. I can see how if they're on site, but like if they're out in the community and like, let's say they're going to somebody's house and then a neighbor comes up to them and just starts unloading a bunch of stuff, that's not recorded right now.
It's dependent on agency policy. The standard across the state is the starting point is uniform. Most often it'll be permissive for being, there's nothing that says they can't wear the body-worn camera, so some elect to wear the body-worn camera, but it's the way it's set up now is uniform is the baseline.
So then technically a chief or sheriff could just be like, all right, well, I'm wearing my suit every day going forward, so they could just carve themselves out of this bill.
They could if that's how they want to present themselves to the public.
Okay. The only other question that I had before all that was, you had mentioned that it wasn't your intent to have it apply to sort of like non-investigatory things. But would it apply to communications between officers? So let's say they were on site and a sheriff or a chief reprimanded somebody. Would that also be included in your intent to record that interaction?
I know most agencies for internal personnel matters allow the cameras to be turned off. But if it's relevant to a criminal investigation that's going on, then the cameras are on.
Okay, so like, let's say the chief showed up and saw somebody was mishandling something and he's recording all of that, and that's your intent, is to include that as well?
You'd have to be a little bit more specific, I'm sorry.
So if he's on site and he sees something he doesn't like and he reprimands somebody on site, and that's gonna be recorded, and then that could be admitted into evidence, for example, for the defense perhaps, that, oh, your chief called you out for something, that you had done on site during the handling of the evidence, whatever. So that this bill would potentially allow that to be entered as evidence on behalf of the defense.
So I would say that if an officer is somehow mishandling evidence, that's discoverable information under criminal procedure and would have to be disclosed regardless of the body-worn camera.
Okay, thank you.
Thank you. Delegate Conaway?
Chair, thank you, delegate and panel, for coming in to testify. So I want to start off on page 2, line 6. Who regularly interacts with members of the public? What is the meaning of regularly? That's being struck out of the bill.
That's what's striking.
So while you're looking that up, my question is, are there currently any law enforcement members that wear body cameras that are not in uniform?
So as I mentioned earlier, most agencies are permissive, so you might have officers that are not in uniform that do wear body cameras or don't wear body cameras based on whatever's going on. You might have, say, a detective who's working in the office and making phone calls, would not need to wear a body-worn camera at that time. Is that?
Okay, so you just testified to that, so you're testifying that again, so I'll use a different type of terminology for you. Do the knockers generally have to wear body cameras? That's the people who come and issue warrants. That's what they're called in the city, knockers. Do they have to wear cameras anytime, anybody other than the detective?
Yes, so those officers wear a modified uniform, which is an outer carrier vest, and BDU pants, which is battle dress uniform pants, with the big, large pockets on the side. So that's the modified uniform, other than the everyday uniform that patrol wears, and so they are required to wear body cameras. Anybody and it's considered plain clothes, but it's plain clothes, but with large identifiers, like big, bold police across the front of the chest, they are required to wear body cameras.
But that is not an official police uniform.
That is. That's considered.
That is official.
We consider that uniform.
You consider that, okay.
Yes.
The purpose of considering that a uniform is to require the officers to wear body-worn cameras. Because we call it a uniform, that triggers the requirement to wear body-worn cameras to ensure that those officers are wearing body-worn cameras.
Okay. So really, the only people that you're trying to get are the people who are in upper ranks, because generally what you're saying, when there's interaction with the public, even though it's what the public might call plain clothes, those plain clothes are really described as being a uniform. If it's a sweat hood, I mean, I've seen police officers in sweat hoods and all of this. I think when you had the gun trace task force, I don't think they had all of them didn't have big police signs on them. I'm not really sure. I mean, that was such a long time ago, but I believe I've seen some police in some outfits that I couldn't tell that they were law enforcement.
And I can clearly testify and happy to testify that a lot of the interactions that the Gun Trace Task Force committed were captured on body camera, which helped successfully prosecute those criminals that were dressed as police officers.
Yeah, I'm understanding that, but sometimes that the Gun Trace Task Force didn't wear that quote-unquote uniform. Is that correct?
No, so that's the outer carrier vest with the hoodies under it, as you described?
Yes, yes.
Yes, that's considered a uniform.
So that's considered the uniform?
Yes, sir.
All right. Well, thank you so very much.
Thank you, Delegate Williams.
Thank you, Madam Chair. Mr. Platt, you were talking about some proposed amendments that you guys had, and I don't know if you saw the testimony from the chiefs and sheriffs. They also have some proposed amendments. And so I was wondering if you could kind of talk about a little further the amendments that you contemplating, proposing possibly, and how that relates to what the chiefs and sheriffs have proposed.
Thank you, Delegate. Yes, happy to submit this to the committee, but basically what the amendment would do is exempt what is not considered law enforcement related duties. So basically would say their concerns would be we don't want to show up to community meetings or have, conversations with constituents, and we're saying that that type of behavior would not be considered, and therefore you would be exempt from having to wear the body camera. But like I said, I'm just concerned that they would say in their written testimony that the chiefs would be able to develop their own policy that would just exempt them from anything. That's what we would be concerned about.
Okay, thank you.
Thank you.
Thank you. Members, any other questions? Seeing none, that concludes this panel. We're going to move on to unfavorable. And we have Daniel Franklin. Chief Franklin.
Madam Chair?
Yes, how are you, sir?
Fantastic, thank you.
Great, great.
Still following up on your request from our last hearing.
Well, whenever you're ready, and if you could just move the mic towards you, that's it.
How's that, a little better there?
That's perfect, thank you.
All right. Okay. Good afternoon, Madam Chair. I see Madam Vice Chair has left us and the members of the committee. My name is Daniel Franklin, Chief of Police, Morningside Police Department, Prince George's County. I'm here on behalf of the Maryland Chiefs and Sheriffs to provide favorable with amendments testimony on behalf of House Bill 349. First things first, I don't drive a $50,000 SUV, just in case anybody was wondering. By the way that this bill reads currently, I should be wearing a body camera right now. I am in uniform, even though it's a dress uniform. I'm conducting law enforcement related activities. We need to clarify what law enforcement related activities are. There's no, in the bill, there's no clear definition. To talk about the costs, okay, I have a breakdown. There are 6 different line items that go into cost, but anyway, the short version is for me to put a body worn camera on from the day that I started, it cost my agency $5,078. For bigger agencies, that is a tremendous lift. For smaller agencies, that is a tremendous lift. You heard testimony that body worn cameras are designed to capture the everyday activities police encounter. Not my words, previous testimony. All of my law enforcement related activities obviously are not going to be in the field. They're just not. I won't call it a privilege, but part of the job of being the chief is not always being in the field. Sometimes I have to do things behind the scenes, et cetera, et cetera. The thing that I have wanted to ask about, and again, I guess not ask is the right word, but the chiefs and sheriffs have submitted amendments. I feel that they are reasonable amendments simply because once we can clarify what a law enforcement related activity is, the rest of this bill will flow the way it's supposed to. But again, if you're capturing daily activities, enforcement activities, great. I don't think it needs to go beyond that. For those reasons, I ask you accept the amendments and give this bill a favorable with our amendments recommendation. Be happy to answer any questions.
Thank you very much. Members, do we have any questions? Delegate Woods.
Thank you so much, Madam Chair. Just would you clarify for me, I thought I heard that if they were public activities, if there were things like what we're doing right here with legislature, that the body worn camera would not be required. Did I misunderstand that?
You may have heard that, and we may have heard that. It is not in writing in the bill. So I don't know if that's a proposed amendment to clarify. That's what I'm asking for, is some clarification on what law enforcement related activities are. That's in the written testimony the chiefs and sheriffs submitted. It does go a little further down that road to clarify what they would be, in exempting community meetings and things of this nature.
All right, thank you. Thank you, Madam Chair.
Thank you. Are there any other questions, members? Seeing none, that concludes this panel and our bill hearing for House Bill 349. Thank you, Chief.
Thank you, folks. Have a great day.
We're going to move on now to Delegate Moon. We are kind of going out of order just a little bit for a couple of things that we need to go out of order for. So this is Delegate Moon. We have House Bill 904.
Thank you, Madam Chair.
Hold on, Delegate Moon. Just give everybody a chance to catch up. House Bill 904. Delegate Moon.
Thank you, Madam Chair, colleagues. This is a similar panel and a similar topic about equipping law enforcement officers. So this one, I hope, is pretty simple and straightforward. It basically says that law enforcement officers in the state need to be provided body armor, in other words, bullet-resistant vests and such that are not expired. They do, in fact, expire after a few years, and so all this bill does is says that you cannot provide expired equipment, and if you do, you have a month to get unexpired equipment, and if that doesn't happen, then GOCAP can withhold grant funds from the law enforcement agency until it comes into compliance and provides unexpired body armor. That's the bill in a nutshell.
Good afternoon again, Madam Chair, members of the committee. My name is Clyde Boatwright, President of Maryland State Fraternal Order of Police. We stand in support of the legislation requiring our agencies to issue bulletproof vests, bulletproof vests bullet-resistant vests that are not expired. We did a poll amongst our membership and found that agencies were sending police officers on the street with expired vests. We would not put our children or grandchildren in a car seat that is expired. And the main reason is simply these bulletproof vests have a warranty and a shelf life. And after 5 years, with all of the moisture, rain and snow and sweat that the vests are exposed to, the warranty, the manufacturer will not uphold the warranty if an officer is shot in the line of duty. And, you know, I've had the unfortunate opportunity to go to shock trauma to see police officers after being shot. And thankfully, there's been a few instances that it was the bulletproof vest that saved the officer's life. So I will say we stand in support of this legislation. It's not a funding issue. Most police departments issue these vests anyway. You know, we just got to make sure that our officers have equipment that is not expired when they're expected to go out and enforce the laws. We just had, you know, of course, last night we had a Maryland State police officer that was shot at conducting a traffic stop. And so the dangers of policing still exist, and we just want to have the best equipment available when we go out on the street to perform. So with that, we want to thank Delegate Moon again for sponsoring this legislation, and we're asking for a favorable report.
Good afternoon, Madam Chair. My name is Angelo Consoli. I'm the second vice president for the state of Maryland, FOP. I'm here in support of this bill as well. This body has passed bills that have mandated seatbelts in cars, mandated child safety seats that aren't expired. And this is a simple list. We think that it only makes common sense that you would send a police officer out with a vest that can stop bullets and save his life, but ensure that it's working order and that it's not expired. It's a safety issue. We have laws on the books for the fire department for their safety equipment, mandating that. So we feel it's something that is definitely needed. The thing we have also found is those that don't have it, like Clyde had mentioned, it's not a monetary thing. There are several grant streams for agencies to help them afford the vests. Most agencies, if not all of them, have gone to even though there is no law, there is no requirement that we are in a vest, that we do have them. So it's not like we all of a sudden have to come up with 1 million vests. We do have the vests and we are issued them departmentally. The problem is we have agencies out here that have no accountability for those vests. So once they issue it, some of them have been lax in their monitoring of it and then just not reporting it in a timely manner. They take a while to then get replaced. The vests, as Clyde mentioned, when they get wet and get sweat on them and through the rain and everything else, the fibers that are in them do deteriorate in time. A vest, people have mentioned that the 5 is a manufacturer's thing. It can go long, it could go short. You don't want to take a risk with it, but the main thing is the manufacturer will not warranty it after the expiration. So we just ask that we have it, and we do have to have the penalty phase in there, because to just say do it, if the department doesn't do it, like a lot of other things, what's the caveat when they don't do it? So if they're doing what they're supposed to do, this never becomes an issue, and it's just a law that does the right thing. So with that, we ask a favorable report.
Good afternoon, Madam Chair and committee members. I'm Lieutenant L.A. Cohen, here representing Baltimore City FOP Lodge number 3. This bill is important in keeping officers safe. Bill requires agencies follow accepted manufacturer and National Institute of Justice standards without imposing significant costs. Most law enforcement agencies in this state already have internally accepted that the protective body armor needs to follow NIJ and manufacturer standards, and that the body armor should be replaced in a timely manner. However, there's currently no mechanism to force agencies to follow their own guidelines. At the Baltimore City Police Department, when the FOP first raised this issue over a decade ago, there were more than 300 officers with unsafe body armor. As recently as December 2025, there are still dozens of officers assigned expired vests. Other members across the state have had similar issues. The legislation takes a balanced approach because the bill does not place any additional financial costs. Agencies have already generally budgeted to have these vests available to members. It just ensures that they do it. So for those safety reasons, we support the bill favorably. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, I'm Ari Ploud here on behalf of the Maryland State Fraternal Order Police in support of House Bill 904. Thank you, Delegate Moon, for sponsoring this bill. You heard from the panel, this is the bill about safety. It's a common sense bill. One other provision that the bill does is that an officer would basically be placed on administrative paid duties if they were not given the up-to-code body armor. One other thing I wanted to say is that there may be some amendments that we would be proposing because we understand that the provision on page 2 regarding if the agency has not replaced the body vest, we would say that at least made a good attempt. So if they at least place an order in months in advance, then that would be sufficient. So just wanted to clarify that as well and ask for a favorable thank you.
Thank you for anticipating that question. Is Mr. Boston joining us or no?
I don't think so.
Okay, that's fine. Members, do we have any questions? Delegate Boucher.
Thank you, Madam Chair. Welcome back to the seat. Since I'm a businessman, I'm always hung up on a liability issue. Has the FOP had to sue any municipal police departments for the failure of expired body armor causing an officer death or injury?
I can answer that question.
Thank you.
No. However, 25 years ago, when I was a rookie police officer coming out the police academy, my agency didn't issue vests. They gave us expired vests from the Maryland State Police, and we had to sign a waiver that if we were shot in the line of duty, that the agency was not liable. That actually happened.
So there is a tremendous liability issue here.
Yes.
Thank you very much.
Yes.
Members, do we have any other questions?
No.
Delegate McComas.
Thank you, Madam Chair. I've been to APG and looked at some of the equipment that they're producing, and it's very, very heavy. I was just kind of wondering what the weight of the body wear is on the police officers.
So I'll answer that too. So it's actually light. So for regular patrol, if you wear the vest that goes under your uniform, it's pretty light. The outer carriers are designed, they're weight-bearing vests. So you can add additional components. You could put your taser, your radio, your handcuffs on those outer carrier vests and still have the protection that if you're shot in the line of duty, that it'll stop the bullet.
Now, the other question I have is, as the bad guys keep, upping their game, and then we have the ghost guns and all the manufacture, are you concerned that the vests that are currently being purchased are maybe not strong enough if there's more lethal weapons used by the bad guys?
So what we have found is that the technology has improved over the last 30 years to make the vests even safer than they were many, many years ago. So as the grains and all that go into the ammo changes and the different, what do they call, full metal jacket and all of those different types of rounds, wire cutters and things like that, the vests are anticipated that they will be used by people on the street. And so those vests are usually up to those codes.
Okay.
And that's why we have to replace them every 5 years.
Yeah, at least.
Yeah.
Okay, thank you.
Thank you. Delegate Mangione?
Thank you, Madam Chair, and thank you for the bill. To my colleagues to the right, can't believe you have such a good bill. I mean, we were talking about that earlier. Now, I appreciate it. I think it's a good bill. And I guess the question, I'm not sure it's in here, but save me the time, is how do you hold the locals accountable to make sure that they're not violating this? And I thought I saw a little part about grants, but I just want you to elaborate on that. And is that where a lot of the locals are getting, are they using specific or locals for these bulletproof vests, the grant money, or is that something they really use out of their local budgets?
So the bill, the way to hold the jurisdiction accountable is they'll be down a person on the force while they're on desk duty, basically, until the problem gets remedied. And they'll also potentially have their GOCAP grant funding for this and other things withheld until the problem is solved. If you look at the fiscal note, it gives you a little bit, there's about $50,000 every year in body armor grants that are provided, and the vests cost about $1,200 each.
Okay, thank you. I think that helps.
Delegate Williams?
Thank you, Madam Chair, and thank you, Delegate Moon, for bringing this bill. Quick question. I don't know if you had a chance to look at the testimony from, I think it was, who is this, the Maryland Municipal League, or is this BACO? It's MML. With regards to the time frame of the 30 days, they just expressed some concern that it might not be enough time just because the equipment has to be specially fitted for the officer and things like that. And so I just wanted to kind of get some feedback from you all, just your experience as to whether or not that time frame is sufficient or not.
As already mentioned, there is a possible amendment coming in to help alleviate on the one part where you're talking about the GOCAP, where if an agency could show that like within, and we're still deciding on the time, 3 months, 6 months in advance of it expiring, they ordered a vest, which that's more than enough time. The 30-day part that's actually in the bill, that's saying once the vest is expired, we're saying you cannot use that officer. He's got to go on admin leave. So now this officer's not going to be able to earn overtime, part-time, any extra money. He's at straight day work. And so that's why it's 30 days. And then they have to report themselves to the state saying they violated this officer. Because if he's already lost money for 30 days, then that's when they got to go into their penalty phase. So at that point, if they've missed it, they've had, by this new version of the bill with the amendment, they'll have had 6 months in front to do it right, another 30 days on the back end to do it right. And if they haven't done it right by then, then shame on them. They should lose out on the money until they fix the problem.
Okay, thank you. And I apologize if I missed it. I know I had to step out for a quick second, so thank you.
Members, are there any other questions? Seeing none, that concludes our bill hearing for House Bill 904. Delegate Hornberger, thank you so much for your patience. We're going to call your bill up next, House Bill 508. And we're going to call up Mike Shire and Mike Davey.
Thank you, Madam Chair, Vice Chair, members of the committee. So glad to be back in front of my favorite committee. Yep. Exactly.
Can I say that too?
Yeah, exactly. For the record, Delegate Kevin Hornberger here on behalf of HB 508. I'm going to talk about what the bill does and then follow up with why we need this bill. This is a direct copy of the bill that we submitted last year to this committee. It was highly debated and deals with police accountability, investigation records relating to administratively charged, unfounded, and exonerated complaints. So basically what this bill does, if there is a complaint that's filed against a police officer through the Police Accountability Board, and it is found to be unsubstantiated, unfounded, and not pursued by that board, that after a 3-year period has gone by with no other charges, that it would be removed from the personnel record, okay? So why do we need this bill? Well, we're 5 years into this program now that we've established that this body took on. And what we're finding is that often cases, there are charges made against an officer that do not proceed for numerous reasons. Where this is becoming a problem, especially again at the 5-year mark, is what we're finding is that 2 things are happening. One, an officer might have a perfect personnel record. However, if these charges are on there because they do not get removed, they can impact 2 things negatively and act as a false positive. One, they can go against their personnel records and their matriculation in the agency. So we have a scenario where there's 2 officers at a similar level. They're going for a promotion to, let's say, sergeant or a supervisory role. One has an unfounded complaint, the other does not. You can imagine how that scenario is probably going to play out. The second, which I believe is more impactful to our communities, is the Giglio information. For those of you that are not familiar with this case, Giglio versus United States, 1972 Supreme Court case, it basically says that a defendant can use this information in discovery and disclose it to a jury, and basically it can impact the outcome of a case. So what we're finding is that a defendant can go in front of the courts and say, hey, we've subpoenaed your personnel records, and there's 1, 2, 3 of these complaints on your file, and as a result of that, you know, the jury may or may not be cognizant of what's going on here. It could end up a dismissal of the charge. In other words, the case could be thrown out because there are these false positives on the police officer or the arresting officer's personnel records. So there's a number of letters in here, a lot of supporting information, both for and against the bill. I would point out that there's still some apprehension in the letters that are unfavorable. However, I believe that we are at a maturity standpoint with the bill because it's been in for 5 years, and that's why it's the right time to move the bill. So with that, I'll turn it over to my panel.
Thank you. My name is Michael Davey. I am General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on House Bill 508. As you all know, in 2021, the General Assembly passed a complete repeal of the Law Enforcement Officers' Bill of Rights and passed the Police Accountability Act, which became effective in July of 2022. The repeal included the inability of a law enforcement officer to have complaints of internal investigations to be expunged from personnel records and to make those complaints and internal investigations discoverable to the public. Law enforcement officers are the only public employees whose personnel files are currently open to the public. The passage of House Bill 508 would allow a law enforcement officer to have the internal complaints of investigations expunged when the complaints result in an unfounded or exonerated by an administrative charging committee or a trial board. The record should be removed from the officer's personnel file 3 years after the administrative charging committee or trial board state their findings. The expungement would only occur after an independent review of facts of evidence by an independent group from the law enforcement agency. As you know, the ACC consists, or the Administrative Charging Committee, consists of citizens who reside in the jurisdiction of the law enforcement agency and are completely independent from the law enforcement agency. A trial board consists of an administrative law judge or a retired circuit court or district court judge, the citizen from the community, and a law enforcement officer of equal rank. And that law enforcement officer does not even have to be from that same department. It is a completely independent panel, similar to the ACC, who have no members of the police department on their charging decision. Unfortunately, false and unproven allegations of police misconduct happen every day. Many of these allegations are very serious and detrimental to the careers of many officers. Many of these issues are completely disproven by body-worn camera footage, but the allegations and the internal investigations remain in the officer's personnel file. We would ask for a favorable report on House Bill 508 and allow police officers to have these unfounded and exonerated charges be removed from their files. Thank you.
Thank you, Madam Chair, committee members. My name is Mike Shire with the Maryland Fraternal Order of Police and Anne Arundel County Fraternal Order of Police, also asking for a favorable report on 508. Over the past few years, you all have seen a lot of discussion in these chambers about expungements of criminal records. Those are people who have been convicted of crimes in the state of Maryland having their records expunged. What we're asking for here is not unreasonable. We're asking for administrative charges to be expunged when an independent body, an administrative charging committee compiled of members of the public, or a trial board with a member of the public, an ALJ or judge, and an officer of equal rank, have found that it did not happen as accused. All right, this is not a not guilty finding. This is an affirmative, it didn't happen. Not only that, it's not like an automatic expungement that you can get as soon as a certain time. No, 3 years it's going to sit on our record. An unfounded and exonerated complaint will sit on our record for 3 years, exposed to the public, because our personnel records, as Mr. Davey mentioned, are the only ones that are open for public inspection through the Maryland Public Information Act. So for 3 years it's going to sit there, and then finally we can get it expunged. We are hardworking public employees. There is no reason that after 3 years, an exonerated or unfounded complaint should still be on our records so that everybody can see it. This is just a simple matter of fairness. We are asking sincerely for a favorable report on House Bill 508. Thank you.
And Madam Chair, I would add that we have a friendly amendment that's also been submitted with the bill. It just goes further and removes these records from other locations within the databases that are shared by the police force. Thank you.
Thank you. Members, do we have any questions? I saw your hand first, Delegate Cardin, so you win.
Just real quick, thank you, Madam Chair. Thank you for the bill. So we've passed legislation in the last 10 years or so to permit people who have actually been convicted of felonies after a certain number of years to have their records expunged, correct?
That's accurate.
And we've also passed bills that allow people who have misdemeanors and after, say, 3 years to be able to have their records expunged. Is that correct?
That's accurate.
All right. And also people who have probations before judgment, or there's been a determination that there could be some guilt involved. In this case, it's my understanding that there has been an assessment that there's been no guilt, even if it's a civil matter, I'm talking in criminal terms, but there's been no actual guilt found. It's just that there either there has been found that it didn't happen, or that there's not enough evidence to show that it happened. Is that correct?
I think that's an accurate assessment.
It actually means, for the definition of exonerated in the Police Accountability Act is that the police officer acted in accordance with the law and the agency policy, and unfounded means that the allegation against the police officers are not supported by the facts.
And it's your testimony and my understanding that having this on your record, even though it shows that they didn't do anything wrong, could have negative impacts on both them personally and also on the ability of the police,
credibility in the courtroom.
Yeah, the police's ability to accomplish their goals.
Right. And not only will it affect the ability to be promoted, be transferred to a special agency, but in the criminal cases, what will happen is the defense attorney will get any what's called Brady information or Giglio, depending on the jurisdiction, and the judge will review the personnel file or the internal affairs file of that officer in what's called an in limine hearing. But what unfortunately happens is even these exonerated cases and unfounded, the judge will often still let those in for a jury to hear to affect their credibility in a negative way.
Okay, thank you.
Delegate Card, if I could add, I want to thank you for pointing out the personal impact that these have, and point out to the committee as well that we know that the more work a police officer does, the more interactions, the more traffic stops, the more enforcement actions, the more likely they are going to have unfounded complaints. So by having these things stick on the record, you're basically discouraging an officer from working. You're saying, you know what, you have discretion, officer. If you make 100 traffic stops and there's a 1% chance that you're going to have a complaint, then maybe you'll get 1 out of 100. If you make 1,000 traffic stops, now you're going to have 10 complaints. So maybe only make 50 stops and maybe you won't have any complaints. That doesn't seem like what we're trying to accomplish here. By exonerating these things and having an opportunity for them to leave their record, you relieve that personal pressure on the officers as well. So thank you.
Thank you, Madam Chair. Are we seeing criminals using this as retaliation to scar a charging officer?
I represent a lot of police agencies, a lot of fraternal order police unions throughout the entire state. Depending on the jurisdiction, what we'll see is a number of complaints from one community will be made against that officer that works that post or that patrol because he's aggressive and he's doing his job. And the easiest way for a chief to resolve those issues is just move them somewhere else. And that's what we see
So
happening.
it can be used as a mechanism against law enforcement?
Absolutely.
Thank you.
Members, do we have any other questions? Delegate Valentine.
Thank you, Madam Chair, and thank you, panel, and thank you, Delegate, for bringing the bill. My question would be to Mr. Davey, knowing that you have quite a bit of experience in this with many agencies throughout the state. In the years that this has been implemented, the last 4 or 5 years, I can't get you to say an exact number, but for an example, for unfoundeds, we'll go with unfoundeds, that's the easiest one to understand. What would you say in your estimate is an approximate of how many have been found to be unfounded? In the cases you've worked, just sure, like is it more than 1%, more than?
It's way more than that. I can use Baltimore City as an example. That's my biggest client. They get an average of 3,000 complaints a year. Now, the ones that will go to the administrative charging committee are the ones that involve the citizens. And we probably get 50 to 60% of those that come back unfounded or exonerated. The other ones do get charged, and we work our way through the process.
Thank you.
Thank you. Members, do we have any other questions? Seeing none, that concludes this panel for House Bill 508. We have 2 who will be testifying unfavorable, Deborah Levy, and do we have Jamie Grace Alexander online? Okay, so Ms. Levy.
Thank you.
You're welcome. Whenever you're ready, you'll have 2 minutes.
Thank you so much, Madam Chair. Members of the committee, Maryland, the Office of the Public Defender respectfully urges you to issue an unfavorable report on House Bill 508. This bill, which mandates the expungement of police misconduct records after 3 years, poses a direct threat to the progress of policing reform and the fundamental fairness of our criminal legal system. First, before we go any further, all of the assumptions that were made in the last round of questions were merely assumptions. But let me tell you what the evidence shows, that we are in a tremendously fragile state of police accountability in Maryland. The administrative charging committees established by the Police Accountability Act of 2021 are not yet fully operational. They are backlogged, severely under-resourced, and in many jurisdictions, even slow to start. In places like Baltimore City, still under federal consent decree due to systemic failures, vacancies and case backlogs persist. To allow the destruction of records before a truly effective and reliable system of accountability is fully established is a profound mistake. Of all of the decisions that the gentleman before me testified about, none of those are public. None of those decisions from the trial boards are we able to access to find out how did they reach their conclusion, on what information did they base their testimony. We hear stories of trial boards approving or reversing charges with no evidence presented at all. Those decisions are not available to the public. Ever since the Law Enforcement Officers' Bill of Rights has passed, the law enforcement lobby has stepped up to the table for the Maryland for the Maryland legislature to slowly chip away and peel back all of the reforms that were put in place by this legislature. We are not yet in a state where we have fully implemented the requirements of transparency and accountability that was intended by the Police Accountability Act of 2021, and it is not yet time to roll back those protections. For those reasons and more, we urge an unfavorable report on House Bill 508.
Thank you. Members, do we have any questions? And do we have anybody online? No? Okay. That concludes this panel, and it concludes the testimony for, excuse me, House Bill, I'm sorry, for a second, I can't find my number, House Bill 508. All right, we're going to call up Delegate Williams. Along with Delegate Williams, I'm going to call up Felicia Porter, Mayor Selena Benitez, Shauna Cater,
And then I think I have one person online, Madam Chair,
Lopez online?
who's part of my sponsor panel.
Eric Lopez, is that who we're talking about?
No, Eric Lopez unfortunately is unavailable, Madam Chair.
Okay.
It should be,
What about Noreen Shaw?
that's who I'm looking for.
Is Noreen Shaw there? Okay, can you go ahead and let her in? So I don't see, or do I see Felicia Porter?
Oh, she's, Councilwoman Porter's unable to make it, Madam Chair. She sent me a text expressing her inability to be here this afternoon, but is still a strong supporter of the legislation.
So
of the
we have
Councilwoman.
Shauna.
And this is Ms. Benitez.
Okay. And Shauna Cotter?
Yes,
Okay.
Shayna Cotter.
Shayna Cotter, I'm sorry. Okay, so it looks like we are doing pretty good, and I think we're ready to go. Delegate Williams?
Okay. All right, thank you, Madam Chair, and thank you to members of the BEST Committee and the House of Delegates, the Judiciary Committee. I am Delegate Nicole Williams, representing District 23, and I'm here testifying in favor of House Bill 155, also known as the Public Safety Law Enforcement Officers Prohibition on Face Coverings. This bill would require the Maryland Police Training and Standards Commission to develop a model policy prohibiting the use of facial covering and the performance of their duties, and requiring law enforcement agencies to adopt policies consistent with that model policy adopted by the commission. This intent of this legislation is to prohibit law enforcement officers from wearing facial coverings while in the performance of their duties in the state, except under certain circumstances. And those circumstances are actually enumerated in the bill. I know that there was testimony that was submitted by the chiefs and sheriffs, but I think what is already actually in the bill addresses those concerns, because it does already provide an exception for, to protect against the transmission of disease or infection. It does allow masking in situations necessary to protect against the exposure of any toxins, gas, smoke, or other hazardous or harmful environmental conditions. The bill also provides an exception that law enforcement can use protective gear worn during tactical operations for the purposes of physical safety. So all of those things are already in the bill. I do believe the Senate bill has some amendments that deals with the penalties involved, and that is something that we are willing to entertain as it was passed out of the Senate, to also look at some of those amendments from the Senate bill, which I think will also address some of the concerns that have been raised by the chiefs and sheriffs. So I did wanted to make sure that I mentioned that. But really this bill is about improving transparency, accountability, and public safety, and really reaffirming the public's trust with law enforcement. in communities all across the state. Community policing is really the foundation of a strong relationship between law enforcement and the broader community. And so in order for this relationship to continue to thrive, there has to be a clear way that we can identify law enforcement officers and ensure that those who are there to protect, that they feel safe within their own communities. And so, how much more time I got? 36 seconds. Okay. That's really what this bill is about. It applies to local, state, as well as federal officers all across the board. And for those reasons, I'm asking this committee for a favorable vote on House Bill 155.
So whoever would like to be next?
Good afternoon, Madam Chair and members of the committee. My name is Shana Cotter, and I'm here representing We Are CASA as its Deputy Legal Director. We Are CASA urges the committee to provide a favorable report on House Bill 155. Across this state, masked men with guns have infiltrated our communities. They are terrorizing our communities under the guise of law enforcement. They are taking and abusing our fathers, our mothers, our neighbors, and our loved ones. We Are CASA hears their stories every day. We Are CASA operates a hotline for community members to report ICE activity. Last year, we received over 2,000 calls and confirmed 567 ICE detentions right here in Maryland. Behind these numbers are real people and real families. They include a young person near the Eastern Shore who called to tell us about how a group of 6 masked men tackled his father to the ground before his eyes and took him away. He did not know where his father was being taken. And a woman who reported that her husband was sitting in his car near a park on his lunch break, eating his lunch. Masked men approached that car, demanded that he get out, and when he did not immediately comply, they broke his car windows and forced him out, again taking him away. A secret masked police force enacting this type of violence is anathema to the rule of law and to public safety and community trust. Masked enforcement does not make us safer. It heightens the risk of violent crime. In fact, the FBI itself last fall issued a public safety bulletin urging law enforcement to adequately identify themselves for this exact reason. Across the country in communities like ours, we are hearing reports of masked criminals impersonating ICE to commit crimes, including robbery, sexual assault, and kidnapping. When law enforcement conceals its identity, it creates a blueprint for abuse and criminal impersonation. HB 155 won't solve every harm facing our communities, but it's a crucial first step, and We Are CASA urges the committee to provide a favorable report on House Bill 155. Thank you.
Thank you. So good afternoon, Chair Burnett, Chair Davis, and members of the Judiciary Committee. On behalf of the City of Mount Rainier, I respectfully submit testimony in strong support of House Bill 155, which promotes transparency, accountability, public trust in law enforcement by prohibiting the use of face covering by law enforcement officers during official duties, with the exceptions obviously listed by Delegate Williams. For the City of Mount Rainier, this legislation is especially important because our community's strong emphasizes on the relationship-based, community-oriented, and public safety. Mount Rainier is a diverse municipality where residents regularly interact with the same officers at the community events, neighborhood patrols, and local meetings. Clearly, visibility and identification of officers during these interactions is essential to maintain trust, the escalating conflict, and ensuring the residents feel safe and respected. When community members can clearly see, identify the officers serving them, it strengthens the legitimacy and improves cooperation and supports collaboration public safety models that Mount Rainier has worked so hard to build. HB 155 strikes an appropriate and thoughtful balance between public transparency and officer safety. By directing the Maryland Police Training Standards Commission to develop a model police policy, the bill ensures statewide consistency while allowing for professional standards grounded in best practice. At the same time, allowing the professional standards exceptional for undercover operations appropriately recognizes circumstances where anonymity is necessary to protect officers and preserves the integrity of investigations. Mount Rainier supports the legislation because it reinforces the principles of public servants, especially those that entrust with significant authority should operate in a manner that is visible and accountable for the communities they serve. Clearly, identification, miscommunication, mistrust, or interactions is not the way to go. For these reasons, the City of Mount Rainier urges the committee to issue a favorable report on House Bill 155, and please move this important legislation in order to help our officers. Our officers should never be in a position where they don't now know whether our residents are being kidnapped, legitimate, or they are under other people. So thank you guys so much.
Thank you, Mayor. We're going to now go to, let's see who we have. We have Ms. Shaw online. Yes.
Thank you so much.
Thank you.
My name is Noreen Shaw, and I'm the Director of Immigration Policy at the National ACLU. And in my role, I work with legislators around the country who, like you, are debating whether to ban law enforcement from wearing masks. Why are we debating this now? Because in our nation's recent history, no law enforcement agency has ever used masks to routinely disguise themselves from the public and hide until now. And police impersonators are wearing masks now to terrify and exploit our neighbors, prompting the FBI to urge all police to identify themselves. So we're experiencing a crisis of professional policing and public safety. As the International Association of Chiefs of Police, one of the nation's largest police organizations, put it in a recent resolution after hearing from 35,000 of its officers, masks, quote, create confusion, fear, and mistrust among community members and responding agencies, potentially increasing operational risks and eroding public confidence. In our nation, masks have a history. Masks are what the Ku Klux Klan wore as they attacked homes, maimed and killed and terrorized millions of Black Americans. We take pride in our nation as a democracy. We call ourselves a free country, and we associate masked men with the opposite, with the tactics of an authoritarian regime. But today, go to Instagram and you will see unreal images, people tackled to the ground in grocery stores by people in masks, people dragged on the floor. This is not the America we deserve. It's not the America that our Constitution and our laws allow. We know what police should look like in a free society. We know power should be exercised openly, lawfully, and with accountability, and that is what this bill stands for. I urge you to issue a favorable report.
Thank you very much. Members, do we have any questions? Delegate Erica.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. Okay, so I'm trying to look through the bill real quick, but you can probably just tell me. Is there a carve out for N95 masks?
It talks about medical grade or surgical masks.
Okay,
worn
so-
to protect
okay.
against the transmission of disease or infection.
Okay, so because we've actually had testifiers here today who have been wearing N95 masks. So this is an ongoing thing. Some folks are never going to stop wearing them. So then they would be allowed to just wear them if
They are allowed to do so under this bill.
Okay, that's good to know. Also, there was something mentioned from one of your testifiers about folks being unable to tell if they're being kidnapped or if they're being arrested. And you can just tell me, the videos that I've seen, they are all wearing a plate, like a fabric plate on the back that says police. Why is that not happening everywhere? Are they just not wearing a jacket that says police?
I don't always see that, but I don't know. That's just my experience.
Okay, so there's just some
Sure.
plainclothes people that are not wearing any insignia that says police on it?
So if I could just address that briefly based on what our community members are seeing. I don't think in every single one of the reports they have seen exactly what folks are wearing, but there is certainly confusion and fear based on how they are presenting in the community. So if they're not identified in a way that people understand who they are, and in addition, just the masking itself, which is what this bill is specifically targeting, is part of what creates fear. And in fact, there's a study that came out just this month surveying Americans on their reaction to law enforcement masking, and it found that a full 86% of respondents reported increased fear that officers wearing masks would use violence against them, that 85% believed that masked officers were more likely to abuse their power. So, one issue is not knowing exactly who it is, but another is just the a masked police force presents to the community as people who lack accountability and are likely to inflict harm on them and violence on them. And that's what our community has in fact been seeing.
Right. And this doesn't deal with the uniform that the officer is wearing. In fact, I think we might have another bill that deals with that, but that's not this bill. It doesn't deal with the uniform itself in any way.
What about, I understand the perception of fear, which we cannot actually legislate the perception of fear. It's not realistic. That's not what we're here for. But what is the actual difference between a police officer and you being able to tell, oh, this is a police officer, this is not, by their face alone? Because all we're saying is they have to have an uncovered face. How would I, a citizen, know, oh, I can see this person's face now, that's a police officer. I can't see this person's face, it's probably a kidnapper. How make that make sense?
Yeah, so it's, like I said, this isn't going to the totality of the uniform, but what we are seeking to have it with regards to this legislation is people to know who they're engaging with. And who they're interacting with. And so if you can see the officer's face, that also gives the person who is interacting with the officer a greater sense of comfort in interacting with that officer, because they can actually see the officer's face. They have a better idea of reading that officer's body language, which is harder to do if you have one of the ski masks, for an example.
Okay, so, but we did mention before, you can't really legislate people's emotional reactions to things. That's not really possible. So the idea is that just seeing someone's face would allow someone to just feel better about it being a real police officer versus not seeing their face.
And it also goes against, really honestly, the general practices of most law enforcement agencies anyway.
Is that true?
I think Ms. Shaw can probably speak a little bit more to that.
Go ahead, Ms. Shaw.
Thank you so much, Delegate. Yeah, I do want to speak to the fact that what I said in my testimony, which is that no law enforcement agency in modern American history has routinely worn masks. Even if you think about the DEA, the Drug Enforcement Agency, they do not wear masks. They have said specifically that they don't wear masks even when they're arresting people who are drug traffickers, because they believe that it's important for public confidence in law enforcement to know that you are talking to police. I also quote a retired U.S. Army Lieutenant General who said, he was talking about working in Iraq with police agencies there, trying to stand up a police force in Iraq. And he said, police officers, federal agents, soldiers, anyone empowered to detain, arrest, or use force must be identifiable both by their chain of command and to the citizens around them. When officers purposely conceal their faces and perform their duties without name tapes or badge numbers, they sever an essential connection to the public. And that's why you see so many law enforcement leaders around the country saying that masks are hurting their ability to have trust. You're right, Delegate, that you can't manufacture trust. But what we do know is that you can damage it severely when people cannot tell the difference between masked impersonators and local police. And we can, in the state of Maryland, increase trust in law enforcement by making sure people know the police officer in your neighborhood is not going to be wearing a mask.
Yeah, I think we could all accept that, like, this is potentially an extremely slippery slope to say we're gonna legislate exclusively with the idea that we're gonna completely erase people's fears. That's really kind of unreasonable. And how would this be any different than someone, for example, we could have a bill that said you have to have a badge number on insignia, required badge numbers. I mean, there's a way to let the folks know this is a legitimate police officer, and showing their face is not connected in any way to that. But
For what it's worth, I can just add that during the first Trump administration years, when the Trump administration deployed agents to Portland, Oregon, Congress responded by passing a requirement that they do identify themselves because they were concerned about that fear. And it is the case that all the time we have legislatures that are passing laws to try to increase public trust in law enforcement, partly in recognition that when people are afraid of law enforcement, more violence is likely to happen, more disorder is likely to happen. Law enforcement knows they need community trust to function, to do good policing.
If I may also add to that, the FBI's October 17th, 2026 report, it's the FBI's opinion that masking is harmful for public safety. And so while I understand the perspective that we can't, legislate people's feelings, certainly this body does have the ability to set the norms of how law enforcement is interacting in our communities, and those have real tangible impacts, as we have seen, from our members and communities across the country. So by setting those norms and those rules, that is something that this body can do. And there's data, as we've seen, and I think it's also just intuitive, and we've seen so many examples of the idea of law enforcement wearing masks. It strikes fear, and it strikes fear in part for the same reason that a kidnapper wearing a mask strikes fear. There is no accountability. You don't know who they are. You don't know where you're being taken, and it's much harder to identify, how to hold the person accountable if they've broken the rules.
Thank you very much. Delegate Moreno?
Are there any documented instances of just non-ICE officers posing as ICE officers? And if so, can any of you describe, what those instances look like?
Sure, and again, I'm reading from the FBI's October 17th, 2026 memo. So they lay out a number of examples, and it's not exhaustive. But for example, they lay out an instance in which in August, 3 unknown subjects wearing all black, including black vests, claimed to be immigration officers. They robbed an ATM located at a restaurant in New York. They tied one victim's hands together and placed a garbage bag over their head. Another person they tied and kicked to the ground while they had their hands tied. In February of 2025, there was an individual claiming to be an ICE agent approached a Hispanic woman in Brooklyn. The individual directed the woman to a nearby stairwell where he punched her, tried to rape her, and stole her purse and cell phone. There are additional examples in this FBI memorandum, and it's not an exhaustive list.
And is there any training manuals that gave this type of guidance to wear masks that you know of? Anybody?
I don't know.
Like where did that trend start?
Where did the trend start to use the mask?
Yeah, when did they start using masks?
Delegate, I can answer that.
Sure.
There's actually no federal law authorizing the use of masks to routinely disguise identity, and we've never seen that from ICE in this country or any other federal law enforcement agency to routinely interact with the public in non-criminal settings by wearing masks. In fact, federal law generally requires identification in some purposes. And federal regulations concerning immigration agencies say that immigration officers effectuating an arrest must identify themselves as soon as it is practical and safe to do so.
So it's never been a situation where some training manual says, go ahead and start wearing masks, or one of them started wearing it and then a bunch of them started wearing it?
That's about the size of it, sir.
Okay, thank you.
Delegate Conaway?
Thank you, Chair. Thank you, Delegate, for bringing the bill, and panel for coming in to testify. So I've heard that you have a ski mask, but then some people just have a mask. Is it a ski mask, or is it the like COVID mask that we're talking about here? Or it's any combination of that?
It's a combination. So the bill defines face covering to me any opaque mask, garment, helmet, headgear, or other item that conceals or obscures the face of the individual. And face covering also includes, I hope I pronounce this right, a balaclava, thank you, ski mask, neck gaiter, or tactical mask. But again, there are also exceptions in the bill under certain circumstances.
So we know officially that the federal agency has not authorized these ICE agents to wear masks? Is that the statement we're making?
Well, it's not necessarily targeted to ICE. I want to be very clear. This is regarding law enforcement across the board. And what this bill does is just really, again, asking the Maryland Police Training Standards Commission to adopt model policy for local law enforcement agencies to use and adopt as it relates to the use of masks.
Good. What I'm asking about right now is today, has any agency other than ICE or including ICE, have they authorized their employees to use masks, or the people are just, the law enforcement officers are just using masks because they want to?
I'm not certain if there's a specific policy requiring their use.
I have a question also about page 4, line 16 through 22, when the law enforcement officer violates the section, so you have these misdemeanor conviction subject to imprisonment not exceeding 2 years, waives all immunity to civil action, so forth and so on. If the law enforcement agency is telling them not to wear a mask and they do, they're not going to understand them taking this on. But if we don't know whether or not they've been instructed, that somebody in some agency has not been instructed to wear a mask or been told that it's optional, how should an officer who violates this section come under these terms?
Right. Well, once this is, part of the bill where the agency would have to adopt a policy. And so this would only apply if the officer is violating that policy that has been adopted by the agency pursuant to this bill.
Oh, I understand. So if we pass the bill, the agency does not have to adopt the policy, and therefore the officer might not come underneath of it. Is that what you're saying?
Well,
if we pass this, does the agency have to adopt the bill?
Let me back up, make sure it says
That's
shall.
not-
Yeah, the law enforcement agency with law enforcement officers operating in the state shall adopt a policy consistent with the model policy. So that jurisdiction would have to adopt a policy. And therefore, if the officer, once that policy has been adopted, violates it, then that's when this would come into play.
Thank you so very much, Delegate.
Thank you, Delegate Conaway. Are there any other questions, Delegate McComas?
Actually, I'm going to defer to Delegate Mangione, because since he's been
Patient.
very, very patient. So I'll wait, because he might talk about what I might be talking about, so.
Thank you, Delegate McComas, and thank you, Madam Chair, for that. And so I guess just one of the points, two things here, and this wasn't my original questions, but since it's been brought up, I mean, if you just address the fact that impersonating an officer, number one, is already illegal, because this was a big rebuttal point you made to the delegates' questions here. So I'm not sure I see the relevance in that. And criminals pretending to be ICE could still show their face, as was already alluded to. So I just don't see how a mask ban would stop someone from falsely claiming to be ICE. I just wanted to get that out there. But my real question is, whether you agree or like it or not, ICE obviously has the right to enforce federal immigration law, especially there's another point here that has to be made. There's been an 8,000% increase in death threats against ICE. So my question for you would be, how can a state tell federal agents what they're allowed, in essence, to wear during their job? I mean, how can you constitutionally criminalize the conduct of federal officers during their federal duties?
Yeah, so I'll comment initially, and I'm gonna turn it over to Ms. Shaw. But again, this is with regards to law enforcement across the board operating here in the state of Maryland. And so I'm gonna have Ms. Shaw just kind of also reiterate that, but yes. You're muted.
Thank you, Delegate. I'm happy to get into the constitutionality questions. I just want to note on the report about doxing that I don't think that we can rely on the information that's coming from the Department of Homeland Security, either the Secretary or the Office of Public Affairs. And there have been people who have questioned and asked for the data to back up that claim about death threats and the percentages that are being cited there. And of course, just as a reminder, this is the same Department of Homeland Security Public Affairs Office that said that Alex Preddy and Renee Good were domestic terrorists after they were shot and killed by federal law enforcement. So as to your question about the constitutionality, this is a matter of the state taking a measure that is meant to increase public safety and address that harm for all law enforcement agencies and for the entirety of the public. The 10th Amendment reserves to the states that police power to set regulations to enhance public security and public health. In particular, what we've set out here is that this is a law that's necessary to support public safety. It's a law that is generally applicable to all law enforcement agencies that are operating in the state. It doesn't single out the federal government or federal law enforcement. It applies to all federal law enforcement agencies. Now, the state that has actually passed a law enforcement mask ban, California, has seen it challenged by the Trump administration. And a federal district court in California did rule in favor of the Trump administration on a motion for a preliminary injunction. In that case, what the federal district court found was that the California law at issue discriminated against the federal government because it included the federal law enforcement agencies, but not the state highway patrol. This bill does not commit that same, what is clearly an error in drafting from the perspective of the federal district court. And what's clear also from that federal district court opinion is that a law enforcement mask ban does not impermissibly directly regulate the federal government, because wearing a mask is not necessary to doing federal law enforcement work, which is clear from the fact that, of course, they never wore masks routinely before this time. So I'm happy to answer any further questions if that's helpful.
I'm just, I don't have it in front of me, but you're saying that the 10th Amendment, the state has the right to override the federal government in that regard because of the 10th Amendment? Is that?
The 10th Amendment reserves to the state police powers and powers to regulate for the public welfare.
But that's what you're saying, because of the 10th Amendment.
Just
they
like the
can,
state, sorry, go ahead, Delegate.
Yeah, sorry. You're saying because of the 10th Amendment, the state can now, I mean, because of the rights in the 10th Amendment, override the federal government's authority as to choose what they want to wear for the safety of the federal government agents.
It's a good question, Delegate. The way that courts analyze this is, first, is this an exercise of the police power? Is it intended to address the general public safety and health and welfare issues? If the answer is yes, there's a second question in an analysis of what's called the Intergovernmental Immunity Doctrine. And under that doctrine, if the state law in question directly regulates the federal government, then it will be impermissible under the doctrine. There's a second prong to that, which is that if the state law discriminates against the federal government, then and singles it out, essentially, then it will be permissible under the Intergovernmental Immunity Doctrine. In this case, what I was mentioning is that the Federal District Court in California found that the regulation, the California law enforcement mask ban did not impermissibly directly regulate the federal government. And it was a similar ban, but the problem with that the court found with the ban was that it applied to federal law enforcement and local law enforcement, but not state law enforcement. In that sense, it discriminated against the federal government.
Thank you.
Thank you. Delegate McComas.
Thank you, Madam Chair. Okay, I kind of want to back up the truck here a little bit. Isn't it true that the officers were motivated to wear masks because they were being doxxed by the community, the immigrant community that they were working with? And basically they had fear for their families and their self and their safety, so that's why they did that. They put on the masks so they were not going to be victimized. Their family wasn't going to be victimized. Isn't that part of the reason why they're wearing masks? It's not because it's cold outside.
Who's that? Is that directed
Are you
to Ms. Shaw?
directing it to Ms. Shaw?
Who are you directing the question to, Delegate?
Anybody that wants to answer it.
Okay. If you want to go ahead.
Sure, and thank you for the question. And I think to begin with, we have to kind of start with the premise of what does it mean for law enforcement to be doxxed? It's a problem that's created by the masking itself. So the public expects law enforcement to identify themselves. That's the norm. And so folks expect to be able to know, who they're interacting with, to see their faces, to see their badge numbers, to be able to call a supervisor so that there's some mechanism of accountability. So to some extent, the idea of kind of doxing law enforcement is just created by the fact that some law enforcement officers have now chosen to hide their identities. So there's certainly a strong argument to be made that the masking itself is causing the doxing. It's forcing people to say, who are these people that are attempting to hide their identities? I'll also say there's no real data that's publicly available about doxing. So while we have heard the federal government continue to tout the fear of doxing, they have not provided any data. And in fact, DHS has said that it will never confirm or deny any report of doxing or attempted doxing. And so for that reason, there's no data to base this on. And on the flip side, there's just enormous data.
Ask you a question? If I was a person that was illegally in the country and I saw an officer, that might say, hey, you're an illegal immigrant and you need to go, that would create fear whether they had a mask or not, wouldn't it? Because I'm not supposed to be here. I'm not here legally.
Delegate, thank you for that question. And I'll just, again, begin with the idea that the people who are afraid right now are all across the spectrum of U.S. citizens, permanent residents, folks who have status, folks who had status until the Trump administration took it away, through the end of the TPS programs, for example, to folks who are without status. So that fear, we are hearing it from across the community. And we're hearing it also from the folks who are seeking to exercise the right to observe law enforcement activity, to record ICE. And I think it's really quite hypocritical in a way for ICE to be asserting that they have to carry out their operations anonymously when they're simultaneously seeking to unmask folks who oppose them by subpoenaing Meta, for example, on folks who have spoken out against ICE. So that fear exists across the spectrum, in large part due to the masking itself, in connection with the extreme violence that we've seen, again, against the spectrum of community.
So I definitely want to add that, so ICE has been working in the state and the nation for many years, but to the level it has risen, we have not seen. So the mask does increase the fear for everybody, whether you're undocumented or not. I'll tell you this, I'm a U.S. citizen. And if a person's coming at me, not identifiable, trying to grab me and put me into a van, I'm going to be concerned. And unfortunately, a lot of this thing is happening whether people are documented or not. They're just picking up quite a few U.S. citizens as well. So to me, it's not just a matter of people being in fear whether they're documented or not. It's a whole community of various backgrounds, even people that are born here that also are feeling this fear. And a lot of it has to do with the masking itself. When the kidnapping, you guys talked about it, when it happened in our neighborhood, the residents couldn't identify what agency it was, who it was, so it was very hard to even give the details to the police, even to us, in order for them to know who took this person, and they weren't even sure where they were heading. So that gives you a sense that instilled fear to many people in the community that were born here for many generations, but still didn't feel safe to be able to walk outside the streets because of what they saw. So although ICE has been here for many years, right? It's the tactics that they're using now that has created this fear, intimidation, that now they feel they need to cover their face in order to make sure they protect their entire, so therefore they're not dogs. So I just want to make sure we don't put that, the horse in front of the car. It's the other way around. They're creating the atmosphere, and now they're falling into this.
Thank you. Delegate Cardin.
Madam Chair, thank you very much for bringing this bill and your compelling testimony of your witnesses as well. We heard legislation earlier, I think today even, regarding people's ability to file a claim for violation of civil rights. You recall that legislation?
Oh, that we heard on the floor today.
Yes, we heard on the floor today. And we learned then, did we not, that for over 100 years there has been a law that allows people to file a claim against a state actor. Is that correct?
Yes.
Okay. And as far as you know, and I don't know if your witnesses want to answer this, but it can be a yes or no, has there ever been an issue, a pervasive issue of a civil rights violation by state actors and the victim not being able to identify either the law enforcement officer or the other actor involved because of face coverings?
Yes.
In a state, in Maryland.
In Maryland, if someone's
from a
brought a
Maryland
1983
agency.
case against law enforcement.
Do we know of a pervasive problem with people covering their faces from Maryland officers or from Maryland agencies? Is that something that we've had a problem over the last 100 years?
I don't have any data on that. I live in Shaw.
But the legislation that if we do pass it will allow us to then proceed against folks in who are perhaps federal actors. Is that correct?
It would allow federal actors, state actors, local actors.
All actors. It does not discriminate against anybody. Is that right?
Correct. That is correct.
And this bill does not discriminate in terms of who is required, who's prohibited from wearing face coverings. Is that correct?
Yeah, it's really focusing on law enforcement officers. That's it. But yes, it doesn't discriminate.
Doesn't discriminate between state, federal, local.
No, not at all. It could be state police. It could be ATF. It could be the city of Bladensburg.
And here's my last question. If there is if we find that there is now a pervasive problem with whether it be one particular agency or multiple agencies, whether it be state, federal, local, that are hurting people's ability to identify who they are because they believe that their civil rights have been violated, this bill would help us make sure that that problem is solved. Isn't that correct?
That's correct.
Thank you.
Chair. Thank you, Madam Chair, and thank you, Delegate, for bringing the bill, and thank you for the panel coming in today. I want to switch gears a little bit. I think it may be covered. I'm just trying to look for a specific group of individuals, which would be for narcotics officers. And I understand it says it does not pertain to undercover operations, but I'm looking at something more specific. As someone in my past life who wore balaclavas a lot in my former profession, I don't think it's covered under the physical safety and tactical operations either. So as a narcotics detective, you're routinely on search warrants, you're certainly in investigations, you're certainly in interviews. If I was to come in a search warrant scenario, had uniformed officers, had special response officers, I would wear a balaclava because obviously I don't want my identity revealed. Or if I was called to a scene of a stop or who someone wanted to speak with a narcotics detective, I would wear a balaclava because I didn't want my identity revealed. How would this legislation pertain to those individuals? Because I thought it might be captured in some of the exceptions, but I don't really see where it does.
Right. I'm certainly happy to talk further with you. I mean, that was what we were trying to get at with regards to the tactical operations portion or exemption in the bill.
In some of those scenarios, because it doesn't specifically, I was trying to see where it might fit, and I just didn't see where those particular detectives would fit in, because it wouldn't be a tactical operation, some of the ones I just explained, and it wouldn't necessarily be an undercover operation, but they are used in those. And again, these are in situations where they would know who the individual is as far as my name, but I would still be wearing a covering because I may be involved in those individuals in other scenarios where my identity would have to be protected.
Right.
So.
Thank you, Delegate Valentine. Okay, members, any other questions? Seeing none, we're going to go ahead and go to our next panel. Thank you very much.
Thank you.
Everyone for being here. Is Eric Lopez, Kelly Rojas? Okay, Ms. Rojas, are you here for Eric Lopez? Are you with the American Center for Immigrant Rights? Yes, you are. It says it right there.
Yes, I was here for the past panel, but I know that's finished now. Yes.
Okay, well, go ahead because we want you signed up. We want to hear what you have to say.
Yes, thank you. My name is Kelly Rojas. I co-direct the Detained Adult Program at the Amica Center for Immigrant Rights, and I'm here to provide testimony in support of House Bill 155. My organization, we are a nonprofit organization that provides pro bono legal defense services to community members detained by ICE Immigration and Customs Enforcement in Maryland and in the DMV area. Our organization has specialized in detained removal defense for the past 25 years and are leaders in creating systemic changes in the immigration system for the benefit of vulnerable non-citizen community members. We strongly support HB 155 because mass law enforcement erodes public trust. Law enforcement officers, as the panel has heard from other witnesses today, law enforcement officers who wear masks break the public trust by creating a sense of intimidation and fear into engagements with community members. Mask wearing contributes to the risk of escalation because it leaves doubt to the legitimacy of the law enforcement action and to whether it is a law enforcement officer engaging in valid operations. Even ICE, former ICE policy regulatory agents have spoken publicly about the dangers of utilizing masks in the field. As pointed out by one former ICE employee who was quoted in the press, it's very dangerous. How do you know that you need to not resist to avoid arrest as opposed to resist arrest to possibly survive the encounter? And I want to underscore how much our clients fear masked officers. Our organization has been providing legal services to non-citizens in ICE custody for over 25 years. This past year has been different from anything our clients have previously confronted. Our clients are terrified at the sight of masked officers posted up in immigrant neighborhoods. There's no certainty as to whether the masked people pulling them out of their vehicle is law enforcement. Additionally, many of our clients have experienced persecution or torture in the past at the hands of law enforcement or private actors, and being approached by masked individuals can invoke a similar type of fear. I think as an immigration attorney and a practitioner, with regards to the prior testimony being shared about the importance of this being applicable to all law enforcement officers, just underscoring that, like, I've worked with many clients who come from countries where it is the norm for law enforcement to be shielded from sight, masked at all times. And I think that it's important that the state of Maryland and in this country, that is not the norm here. And I thank you so much for allowing me the opportunity to testify in favor today.
Thank you, Ms. Rojas. Members, do we have any questions? Seeing none, thank you very much, Ms. Rojas. Oh, sorry, Delegate Phillips has a question for you.
This will be, isn't it so, ma'am? Yes. And members, as a young man, I think you all know my story. I grew up spending time in Cecil County, Maryland. And I remember people that were masked under a different circumstance. And I remember the fear associated with that masking with the Ku Klux Klan. I can remember being somewhat forced, because I think I was trying to be taught a lesson, my uncle taking me to Rising Sun and sitting off in the distance. This whole question about masking and about the fear it creates in people is real. And so I would just, as we're thinking about all of this, just understand that that fear is real. Thank you, Madam Chair.
What are the magic words?
Isn't that so?
You did start off with it. Thank you very much, Delegate Phillips, and thank you, Ms. Rojas. This concludes our testimony. No, it doesn't, I'm sorry. We have favorable with amendment. We have Councilmember Will Jawando and Jane Horvath. Okay, great. Ms. Horvath, you're here, so I'll let you start, please.
Thank you. Thank you, Madam Chair and Vice Chair and Delegate Williams for sponsoring this piece of very important legislation. I'm Jane Horvath. I'm a member of the Route 1 Corridor chapter of Indivisible, which is a national pro-democracy organization, and I lead our state and local working group. There's concern, much of this you have heard already, so I'm gonna just summarize, but there's concern among law enforcement agencies around the country about the growing threat of officer and agency impersonation. The FBI has in fact requested that the Federal Department of Homeland Security limit the use of masks and require agent identification, precisely because agent impersonators are committing crimes. That's right in their letter. State and local police are being impersonated as well, many now with masks. I found 5 media reports of Maryland law enforcement impersonations, and most of those were in 2025. So this whole concept of impersonating is growing because of ICE and masking. I would like to just step back. I want this bill to be successful, and I think that there are 2 technical issues in the bill that can be resolved. The first is that the bill could be read to require specific policy adoption by law enforcement agencies outside of Maryland. And I believe that the federal government would try to take issue with that with regard to the supremacy clause. I think SB 1 on the Senate side has dealt with this in some way, and if not, then just requiring the adoption of specific policy to apply to Maryland law enforcement. But anybody operating in the state of Maryland would still be under our law. And the second concerns the use of the word tactical. All ICE operations, if you look at it and you look at a definition of tactical, they could all be considered tactical operations. And so this one provision that exempts for tactical operations, I think, is too large.
Thank you very much. Councilmember Jawando, how are you?
I'm doing well, thank you. Good afternoon.
Good to see you.
Good to see you as well. Chair Bartlett, Vice Chair Davis, members of the committee, my name is Will Jawando. I'm an at-large council member here in Montgomery County, Maryland. I'm here to share my strong support for HB 155. I hope that you will pass this important legislation, which will help protect our residents and provide needed transparency. As many of you know, throughout history, masks have been used in American law enforcement to shield the wearer from accountability. They've been used for terror, they've been used for impunity and anonymity from violence. And unfortunately, we're seeing history repeat itself before our eyes. As federal immigration enforcement officers are terrorizing communities, my county here, throughout the United States, including in Montgomery County and other parts of Maryland. The actions of ICE that we are witnessing are not about enforcing laws or keeping people safe, but they're about causing fear through violence and intimidation. We must reject these practices and stand up for residents and the rule of law and safeguard our communities as much as possible. I recently introduced a similar piece of legislation here at the county level with strong support with the majority of the council sponsoring that bill called the Unmask ICE Act, which would prohibit the masking of federal, state, or law enforcement officers in Montgomery County. The introduction of this county legislation demonstrates the urgent need locally and at the state level for protections outlined in HB 155. We cannot wait for federal action or hope that voluntary compliance will protect our residents. And by passing this bill, Maryland would establish a clear statewide standard that reinforces local efforts like ours and ensures consistent protection across jurisdictions. Please note that just last week, at my request, a majority of my colleagues on the council have voted to support HB 155. And our county's strong support for this reform shows that there's political will for this change. And I urge you to give the bill a favorable report so that Maryland can help lead the nation in this critical public safety and accountability issue. One amendment I suggest is to make it effective immediately because this is urgent and we need that in this legislation. Thank you for your time and for your efforts.
Thank you. Members, do we have any questions? Yes, Delegate Erica.
Thank you, Madam Chair. Thank you, Councilman, for being here. You said the majority. Who did not support it?
Who did not support the
You said the
HB
council had taken a
155?
vote? Yeah.
Yes.
No, did you mean that, or were you talking about the council bill? Or was it HB?
I was talking
Was it
about
our
state,
bill?
we often send to our delegation support for state legislation. So I was talking about in both cases, a majority of colleagues sponsored my bill and a majority also voted to support HB 155. I think it was an 8-3 vote. I can get you the names, but I think there was maybe 3 people that didn't support it.
I'd be interested. Maybe I'll write him a check one day.
Well, with that, do we have any other questions? Thank you. This is my law school classmate. Good to see you.
Good to
Take
see
care.
you as well. Take care.
All righty. Bye-bye. Thank you, Ms. Horvath. That concludes our bill hearing for House Bill 155. Delegate Kaufman has been patiently waiting. We're going to call Delegate Kaufman up next, House Bill 634. We also have pages in our legislative pages in our audience. Would you all stand up, please, so we can. Very good to see you. Could you holler out really quickly where you're from?
Okay, I'm from Baltimore County, District 10.
Great.
I'm from Anne Arundel County, District 33B.
I'm from Cecil County, District 45.
Great.
I'm from Baltimore City, District 45.
Right.
I'm from Montgomery County, District 14.
Great, great, great. Wonderful. Thank you for being here. I hope you're learning something. And if not, I hope you're just at least having fun. Okay, Delegate Kaufman, we're going to call up Sherry Bailey, my friend Dorinda Adams. I don't know if I'm supposed to say that, but she is. Reginald Lawson. And if we have Linwood Alston, Chief.
Is this delegate, is this? Yeah, that's what, it's okay.
Hello, Judiciary family. I'm here so often, I'm clearly having some separation issues.
Yes, and we miss you too.
I miss you too. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. For the record, I am Delegate Aaron Kaufman, and I'm here to request a favorable report on HB 634, Police Training, Autism, and Dementia Lead Act, as amended. Now, when I talk about elopement, you usually think who is going to get married. But in this case, elopement is far more serious because it is how we describe how people with autism and dementia run away or leave a supervised space unannounced. And so this bill addresses a narrow but growing urgent public safety gap in Maryland's emergency response system, which is training law enforcement, dispatchers, and EMS individuals to assist when an individual with autism, another intellectual development or developmental disability or dementia wanders or elopes, meaning, as I said, that the person leaves a safe or supervised setting without permission or awareness, often because of a cognitive or a disability or a cognitive condition. Children and youth with autism and IDD individuals frequently wander from homes, community spaces, and schools. When this happens, these incidences can escalate quickly into time-critical emergencies when minutes matter and where risks are both predictable and severe. National research shows that nearly half of all children with autism attempt to elope after age 4, and more than 1 in 4 go missing long enough to cause serious concern. The most common dangers in this situation are exposure to traffic and contact with bodies of water, because we know that people with autism are drawn to bodies of water and many of them have drowned. And also traffic, which is a leading cause of injury and death and elopement. Despite these risks, Maryland currently does not require uniform statewide training that aligns law enforcement, emergency medical services, EMS, and 911 dispatchers around elopement, response protocols, or disability-informed communication. As a result, response practices vary by jurisdiction, and outcomes can depend more on location than best practices. The LEAD Act addresses the gap by standardizing police training across law enforcement systems that already respond to these emergencies. It requires the Maryland Police Training and Standards Commission to ensure officers receive entry-level and annual in-service training on wandering and elopement response, communication with individuals with non-apparent disabilities, and coordination with EMS and 911. It also directs the EMS board from the Maryland Institute for Emergency Medical Services Systems, MEMS, to incorporate parallel training objectives and dispatch prompts into existing EMS and medical protocols. I'm going to, importantly, this bill does not expand enforcement authority, create new response unit, or impose rigid mandates. In fact, it doesn't have a fiscal note. It builds on existing training infrastructure, allows agencies to meet or exceed curriculum standards using equivalent curricula, and focuses on readiness, coordination, and public safety. In the interest of time, I'm going to skip some of my other examples, but we know that there's growing national consensus that disability-informed responses is a core public safety responsibility. In Illinois, for example, lawmakers enacted statewide autism-informed training requirements for all enforcement officers to improve communication and response during these crisis situations. Minnesota does the same thing. And New York has advanced bills that would mandate disability-focused enforcement training, reflecting a growing bipartisan recognition that disability-informed response is a core public safety responsibility. This bill positions Maryland as a leader by ensuring that the police, EMS, and dispatch are trained together using a shared framework for the moments when coordination matters most. For these reasons, I respectfully request a favorable report on House Bill 634, Police Training, Autism and Dementia Lead Act of 2026, as amended. Thank you very much for your time, and I'm proud that I believe this bill doesn't have any opposition, Madam Chair. It's always a joy to be with you.
Ms. Adams?
Chair Bartlett, so great to see you, and Vice Chair Davis and all members of the Judiciary Committee. And I acknowledge 5 of you actually are co-sponsors on this bill, so we thank you. I am Dorinda Adams. I'm actually serve on AARP Maryland's volunteer executive council, and I'm the lead for all things caregiving within AARP Maryland. And this bill is about bringing people together across the lifespan. So we want to thank Delegate Kaufman for being a sponsor, seeing that vision. And we want you to know that we have spent time coming together across disciplines, across organizations, across whatever, to ensure that some of the most vulnerable, those that we care about, whether professionally or personally, are treated with, to the best of everyone's ability, respect, dignity, and compassion, and can be supportive. Because if you're working in the industry, you want to do the right thing. I'm a true believer. You don't get up every morning and say, how can I make people's lives miserable? You want to do the right thing. And if you're the caregiver of someone who is vulnerable, you want your family member to be safe, respected, and loved. And on behalf of AARP Maryland, and I quote our founder, Edith Percy Andrus, AARP, we believe in what we do for one, we do for all. So we thank you for a favorable outcome on HB 634.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Sherry Bailey. I am a founder of a Maryland nonprofit called Layla's Gift, nestled in Harford County, but serves Maryland. But most importantly, I'm a mom to twins, Lana and Layla, and a caregiver to Layla. Layla was born alongside Lana in 2014. She was Hopkins' first case study of a very rare syndrome. So not only does she have a rare syndrome, but she's also nonverbal, and she also later was diagnosed with autism. The first 6 years of Layla's life, she was bound to a wheelchair. One day I gave her a bath, was getting her dressed, and she started walking like she had been walking for the last couple of years. It was a milestone, but quickly turned into another new risk, which was elopement. I did not know what it was until the day happened about 6 years ago, where Layla was in the care of the nanny and left the front door on her own. Very scary moment, as you can imagine. Later, learning through just a bunch of research, found that 49% of children with autism tend to elope. We hear percentages, but it does not give the human factor. So if there's a room full of 100 kids on the spectrum, 49 of them will elope. This is not a one-time thing. This can be a lifetime thing. Some elope frequently, some as frequent as once per week. It's a scary reality. Our national experts say that drowning is the leading cause of death. In 2024, drowning instances accumulated to 91% of the fatalities. That is a jaw-dropping statistic. I sit here before you today as not just a mom and not just a caregiver, but an extreme advocate for children like my daughter, and also an advocate for lifespan, which is the uniqueness that comes with this bill, because we also have individuals in our community with dementia that also deal with elopement. And this is a single legislation that allows us to better understand elopement across the lifespan and work together to save lives. So with that, I strongly urge a favorable report for House Bill 634. Thank you.
Thank you very much. Chief Lawson, no, Chief, I'm sorry, Chief Alston, and are you going to just trade places, Mr. Lawson? Okay, that works for me. Whenever you're ready, Chief, thank you.
Thank you. Good afternoon, Madam Chair and members of the Judicial Committee. I'm Linwood Alston, the Chief of Police for the City of New Carrollton and a former Commissioner with the Maryland Police Training and Standards Commission. I'm here in strong support of House Bill 634, the LEAD Act of 2026. This bill ensures that Maryland law enforcement officers receive specific training regarding individuals with dementia and autism, particularly in situations involving wandering, elopement, and missing persons. From a law enforcement perspective, these are not routine calls. They are high-risk, time-sensitive emergencies. Individuals with autism who elope are often drawn near water. Individuals with dementia may become disoriented within blocks of their homes, wander into traffic, or appear uncooperative, but they're simply confused. Without proper training, these behaviors can be misinterpreted. Misinterpretation can lead to escalation. Sadly, escalation can lead to tragedy. The LEAD Act ensures officers receive particular and operational training that saves lives. I also come before you today not just as a police chief, but as a son. My mother is currently facing the realities of dementia. I have seen how quickly confusion can set in, how someone who once guided you through life can suddenly become unsure of where they are. If she were to ever wander, I would want the responding officers to understand that she's not resistant, she's not defiant, she's afraid and confused. Training transforms reaction into compassion. Training transforms uncertainty into skill. Training saves lives. Maryland has led the nation in modern policing reforms and training standards. The LEAD Act continues that leadership by preparing officers for encounters that require patience, awareness, and coordination. I respectfully urge a favorable report on House Bill 634. Thank you for your time.
Thank you. Mr. Lawson?
Good afternoon, Madam Chair, Judiciary Committee. My name is Reginald A. Lawson. I'm a former caregiver for my late mother, author of the book At Home with Dementia that was designed for caregivers, as well as a certified first responder dementia trainer. During the early stages of dementia, elopers go out a couple minutes at a time and return home safely. However, as they progress through dementia's lifespan, their compromised mind prevents them from doing so after that. My mother averaged 6 elopements a month. She often stood in her front yard or at the corner just 30 feet from her front door, unaware of where she lived. Neighbors would bring her home, startled by her attempt to open their front or back door, thinking that was her home. We only reported elopement just once in 2 years because of the frequency, but also because local law enforcement had no idea how to handle it. Dementia elopement is a psychological and spiritual need to run towards or from something. For example, to attend a funeral that does not exist, to visit a non-existing hospitalized friend, to be on time for a job they no longer have, or worse, to escape someone in their home they think will hurt them once they looked in the mirror and don't recognize themselves. Our trust in first responders at its highest during our darkest moment. When they elope, our world becomes very frightening to where we dread the ring of the phone, the knock at the door, or the approaching of a patrol vehicle. Once dementia elopers are contacted by first responders, they only have a few seconds to establish a sense of trust. And how they handle that will determine a positive outcome of a safe and uninjured return or injury and death. The enactment of this bill strengthens our loved ones' chances for a safe return and enhances our first responders' abilities to succeed in their mission and commitment to serve and protect. I respectfully and humbly urge for your favorable vote for House Bill 634.
Thank you very much for your testimony. Delegate Taylor?
Thank you, Madam Chair, and thank you, Delegate Kaufman, for bringing this bill. I don't see any letter of information or any testimony from the Police Training and Standards Commission. I would love to know if you've had a chance to talk with them, especially in light of, and I also see that there's no fiscal note really. And I'm assuming that part of that is because we had Ethan Saylor's law in the past that required some sort of autism training, and Eric's ID law last year that passed that talked about hidden disabilities. But I applaud you for this law, because we can't have, which includes dementia, because we can't have too many tools in the toolbox for this kind of important work. So again, my question really is what is the MPTSC stance on this bill?
Well, I haven't spoken to them, and my family has a phrase that says no news is good news.
Yeah.
And so the fact that I haven't heard from them, and I'm taking as a positive sign. Now, I'm working very closely with Mrs. Teresa Hessler. Maybe she's spoken with them, but I think my staff or Ms. Hessler
May I make some comments?
is fine with it, but I think my other witness may have more information.
Thank you.
Thank you. So yes, we have sat down with the department. Yes, of course. Yes, Sherry Bailey here. Yes, we have sat down with the department. We've actually reviewed the current Public Safety Act and identified the opportunity to make it lifespan. And obviously, they can't say they endorse anything, but there was no objection, and it felt pretty straightforward. There was actually appreciation for a single legislation, to your point, Delegate, around elopement at the lifespan level versus elopement for this Group A, Group B, Group C. The other big difference is the LEAD Act is encouraging a statewide framework, where it's very different from today, right? Today, you see things done differently by jurisdiction, by city, by county. What the LEAD Act does is install training for elopement across the state, regardless of county or jurisdiction, which is also a note of appreciation.
Awesome, thank you.
Members,
Thank you,
do we
Ms.
have any
Bailey.
other questions? Seeing none, that concludes our testimony in person. We're going to move to anyone who's online or virtual. Dr. Cross? Do we have Jamie Alexander? No? Okay, all right. No worries. Dr. Cross, whenever you are ready, we'll give you 2 minutes. Thank you.
Thank you so much. I am asking for a favorable on House Bill 634, Police Training, Autism, and Dementia LEAD Act of 2026. We are definitely foreseeing a change in how our state looks firsthand at how public safety outcomes must improve. When law enforcement officers are equipped with practical training, it reflects the real needs of our community. As a local government officials, we are encountering community leaders that involve individuals with autism, dementia, that require significant awareness, patience, and specialized response techniques. With proper training, routine interactions can unintentionally escalate and place both the officers and the vulnerable residents at risk. The requirement to include training on wandering behaviors, sensory awareness approaches, and reunification practices is not something that is unheard of. We do have Eric's ID law. We do have Ethan Saylor's bill. The interagency coordination must reflect, however, a responsible evolution to modernize our policing to include all members of our society. Local governments rely heavily on well-trained officers who can respond effectively to residents and experiencing those cognitive and developmental challenges, including PTSD and other things of hidden disabilities. Families deserve this confidence that emergency response will prioritize safety, dignity, and foremost, understanding. This legislation strengthens that trust between law enforcement and communities that we serve. I do highly recommend a favorable on this bill. noting that Maryland Police Training Standards and Commission should establish measurable performance outcomes and reporting guidance, as well as encourage the collaboration with local health professionals and care providers. Thank you so much for the opportunity to testify.
Thank you. Members, do we have any questions? Seeing none, thank you for being here. This concludes our panel, and this concludes our testimony for House Bill 634.
Don't worry, Madam Chair, I'll be back one more time this session next week, so.
Good to hear it. You're welcome. You're always welcome.
Thank you, Delegate Coleman.
I'm gonna take a picture. Sir, can you stay for a picture?
Yes.
Can you get them to? Can you get them to stay?
Yeah.
Delegate Ebersol, we're going to call you up next. This is House Bill 1341, members. House Bill 1341.
Thank you, Chair Bartlett, Vice Chair Davis. Eric Ebersol bringing you House Bill 1341. As originally introduced, this bill was designed to keep school resource officers and other school security personnel from being allowed to share sensitive information about students' immigration status, their families' immigration status, their friends' immigration status, even school members' immigration status. SROs are in a unique position to gain this information that's off-the-record information, and we want to be sure that they were trusted. We also wanted to protect those very people that they might be interested in knowing about. This bill has several amendments suggested with it, and I'm going to try to detail them in the next 2 minutes and 30 seconds. This bill would add principal, assistant principal, teacher, and school counselor to the list of people who would not be allowed to share information with these amendments. The amendment would also require school employees or others who are notified of an immigration enforcement action to notify the county superintendent or superintendent's designee. It adds to the current requirement that governments operating specific sensitive locations prohibit anyone from seeking access for immigration enforcement purposes, areas not open to the public. And it adds to that, current public schools, libraries, units of executive branch and local governments, but it adds courthouses to this. In addition, it adds to the definition of sensitive places about which the AG must publish guidance which helps everything in this bill work: school vehicles, school bus stops, and locations used to distribute food to people in need. It changes the current language requiring federal agents who are conducting investigation, enforcement actions, or immigration enforcement actions in sensitive locations to notify local law enforcement from federal law enforcement officer to judicial officer. And this brings the terminology in line. Clarifies that school personnel yield to judicial warrants, but they're not required to determine whether the warrant is valid. Seems a little bit much for them. And finally, it requires courthouses to implement a policy based on the AG guidelines. Last year, only schools, schools, libraries, and executive branch were required to adopt a policy. Requires the AG to update guidance every year for certain entities. The standard list: public school, public library, unit of executive branch, or local government operating a sensitive location to update their policies. I respectfully request a favorable report on the bill with amendments.
Thank you, Delegate. Delegate Ericon.
Thank you, Madam Chair. Good to see you here in our committee. What examples of this problem happening in our state do you have?
You need specific examples?
Yeah, I would like to know what the impetus of the bill was.
I guess you're asking if I have a specific problem that I'm addressing. I see one, I foresee one. So we have good thing, we have SRO officers. We want to make sure they're able to do their job well, and we're ensuring that.
Okay, so there's no examples that you have?
Well, none that I know of, but they probably exist.
They probably exist. Okay, that's typically not how we legislate, but I got it.
Yeah, but I'm legislating based on making something better, not necessarily finding examples of this happening, right? I will tell you that the Maryland Center for School Safety, which trains SROs, heartily endorses this concept for their SROs.
Members, do we have any other questions? Seeing none, that
He went to the restaurant,
let me just make sure I'm going to call Delegate Cardin, House Bill 31. I'm going to call Michael Davey, Mike Shire, Angelo Coselli, Clyde Boatwright. If you're here, it'd be great.
Oh, wait, I do have more than two. I'm sorry. I thought I only...
No, I saw. That's fine. I looked it up before you. I trusted.
I'm a lawyer, not a mathematician.
I trusted you, but I verified. So it's all good.
Madam Chair, members of the committee, John Cardin, on behalf of House Bill 31, asking for a favorable report. You've heard, for those of you who have been on the committee before, you've heard this bill a number of years in a row. Those of you who haven't, this is a bill that authorizes law enforcement officers who have been administratively charged either by the Administrative Charging Committee or the law enforcement agency to file a petition to show cause in the circuit court if the officer believes that a right granted under the Maryland Police Accountability Act has been denied or violated. Basically, it allows them to go into court and seek information by court order as to what's happening, what's the status of their administrative charge. And if, for example, they've been waiting for months and months and months and they need to have some finality and they want to see what's happening, they should have the right to go in and get things moving. That's basically essentially what it does. The folks around me will be able to answer all of your questions. I know that Mr. Shire has been dealing with this for years, as well as Mr. Davies, and I look forward to their testimony. Thank you, Madam Chair.
Thank you very much.
Good afternoon, Madam Chair, members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order Police. We stand in full solidarity with Delegate Cardin with this piece of legislation that will allow our officers a due process right to file a petition of show cause before a court. We have examples, and you'll hear the examples of where an officer's rights were violated. And I'm not a lawyer, but I know that the officers had to file what's called a writ of mandamus, and those cases have not been heard yet. And it's been a few years. The show cause order allows the officers to get in before a circuit court to have their issues heard. It doesn't delay the process of discipline. In fact, when we had this under the old LEOBR, it was used less than 20 times in the 30 plus 40 years that the LEOBR existed. So it's not a thing that's used pretty frequently. It's just a tool to allow officers who are aggrieved to have a process before a judge. And so with that, I'll stand for any questions, but we unitedly stand with Delegate Cardin for this piece of legislation. And we ask for a favorable report. Thank you.
Good afternoon, Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we are obviously requesting a favorable report on House Bill 31. So a show cause under the MPAA, we've made an amendment that I believe is going to be submitted. So there's two prongs to the Police Accountability Act. One deals directly with discipline. And those questions, those issues can generally be dealt with by the administrative law judge who's hearing the trial board or the retired judge. So we don't really need a show cause to get into circuit court for that. The administrative law judge can make those decisions. If we don't like them at the conclusion of the trial, we file an appeal to the circuit court. But there are other provisions of the Police Accountability Act where the administrative law judge has absolutely no jurisdiction. Those would be cases where an officer is disciplined even before he was given his rights to a trial board, and it's happened. Under the MPA, if a constitutional or due process right was violated, generally, administrative law judge won't deal with that. Investigations that should have been reviewed by the ACC and weren't, generally the judges won't deal with that. There has to be another jurisdiction or venue for us to take those cases so they can be adjudicated. Assistance of representation, issues involving emergency suspensions, whistleblower violations, secondary employment violations. These have nothing to do with the actual disciplinary case from the ACC, but right now, under the law, there's no way to get those into court in an expedient manner. Now we would have to file what's called a writ of mandamus, which just goes to the clerk's office of the local circuit court and will sit like any other lawsuit. And it may take 5 months, 6 months, a year before we would get to a hearing on that. By filing a show cause, we can get into court much quicker, let the judge make the decision, and move on to something else. So we've basically taken this bill. For the last couple of years, we tried to attach it to the disciplinary process of the MPAA, but now we've backed out of that, and we just want these issues that an administrative law judge cannot handle because it's not within their jurisdiction, an avenue to get into court in a quicker manner. Thank you.
Good afternoon again. Mike Shire with the Anne Arundel and Maryland Fraternal Order of Police here asking for a favorable report on House Bill 31. As Mr. Davey said and Mr. Boatwright, there have been a number of examples where officers have been denied their rights under the Maryland Police Accountability Act. Officers who have been demoted when they say, no, I want a trial board. Chief says demoting them anyway. Officers who have been suspended without pay outside of the law. How do those officers deal with those issues? Right now, as Mr. Davey said, it could take years. We are asking for a method to get these in front of a judge quickly so that they can be resolved. Another thing that he mentioned was whistleblowing. When we talk about police accountability and how agencies need to be accountable to the public, whistleblowing was something that was specifically protected in the Maryland Police Accountability Act. What kind of protection is there if an officer whistleblows and then gets suspended or disciplined or other action is taken against them, and there's no ability for that officer to quickly get before a court and say, this is not right. I am being punished for doing what you all wanted us to do, to highlight it when there are things that are happening in our police departments that are not in the public's best interest. If you do not provide us the protection so that we can come forward, do you think that officers are going to come forward when it's their jobs, their livelihood, their families, they lose their health care coverage and all these things when they may be suspended without pay for months and months on end? We are asking for this protection so that you can have the level of transparency and accountability that this body and the public demands and that they should have under the Maryland Police Accountability Act. For that, we ask for your favorable report.
Good afternoon. Again, I'm Angelo Cazzoli, Vice President for the Maryland State Fraternal Order of Police and past President of Lodge 89 in Prince George's County. I won't belabor the points that have already been made by everybody. We were one of the examples. We had officers, 13 of them, as a matter of fact, suspended without pay for over 9 months, which we believe was, against the rules at the time that were in place. We had to file the writ of mandamus, and we were still waiting for the writ of mandamus when the circuit court refused to prosecute any of the officers, and they were forced back to work by the new rules because they allowed it at that point as well. So there are issues like this, and there's others that have happened throughout the state that are the reason why we want these protections for officers, because with the show cause, we could have gotten in front of a judge a lot quicker and gotten a ruling, whether it was for the officers or against the officers. But to make them sit there and wait 9 months, a year, or 2 years for an actual writ of mandamus to hit it to court to say, yes, your department erred and they took away your rights or took away your money, that's just not right. And we think it was inadvertently left out when we did the switches that we did back in 2021 to the new system that we're we're under. So with that, we hope you favorably vote for this bill. Thank you.
Thank you very much. That concludes this panel. Members, do we have any questions? Delegate Valentine.
Thank you, Madam Chair. And thank you, Delegate, and thank you, panel. I'm looking at a couple of the opposing testimony, and both that I've come across speak to how this would be disruptive to the investigations or during the process. Could you speak to that, Mr. Davies, of why this would not be disruptive to an investigation?
Because of our amendment, we're taking it out of the disciplinary side of the Police Accountability Act. We're dealing with those issues that have nothing to do with an internal investigation. These are the isolated provisions of the Police Accountability Act that set aside by themselves that if we believe they're violated, we should be able to go to court. It will slow down nothing when it comes to the disciplinary side.
And by the way, as our witness has said, the courts can rule on either way. So if the court rules against them, then it's going to go forward regardless. So.
And it's important to note, one of the items that Mr. Davey pointed out was a case where an agency decides to go forward with a disciplinary action that should have gone before the ACC. An agency is denying the body, the ACC, the body that this body created, the legislature created, who conceivably should have the right to hear the case and make a recommendation. If there's an agency denying them that right, then that should be something that should happen, should be fixed before it goes to a trial board. But the ALJs and the retired judges will not rule on that because it's not relevant to the actual facts of the case and the evidence of the case. It's out of their jurisdiction.
Thank you.
Thank you. Members, do we have any other questions? Seeing none, that concludes this panel. We're going to move to our unfavorable panel. Deborah Levy.
Thank you very much. Good afternoon, esteemed members of the committee.
Ms. Levy, I'm sorry, can you just pull over a mic?
Absolutely.
There we go.
Okay. Good afternoon, esteemed members of the committee. The Office of the Public Defender respectfully requests that you issue an unfavorable report on House Bill 31. Our position is clear. House Bill 31 is wholly unnecessary and, if enacted, would critically undermine the existing disciplinary process for police officers and cause even more delay. We are all well aware that the Baltimore Police Department is currently grappling with a severe backlog of over 500 discipline cases, with many taking months or even years to reach a trial board. This failure was publicly criticized by Federal District Judge James K. Berdar in December of 2025. He stated unequivocally that justice delayed is justice denied. The department's excuse that they offered was of growing pains is simply not adequate for an agency under a federal consent decree due to a pattern of unconstitutional policing. We must heed the judge's call to prioritize efficiency. Instead, HB 31 proposes a new mechanism, the order to show cause, that will only compound the problem. This mechanism, whether by design or consequence, offers officers the potential to indefinitely stall proceedings, effectively leading to the quiet dismissal of complaints without a disciplinary finding. This completely frustrates the accountability and transparency that the Police Accountability Act of 2021 sought to achieve. It is also simply unnecessary. Law enforcement officers already have afforded a clearly established comprehensive pathway to raise critical issues through a fair trial board hearing with judicial oversight and civilian participation, and then through the appellate process at both the circuit court and the appellate court levels. Law enforcement officers are not in need of a special new proceeding beyond those afforded to every other litigant in Maryland. HB 31 is a piece of legislation that impedes fairness and judicial economy, it frustrates accountability, and it interrupts justice. We have a framework in place to address these issues. And I would also note that if you look at this legislation, there are no guardrails regarding what police officers could take to a judge in the circuit court on an order to show cause. For example, just moving to dismiss for delay, which would completely circumvent the disciplinary process in the Law Enforcement Officers' Bill of Rights. We urge an unfavorable report.
Thank you. Members, do we have any questions? Delegate Valentine.
Speak to what the last panel talked about. I know you haven't seen their amendment that they're discussing about how this would kind of not make sure that these cases were not interrupted. Can you speak to any of that, or did you hear the testimony from the last panel about that amendment?
I think that I haven't seen the amendment, and I'd be happy to look at it, but I think the individuals who are going to have to come in on the order to show cause are the same individuals who are processing the trial boards through that are significantly delayed. And there's no indication that if you were waiting for a trial board to happen, you wouldn't say, there's no mechanism in the bill that says, well, I'm waiting for my order to show cause to proceed to see if you even had jurisdiction over me, or if your decision to place me on suspension was appropriate, or whether you abided by the timelines. You see these kinds of appeals all the time. In the current process, an officer will go through the disciplinary procedure, and then they'll file an appeal and say the agency didn't have jurisdiction in order to punish them or discipline them in the way that they did. So I think what they're trying to do, and if you notice, law enforcement keeps coming in all of these panels trying to chip away at the rights of LEOBR, or I'm sorry, of the Police Accountability Act of 2021 in response to the dismantling of LEOBR. And I think that if you look at them on the whole, they're trying to remove the ability for a panel of individuals selected and mandated by the statute look at the proceeding. And they said it themselves in the last panel that they want a judge to look at the issues that are facing them and circumvent the entire board. So I don't see anything that they offered through even a discussion of any amendment that would bring the type of transparency and accountability into the order to show cause proceeding that is already in the trial board proceeding. And what everybody should be doing is looking for ways to diminish the backlog in order to deal with and implement successfully the statutory framework that was passed by the legislature. And I don't see any folks, respectfully, from law enforcement doing that and heeding Judge Bradar's call to fix this backlog.
I guess when I was listening to the testimony, one of their concerns were agencies taking it out of the hands of that independent review. I think that was one of the cases they cited where discipline was mediated out and it took it out of the hands of that administrative panel or board, is what they were saying. Did you hear that as well?
I did not.
Okay. Thank you, Madam Chair.
Thank you. Members, any further questions? Seeing none, that concludes our bill hearing for House Bill 31. Just 1 second for me, please. Delegate Phillips. This is a jointly assigned bill with members of the Environment and Transportation. Will be coming down.
Everybody's like, we started speaking, and then it was like, wow. We were so close. Yeah. Okay, I thought we were gonna talk about different data. You don't have sex. You don't have sex. Does he have to? I think I have his data. Okay.
Madam Chair, are we waiting for Delegate Stein?
No, we are not. We're going to start with you and your panel.
Thank you, Madam Chair, Madam Vice Chair, once again to the Judiciary Committee. We all know we work hard, so I won't repeat that again. And I'm not going to go through and read all of my testimony. This is about safer stops. This is about creating equitable policing in our communities. This is a priority bill of the Legislative Black Caucus. I want to say what it doesn't do. It does not eliminate enforcement. It requires stops to be based on primary safety violations, not minor administrative issues. It does reclassify certain non-dangerous administrative violations as secondary. Stops must be based on conduct that threatens roadway safety. So I want police to target speeding, reckless driving, dangerous lane changes, and similar hazards. This is data-based, guided by research from a number of different organizations, the Vera Institute, and even right here at home, University of Maryland, Baltimore County with Dr. Umar Usman. Persistent racial disparities in equipment and registration stops occur. Disproportionate impact on Black and brown drivers, minimal public safety benefit that occurs with these stops. It should be noted that when these stops occur in Maryland, arrests occur in well under 1% of non-moving violation stops statewide. So I question, are we using the most intrusive tool of government in the most effective way? I've got to go to my own county because we're an outlier. About two-thirds of the stops are made with African Americans in Baltimore County, and we represent 30% of the population. Of those stops, people are 2.5 more times likely to be searched as a result of the context of those stops. These stops rarely produce serious criminal outcomes, and this legislation attempts to address that imbalance. From the national context, many states and jurisdictions have already made changes, Virginia, Philadelphia, and numerous others. I'd say that in the current climate, minor equipment stops can cascade to even more severe consequences. Expired registrations should not lead to detention or family separation. I want to address a few things that were raised last year. On amendments, we tried to be balanced. We've removed administrative discipline language, clarified scope that it only applies to traffic-related infractions, eliminated retroactive application, preserved enforcement for hazardous conduct, clarified vehicles with no registration remain enforceable, and also we've said if there are 3 secondary infractions, then a police officer would be able to make a stop. I'm going to close there just by saying, at the end of the day, we need to reduce the disparities in traffic stops. And you'll hear from my panel as to why.
Whoever would like to go next.
Good afternoon, Madam Chair, members. I'm Natasha Dartig, Public Defender. The question before you is not whether traffic laws matter. They do. The question is whether Maryland should continue using armed roadside stops to enforce violations that do not improve public safety when we know these stops disproportionately target Black drivers and too often escalate into harm. Data is clear. Since 2021, Maryland has experienced 62 law enforcement-related deaths. Nearly 1/3 began with a traffic stop. Many of those encounters originated from law-level equipment issues, expired registration, plate light. We are deploying armed officers into inherently volatile roadside stops over infractions that pose no immediate danger to anyone. This is not precision policing, it is unnecessary risk. The disparities are equally clear. 2023, Black drivers represented 32% of Maryland's population, 43% of all traffic stops. White drivers represented 57% of the population, yet received 25% of citation. The pattern sharpens when you isolate equipment stops. In Arundel County, 20% of population are Black, 42% received equipment stops. Montgomery County, 20% of the population Black, 41% received equipment stops. When the same disparity appears county after county, year after year, it is not an anecdote, it is structural. The good news is that reform works. We have jurisdictions outside of Maryland, Philadelphia, Virginia, that have shown us that focused enforcement is smarter enforcement. HB 81 does not eliminate accountability for equipment violation. It recalibrates how we address them. It allows law enforcement to concentrate on dangerous driving and serious crime while reducing unnecessary confrontations that place officers and drivers at risk. HB 81 is a measured, evidence-based step towards safer roads, safer communities, and more equitable enforcement. The Office of the Public Defender respectfully urges a favorable report. Thank you.
Good afternoon, Chair Bartlett and distinguished members of the committee. I am here today on behalf of Maryland Attorney General Anthony Brown in support of HB 81 with amendments. Traffic stops are dangerous for police officers and motorists alike, and data shows that the danger is highest for Black and Hispanic drivers because they are disproportionately stopped by police. Reducing the number of non-safety traffic stops is an important goal, which is why the Attorney General supports HB 81. Several amendments are necessary, however, to ensure that the bill strikes the right balance with public safety. And it's my understanding that Delegate Phillips has agreed to some of these, so my apologies for proposing them as amendments when they've already been introduced. First, the offense of driving an unregistered vehicle should be removed from the list of secondary offenses because unregistered vehicles are often uninsured. Second, because traffic stops are currently the main enforcement mechanism for compliance with the MVA code and repair requirements, a procedure should be created through which officers can report secondary violations to the MVA, which in turn can issue the registered owner a repair order. Relatedly, the bill should allow for a traffic stop if an officer observes multiple secondary violations. Third, because officers sometimes perform traffic stops in the context of long-term criminal investigations, the bill should be amended to require officers to inform drivers of all traffic violations that informed the stop, but not all reasons for the stop to protect those long-term investigations. Fourth, the bill currently reads that a court may exclude all evidence recovered during a traffic stop if the officer fails to identify themselves or give the reasons for the stop. The bill, however, offers no guidelines for how courts are to exercise this broad discretion, which is likely to result in disparate rulings across the state and risks that guns or other evidence of violent crimes would be excluded because an officer did not comply with the identification requirements of the bill. For these reasons, we ask that the exclusionary provision be removed. And finally, and I understand that this has also been done, we ask that the retroactivity provision of the bill be removed to avoid having stops that were valid at the time they occurred be retroactively determined to be invalid. We applaud House Bill 81 for seeking to reduce non-safety traffic stops and thank Delegate Phillips for introducing this bill, and we ask that the bill receive a favorable report with the above described amendments. Thank you.
Thank you. Good afternoon. Thank you, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Charmin Leone, and I served with the Cleveland Division of Police in Ohio for nearly 13 years. I'm now a resident of Baltimore City and currently the Director of Law Enforcement Initiatives at the Center for Policing Equity. We are a research and action organization made up of former law enforcement, academics, and community engagement specialists that use scientific research to identify and reduce racial disparities in policing. House Bill 81 represents an important step towards addressing equity, preserving officer resources and morale, and improving traffic safety across the state of Maryland. In the time that I spent on patrol, investigating officer misconduct, and finally leading the background investigation and recruitment units, I found that officers focusing on non-safety stops were not those most effective at discovering serious crimes. In addition, it was demoralizing for officers who must pick up additional calls for service while their coworkers are not available while executing these stops. To improve recruitment and retention, we should be prioritizing practices that actually solve crimes and improve public safety. It is why people want to be the police. In CPE's study of 1.6 million traffic stops, police use force more frequently on people of all racial groups at non-safety stops compared to safety stops, with Black and Latino drivers disproportionately affected. Deprioritizing these minor infractions falls squarely in line with intelligence-led policing.
the trajectory, evolution, if you will, of our profession. That's why we're seeing bills like HB 81 passed across the country, including Virginia, Connecticut, Philadelphia, and Pittsburgh. When Fayetteville, North Carolina's police department shifted their enforcement priorities, safety-related stops increased from 30% to 80% of all traffic stops. Traffic fatalities dropped by 28%. I urge a favorable report, and thank you for your time.
Good afternoon, Chair, members of the committee. My name is Heather Warnken. I serve as Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong support of House Bill 81. I also had the honor of serving as one of the co-chairs of the Law Enforcement Policies and Practices Working Group of the Maryland Equitable Justice Collaborative, the historic initiative led by our public defender and attorney general to address mass incarceration and its pervasive racial disparities in Maryland. There are a lot of reasons why this policy was one of our priority recommendations to come out of that collaborative, research-driven, consensus-driven historic effort in MEJC. This bill will simultaneously redirect police resources to more pressing public safety concerns while also improving relationships between police and the community. It will advance racial equity by addressing a significant source of the pervasive racial disparities in Maryland's criminal justice system and strengthen much-needed systemic legitimacy that is eroded by the distress and risk of these interactions that are borne unequally by Maryland's Black drivers. As you've heard, research demonstrates that non-safety related stops neither improve road safety nor our crime-fighting efforts. Studies demonstrate that these stops seldom result in the recovery of illegal firearms. We've seen jurisdictions increasingly throughout the country pass and implement these policies and strongly urge Maryland to follow suit. Thank you.
Madam Chair and members of the committee, the Maryland Office of the Public Defender respectfully urges a favorable report on House Bill 81, Safer Traffic Stops for All. Our current traffic enforcement practices are dangerous, inefficient, and fundamentally inequitable. Traffic stops are the most common, but also one of the most dangerous interactions between police and the public. Vehicle incidents are the second highest cause of law enforcement-related deaths in Maryland. More critically, data unequivocally shows that these stops disproportionately target Black drivers. In 2023, Black drivers accounted for approximately 43% of all traffic stops, despite making up only 32% of the driving population. This disparity is even worse for low-level equipment and registration stops, the exact stops that this bill addresses. House Bill 81 advances meaningful, targeted reform. It reclassifies 6 non-safety-related violations, such as driving with one headlight, an unilluminated license plate, or an expired registration of less than 4 months from primary to secondary offenses. This means an officer can still issue a citation after a lawful stop for a real safety concern, but they cannot initiate a stop solely for these low-level issues. This change allows law enforcement to refocus on genuine hazards like unsafe speed, reckless driving, while reducing unnecessary and racially disparate interactions. We know this works. In Philadelphia, similar reform led to a 54% drop in non-safety related stops for Black people. And critically, police there actually recovered more guns because they were able to shift their focus to investigating more serious offenses. The data is clear. Unnecessary traffic stops put people at risk and erode community trust. House Bill 81 is a common sense step to ensure traffic enforcement works safely for all Marylanders, improve community trust, and enhance public safety. And we urge you to issue a favorable report.
Thank you. Is there any data that shows that reduced traffic stops also helps with law enforcement safety? Do we have anything on that?
I think the data from the Attorney General's Independent Investigations Division, you were asking if it helped with law enforcement safety.
Yeah, because, you know, when you stop, you got to pull somebody off on the side of the road. And I know that it used to be the officer would be on the side of the road. Now, sometimes I guess there's, you know, you can be on the passenger side. I don't know the rules on when they're passenger side and when they're driver side, but my point is that they're stopping someone on a highway, on a road. Do we have any data with respect to how this affects their safety? And if you don't, it's okay. I just was
I'm not
wondering.
sure if we statistically have data. One of the things, and I believe Madam OPD already said, the number of individuals who were affected, both law enforcement, I believe that included both law enforcement and the individuals who were stopped or apprehended. That number is pretty significant.
Okay, thank you.
Chair Bartlett, I would just add that in the Attorney General's written testimony, we talk about the number of officers that have been killed in the line of duty during traffic stops.
That's what I was getting at.
Yeah, and it's 39% of law enforcement officers who were killed in the line of duty were killed during traffic stops. So while we don't have data that discusses the decrease of those deaths once these non-safety traffic stops are no longer allowed, it stands to reason that the less traffic stops that are being done, the safer it is for law enforcement.
Thank you. Thanks for directing me there.
Thank you.
I see it now. Delegate Simpson?
All right. Thank you for bringing this bill, and thank you for your persistence in bringing it back. So as you've said, this is a research and data-driven bill, and I'm assuming the sponsor is aware of the Attorney General has suggested some amendments.
Yes.
Can you expand upon how, whether you support these and what is the research, that would...
I think for the most part, we are supporting all of them. We removed the language related to administrative discipline for officers. That was a concern that was a concern for law enforcement. We clarified that the only traffic-related infractions are covered. Third, we eliminated the retroactive application, as we said. Fourth, we preserve public safety by maintaining primary enforcement for truly hazardous conduct and by clarifying that vehicles with no registration, which was mentioned, remain enforceable. Also, if someone is egregious and you have 3 secondary infractions, we've now indicated that they can be, a traffic stop can be effectuated. And I think that was it. And I think we have some others that we're working on. But for the most part, yes. The language may be a little bit different, but we're in sync.
Okay. And how does this bill make, our community more safe?
So I believe the bill makes, because our community is all of our community, right? And so it definitely will make it safer for those persons who currently are stopped at a much higher rate based upon what they look like.
Okay. Thank you.
And if I could add to that as well, how it makes us more safe is that when you're not focusing on non-safety related stops, you're focused on those things that cause more harm. It's really about harm reduction too, right? You find more guns, you stop more drunk drivers, right? You don't, and the other crime rates don't go up. That's what our research has shown. So you have more time to do focused investigation. You increase your solve rate. You're not dispersing your, I love this term that they're using now, is about tactical discipline. You're being tactically disciplined. And so it helps in a number of ways.
So it does improve efficiency.
Absolutely.
Thank you very much.
Delegate Taylor?
Thank you, Madam Chair. I was trying to Google this question, but I'll just ask you since you're here. Do other states have a practice of documenting traffic stops?
There are some states that have a practice. I'm not sure. I think we've got some additional data folks that can talk about that on another panel.
Got it. I'll wait. I'll hold it.
But we document traffic stops here in Maryland. That's how we have all of this data. The question is, do we require it for every stop, and do we list every particular item? There is some concern that based on the research that we did, there's some data that we would love to have that is not currently documented in a traffic stop.
Sure. Okay, thank you.
Thank you. Delegate Cardin?
Thank you, Madam Chair. Thank you very much for the bill, Delegate Phillips. So I understand, and I want to be as supportive as I can. We all have constituents that believe, that are constantly talking to me, at least my constituents, about they want all the rules to be followed, and it's not fair that we select which rules we're going to enforce and which ones we're not. And so is there a way to enforce these even though you're not necessarily stopping? So you had suggested maybe that the police officer could inform the MVA, maybe if they're behind a car, they do their little computer like check, they see that it's been, that the registration has been suspended or whatever for 2 months or 3 months or something that's within the non-safety stop, as you call it, can they then just send the citation to the MVA? Or is that going to be a violation of their rights because they were never confronted about it first?
I wouldn't think it would be a violation of their rights. They could make notice of it and send it to MVA. MVA would then send a notice. It wouldn't be a violation. So we're informing the individual that they've got a light out, et cetera.
Okay. So,
and you talk about everybody wants everybody to follow the rules, and that's fine. But this is placing these stops within the rules because we already have rules for secondary stops. So you drive down the road, you don't have your seatbelt on, you don't get pulled over, but we know that that is a violation. If I get pulled over for something else, I can be held accountable for my safety belt.
I understand. Well, but I'm thinking about, look, we know that, I mean, our mayor, the Baltimore City mayor has talked about, exercising on these low-level crimes to try and create an improved quality of life so that people realize that they have to adhere to both the low-level as well as the high-level rules. So could there be something in this? I'm actually, this is just coming to my mind. So if it's been marked by a police, has called in the MVA, say twice, and then when they pull it up and they see that they've already gotten 2 notices to the MVA in the last 2 weeks and they haven't fixed it, then they can be pulled over? I mean, I'm like, it seems to me like if you give them 2 bites of the apple, it seems like.
Okay. I love your question, right? And that everybody should follow the rules.
Could you just pull your mic?
Yes, ma'am.
Yep, thank you.
Sorry. Right, and we want everyone to follow the rules. We are deciding, do we want our armed officers to enforce those rules? They're administrative. Those aren't they are not violent crimes. Most of our citizenry want armed officers to address violent crime. Because it is a rule on the book, there are administrative ways to do that. To ask our armed officers to take time out to do administrative work, we speak about this all the time. 40-some% of our officers' time is done on paperwork, and we're asking them to do more. Part of the officer wellness, the reduction in officer wellness, has to do with things such as that, right? It's about their mindset. What did they come on the job to do? If it's an administrative responsibility, we are capable and
But here's what I'm hearing. I understand what you're saying and it makes sense, but here's what I'm hearing. I'm hearing the police officers are no longer going to have their computer open when they're at stoplights. They're no longer going to be checking people's.
No, that's not.
Well, but that's
what's being said.
That's the paperwork that they're doing, right? They're doing the paperwork that they're doing is saying they're right at the stoplight doing the paperwork right then and there. Then they go, they give them the ticket, and their job is, for all intents and purposes, done at that point. They then have to whatever file all that at the end of the day, but they,
That's a lot of, see, you say it as if it is very minimal, and it's not.
Well,
and you spoke about a wonderful city mayor, Brandon Scott, and one of the things that he spoke about not too long ago is being targeted in our crime reduction. And he spoke about the year where they had 287 murders, but had 91,000 arrests. In the year that they had less arrests, they had 16,000 less murders. They had 16,000 arrests. They don't, it's not, one doesn't negate the other.
You're talking to somebody who wants to get rid of all guns. I would be happy to get rid of all guns. If police officers who are doing traffic stops don't have guns, that's fine with me.
Yeah.
So I just don't understand why we're gonna, it sounds to me like what we want to do is we want to stop policing people for these violations completely. That's what it sounds like.
Yeah, that's not it.
But okay, thank you. Thank you, Madam Chair.
I do want to punctuate an important part of this bill, and it is the fact that Black drivers are disproportionately stopped. So it is not simply that everyone follows the rules, because what we see here in Maryland, the rules are not applied uniformly. If we in Maryland have 57% of the drivers that are white, but only 25 of those persons get tickets, whereas we have 30% of drivers are Black and 57% are getting tickets, the rules are not being uniformly applied. And that's an important part of this bill as well.
I would only argue that that is, that statistic is very interesting, and it's very disconcerting. But it doesn't prove, it doesn't necessarily prove that we don't know whether if Maryland, if Black Marylanders are 33% of Marylanders, and white Marylanders are 67%, which is not, obviously not that exact. We don't know whether 33% or the Black 33% are violating exactly at 33%. And we don't know whether the white Marylanders are violating exactly 67. We don't know that. It's concerning that it's that far off. I agree with you. But, you know.
But the only way we would know that would be stopping at the same rate.
What we do know, Delegate, is that when compared to other jurisdictions that have done that, that number has come down.
But that's good. I mean,
so let me finish. So if we know that by implementing these policies, the disparities on those stops have come down, while we don't know in Maryland, we know for sure that it's had a positive impact on those other communities where disparities existed. And we also know through research that it hasn't impacted their policing in any significant way. There is not a report that I've been able to find that suggests that it impacted their policing in any negative way.
I think
can't find a report.
That's very helpful information. That's very poignant. Thank you.
Thank you.
Delegate Valentine?
Thank you, Madam Chair. And thank you, Delegate, and thank you, panel, for being here today. I have a couple of questions. So first to the bill sponsor, can you clarify your statement earlier about seatbelts is not a primary?
Seatbelt is not yes. Somebody can correct me if I'm wrong. A seatbelt is.
It is.
It's a secondary.
It's my understanding that.
Oh, it's now become a primary. Well, it was a secondary.
It was
began
a secondary. I remember when that turned into a primary in 96.
Yep, I stand corrected.
It became a primary stop in 1996 or 97. My second question, I'm interested to know what documentation means. And I mean this by I know a traffic citation is obviously documentation. A police report, if it turned into a DUI, would be documentation. If for some reason, and I agree, all stops should be documented. That's for the safety and well-being of everybody involved. That's 100%. I agree with that. If a stop has to be stopped, for some reason, an officer has to leave a stop, is a CAD entry or a computer entry, or what is sufficient if he has to leave or she has to leave that stop for some urgent situation? That's where I'm what would satisfy the documentation of the stop?
I'll turn to.
Yeah, sure.
Do you understand where I'm trying to go with that?
I do.
Something's occurring. I have to leave this stop. I don't have the time to write a citation.
Sure.
There are instances where that occur.
Yes, there
And
are.
I want it to be documented.
It happens often.
Correct.
And I appreciate you, Delegate, for acknowledging male and female officers. Thank you, sir. So you usually, when you do a stop, you call it into radio. You put out the plate. So you put out your location. So it is documented.
So for the bill sponsor, that would satisfy the documentation because it has been put over the radio. It is an entry into some type of a system. In those extreme circumstances or exigent circumstance where they had to deviate from maybe a formal citation or a police report. Is that your understanding?
Now, without having, that's something that we may need to consider. We'll have to look at the language.
Okay.
But certainly, if I may, as a public defender, certainly if an officer can always supplement a report. So if they have to leave for an emergency, the bill requires documenting it on a citation or a police report, but it doesn't say immediately at the time of stop. So if an officer goes back to the station and then has to produce a report later, there would be an opportunity to correct that.
My scenario that would have been, I initiate a stop, I walk up to the car, I'm in the middle of just getting the basic information, which I may not have yet, and I get dispatched to go to a traffic accident 3 streets over that I have to leave. Is that radio transmission, is that very initial documentation enough in that type of circumstance is what I'm trying to get at?
No, and I appreciate that, Delegate, and we'll have to figure that one out.
Madam Chair? Yes. I'm very intrigued on I believe you mentioned a few times about the 3 secondary offenses.
Correct.
Or more than one.
More than one.
Would that be 3 separate equipment violations? So what I'm getting at is if you're driving and you see a vehicle with a headlight out, a tail light out, a brake light out, would that satisfy? Because we may get to a point where you have vehicles that have multiple equipment violations and not just a tag light out.
You're referencing, Delegate, 2 that are already still primary. So if it was like an unilluminated license plate, a front headlight, and an expired registration, less than 4 months, those would be the 3 secondary in this particular bill. Certainly, you've given some examples where someone could pull someone over as a primary also.
Well, that's what I mean. If this legislation went into effect, those 3 lights would not be a primary. What I'm saying is, instead of it just being, I guess what I'm trying to find out is, instead of it being a secondary for one headlight, what if you had multiple equipment violations? Could that turn into a primary because you have multiple violations?
The way it's written today is that would be correct. So it's 3.
As it stands today in today's world, but not with this legislation.
No, with this bill, it doesn't say just headlights. It doesn't say, so my thinking is, if I recall, the way it's written today, if you had a headlight, a tail light, and a tag light, those are 3.
That would be 3. You're shaking your head no.
Oh, we didn't include tail light. We just have the one single front headlight.
The front headlight.
Yes. So brake light still needs to be intact, sir. We heard concerns from law enforcement and met with them in the interim, so we took out some of the violations from last year's bill.
I think this is a scaled down list. Is this a very
Yes.
small
So that's
list?
all that's in there is what you're looking at, those 6. So last year, we had referenced like brake lights and taillights, and so
Okay.
those are gone now, and they remain still primary.
They're primary. I'm sorry. I do see the list now that some of those aren't.
Okay.
And my last question, if I may, Madam Chair, is, and this is just a question to the bill sponsor, why 4 months? Was there a reason you landed on the 4 months as opposed to 1 month, 2 months? I'm just trying to figure out logic, why 4 months? For the expired tag.
For the expired tag.
I'm just curious.
Just the thinking that they would get plenty of notice, right? That's all.
Okay. Thank you, Madam Chair.
And I do want to comment, because Delegate Cardin raised an issue. One of the things that I think you'll see to this conversation about police officers and, taking that tool away. In my discussion with the FOP and police officers in general, their thought was, if you tell me the rules, I'm going to follow the rules. And if you remove those things from my toolkit, then I understand. If this is a value that the society agrees with, it's one of the reasons why I don't think there's any testimony from the police officers associations themselves. I believe I'm correct with that. So we did talk to law enforcement officers.
Okay.
All right. Thank you very much. We have a few, is Kelly McConney Moore online? And is Theo Schmidt here?
He is.
Oh, there you are. Okay.
This is my legislative director who's done a lot of work in this area. You want to ask him about stats, please feel free to.
Well, he set you up. Is Chris Burbank here? Chris Burbank?
I was here.
Oh, great. I didn't check you off. Okay, great. So I tell you what we'll do. We're going to go ahead and Mr. Schmidt, we're going to go ahead and start with you. And if you could start bringing in Ms. Moore. Oh, thank you. All right, whenever you're ready.
Thank you, Chair Bartlett, Vice Chair Davis, members of the House Judiciary, for the opportunity to testify in favor of House Bill 81. I've worked with the bill sponsor to help ensure that this legislation was guided by available data, primarily the 2023 Baltimore County Traffic Stop Deep Dive and GoCap race-based traffic stop data. Because of this research, I am urging a favorable report. The goals of this legislation are to address a persistent bias that the data makes undeniable. In Baltimore County, between 2017 and 2022, Black drivers accounted for 58% of all stops, while representing 31% of the population. Statistically, a given Black driver was nearly twice as likely to be pulled over than a white driver relative to population. Once pulled over, Black drivers are less likely to receive a warning and more likely to receive a citation. This disparity is even more stark when we start to look at searches. 75% of all probable cause searches in Baltimore County are initiated against Black drivers. These searches yield contraband less often than searches of white drivers. This implies that the evidentiary bar for searching a Black driver is statistically lower than searching a white driver. This is what systemic bias looks like. This is why systemic changes need to be made. The secondary offenses outlined in HB 81 are non-safety related and often used as a pretext for citations and searches as shown in reported data. By reclassifying non-moving violations as secondary offenses, we remove the pretext often used to initiate these biased interactions. This bill is an important step towards making Maryland's roads safe and just for all drivers, regardless of ethnicity. I urge a favorable report on HB 81. Thank you.
Thank you. Ms. Moore?
Thank you, Madam Chair, members of the committee. My name is Kelly Moore. I'm with the Policing Project at NYU School of Law. We strongly support HB 81 as a common sense measure to align Maryland's law enforcement resources with the actual causes of roadway fatalities. This bill prioritizes effective strategic traffic enforcement. Currently, Maryland's traffic enforcement is more like a dragnet. In 2024, the majority of all traffic stops in the state were for minor equipment or registration issues, while only 12% address the high-risk behaviors that are the primary killers on Maryland roads, like speeding, distracted driving, and impairment. HB 81 ensures that officers are not missing the opportunity to stop the truly dangerous behaviors that actually cause injuries and deaths. As you heard from other panelists, evidence from other jurisdictions shows that limiting these kinds of stops makes roadways more safe, not less. Cities like Philadelphia and Fayetteville, North Carolina, found that when they limited stops for minor violations, they saw an increase in arrests for dangerous moving violations and a reduction in serious crashes. When officers aren't tied up with minor equipment violations, they're free to focus on the aggressive drivers who are actually putting other motorists at risk. Finally, there are, as you've heard, hidden costs to high volume traffic enforcement practices. Non-safety stops are actually more likely to end in use of force than stops for dangerous driving. This creates unnecessary risks for both officers and civilians. And these interactions erode the community trust required to solve serious crimes. And finally, as you've heard, stops for minor violations have worse racial disparities than stops for safety-related offenses. Anecdotally as well, chiefs of agencies, such as the former chief of Fayetteville, North Carolina, reported that his officers were injured less often after they inputted practices like this into place. All of this makes HB 81 a smarter approach to traffic enforcement. It's been proven to work in other jurisdictions, and we request a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Sinet.
Thank you, Madam Chair. You know, you were going a little bit fast as far as for me in terms of the statistics or the data that you were showing as far as with drivers in Baltimore City. Can you go over that?
So the data that I have in front of me is
Yes.
talking primarily about Baltimore County, where we found that it was pretty severely with pretty severe disparate enforcement. Otherwise, I have some statewide data, but I don't have anything specifically on Baltimore City.
Oh, my apologies. I thought you said Baltimore City, but the Baltimore County. Okay, all right. And how much of a disparity was it as far as in terms of the Baltimore County that you read?
Right. Thank you for the question, Delegate. In the county, it was 58% of all stops were conducted against Black drivers. 75% of searches conducted during these stops. 75% of the searches conducted against Black drivers during these stops were probable cause searches. And the rate of citations for black drivers in Baltimore County versus white drivers is almost double.
All right, thank you.
Thank you. Do we have any other questions? I was thinking about a question for Ms. Moore, but I think I can forego my question. Seeing no, oh, Delegate Valentine.
Thank you, Madam Chair. I did have one question. Could you define what is a probable cause search?
It is when there is, an officer on the scene has a given reason to conduct a search, some suspicion of an additional crime committed, as I understand it, Delegate.
Okay. Well,
I would say that they're usually in contrast to consent searches, Delegate.
okay. Because that would not be an exception to like under the Fourth Amendment. So a probable cause search, so they're just searching just because they feel they have probable cause, they're searching a vehicle? Is that so? I'm trying to envision why they would have, how they would have probable cause. Are you saying, like, give me an example of what would be probable cause to search a vehicle?
Suspicion of possession of an illicit substance or a firearm. Or,
So like the smell of marijuana that
Exactly.
we eliminated a few years ago,
yes, that
would no longer apply?
That would have been used as a.
That would have been used.
But it is no, you are correct. That specifically is no longer used as a reason for a probable cause search.
So I'm trying to think another circumstance where, what another example of a probable cause search would be now that that odor's gone?
So the data that we're looking at looks at 2 periods, and we have data from before and after the change of that specific probable cause.
Did the data decline after that?
Not meaningfully, no. Not statistically relevantly, no.
Okay. Thank you.
You're welcome, members. Do we have any other questions? Seeing none, that concludes this panel. We're going to move on over to unfavorable. David Messersmith, Scott Schellenberger, and Alan Culver. If you're here, come on down. And whoever wants to start, please begin.
Yes. Good evening, Madam Chair, members of the committee. My name is Alan Culver. I am Special Counsel to State's Attorney Haven Shoemaker, State's Attorney for Carroll County, and former delegate. I'm here today to testify against House Bill 81, which would make primary enforcement traffic violations secondary traffic violations. That would severely limit the ability of law enforcement to enforce the rules of the road and would have the effect of making Maryland's roads less safe. Imagine driving down a road near your home and you see a car that has only one lit headlight, only a rear license plate that is not illuminated, so you cannot read the plate. And even if you could see the license plate, it wouldn't matter because the registration was expired. The license plate was for another vehicle. You cannot see the driver because the tinting on the vehicle is too dark. The driver of that vehicle cannot see you because the vehicle has no mirrors. Furthermore, the driver of the vehicle is changing lanes without using a turn signal while tossing trash out the window. Under this bill, prior to any amendments, the officer would not be justified in stopping this vehicle. Under House Bill 81, all these traffic violations would be made secondary offenses, meaning a police officer could only stop a motor vehicle for these traffic could not stop a motor vehicle for these traffic violations. The bill throws out common sense like the driver tossing trash out of its car window in another ill-fated attempt to limit law enforcement's ability to enforce the law. We can all agree that it's not a good idea to let motor vehicles operate on our roads without proper safety equipment. And is it really a bad public policy to allow police officers to stop a vehicle because it has a busted taillight, even if that stop leads to discovery of serious criminal behavior? Witness how that worked in Baltimore City when former Baltimore City State's Attorney Marilyn Mosby announced that her office would not enforce minor criminal offenses. Not only did these minor criminal offenses go unpunished, but major violent crimes significantly increased. There is a direct correlation to an increase in serious crime when we limit the ability of brave men and women sworn to protect us to enforce and pursue less serious crimes. Speed and red light cameras cannot replace the work of law enforcement. There are too many citizens who lose their lives on the Maryland roads every year. I urge an unfavorable report for House Bill 81, as this bill would reduce public safety and make our roads less safe. Thank you.
Mr. Culver, okay, eeny, meeny?
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, distinguished members of the committee. My name is Scott Messersmith. I am the Deputy State's Attorney in Wycomico County, and I'm here to speak on behalf of that office and the MSAA to urge an unfavorable report on House Bill 81. We've discussed a little bit at the previous panel the exclusionary rule. I will just say it's an extraordinary remedy not to be applied lightly, that the courts don't apply lightly, and not warranted by the ministerial information that's linked to the possibility of exclusionary rule in the bill. As to relegation of certain traffic prohibitions to secondary enforcement status, I would say that failure to enforce the law delegitimizes the lawmakers, emboldens the lawbreakers, and breeds contempt for the law. I am not hearing that these traffic prohibitions that would be relegated to secondary status should be repealed. And if they're not going to be repealed, then they should be enforced. Make no mistake that limiting enforcement to secondary status only is failing to enforce the law. If I, Dad, told son Johnny, don't pinch your sister, but I'm not going to do anything about it unless you also kick her, I would expect an uptick in pinching. This is the same principle. These traffic stops constitute good policing. I can tell you all, I've been practicing criminal law for 25, going on 26 years in this state with 2 state's attorney's offices and an 11-year stint as a criminal defense attorney in between. And these stops remove contraband from the street. It removes guns, they remove illicit drugs, they find injured victims. Whether it's fortuitous, good fortune interdiction or protectual stops, they serve a legitimate law enforcement purpose. And this bill would take that law enforcement tool away. I am no statistician. I do not pretend to be. I am no social scientist. But I do know that correlation, to get to Delegate Cardin's question earlier, correlation and causation are not the same thing. And I have no reason. I read the racial equity impact note that accompanies the bill, and I have no basis one way or the other to dispute the numbers. But even that note concludes that while the available data does not explain the actual causes of the overrepresentation of black drivers with regard to traffic citations, it is indicative of systemic inequities. If we don't know the why of the numbers, then we don't know that the why is illegitimate. And if we don't know the answer to that question, then we have no rational basis for changing the law. So respectfully, I would urge an unfavorable report on the bill.
Okay.
Thank you.
Mr. Schellenberg?
Thank you so much, Madam Chair. Scott Schellenberger, State's Attorney for Baltimore County, in opposition to HB 81. So, you're a police officer. You're sitting in the parking lot right out at Loch Raven Reservoir. It's 7 o'clock at night in the winter and it's dark. And a car goes by you and its headlight is out. And of course, it's the left headlight, the one that's closest to the double yellow line. If you pass this bill, that officer can do nothing to stop that car. But guess what happens within the next 2 minutes? If you've ever been out Loch Raven, Delegate Cardin, that's a winding road. It's hazardous at night. And all it would take is for somebody to slip over that line just a little bit, and now you got a crash. And so that officer who sees a violation, who someone said we should save it for real hazards. Well, you want to tell me what's more hazardous than not having a left headlight when you're in the road at night? That's hazard. And so you're the officer, you see that car go by, 81 passes, you can do nothing about it, and within a minute you hear a crash. And you come to the crash scene, and the cars have run into each other because the person coming the other way couldn't see that headlight. That's what you are going to see when this happens. And oh, by the way, somebody asked about the change we made when smelling marijuana in the odor of a car. My gun seizures dropped like a rock when that happened. They have dropped down in every jurisdiction in this state. But back to 81. These are safety stops. Certainly, I did hear about some amendments that have been offered. I did not know about 3 secondaries was going to be a thing. I'd like to see the amendments. I haven't seen them. But if anything else, we need to change a couple more things that deal with safety. Thank you very much.
Thank you. Members, do we have any questions? Okay, Delegate Cardin.
Thank you all very much for coming to testify. So I want to ask you about what I had asked the sponsor about the bill, because I don't really have, if we can figure out a way to enforce this without having an interaction with a police officer with a gun and causing stress, I'm okay with that. I just want to make sure we can enforce it. So if your police officers are able to identify a car and send the citation directly to the MVA, we may have to tweak the law to do it, but what's the problem with that?
Well, it can't be a citation because a citation also has to go to court, so we'll have to call it something else. But let's call it sends a notice to the MVA. Well, then that person receives information that, you need to prove that your headlight is fixed within, 60 days. I believe a person would have a right to ask for a hearing with the MVA. So now instead of your officer driving to Catonsville District Court, Towson District Court, or Essex, depending on where the incident happened, now you're going to an MVA hearing. So you're creating a whole nother system where people can challenge things. And then the other part is, who are you going to convince, who are you going to prove to that you got that headlight fixed? I mean, I guess you would have to get it fixed and mail something to the MVA, and that's the proof that they got it fixed. And so I just think, I understand your point about can't we create a way to do this? I think it just creates a whole nother system that would be very, very problematic. We already have a system that works. If you get one of these tickets and you go into court and, it was speeding and a tail light or speeding and a headlight, and first thing the judge is going to ask you is, did you get that tail light fixed? Did you get that headlight fixed? And, if you got a lawyer with you, they're going to bring a piece of paper to prove that you did. And so, I just think we have a system that currently works. And I think that would set up a whole new system.
One more thing. One of the charges is tinted windows. Somebody brought that up. I can't remember who. It drives, by the way, these little minor rules drive me crazy because I try and maintain my cars so that I don't get pulled over. That's one of the things. You can't tell what the color of the driver is if they have tinted windows.
Correct. And you can't tell at night usually either.
So maybe that one is one that we should just look at specifically, especially if we pass this bill. Because I agree that we have a problem with race. We definitely have a problem with race, and it's in Baltimore County. As much as you might want to deny it, we have a problem here. However, there are maybe some things that we can work on that are clearly not going to be racially motivated, because tinted windows drive me crazy because I want to be able to make sure that the person, if I know the person next to me is on their phone, I'm going to slow down and get away from them. And if I can't see because they're swerving and I can't see them, I got to be real careful. So,
Delegate Cardin, I don't think any of us would dispute that the data shows that there's racial disparities. I think is there a way we can fix the problem without diluting the rules of the road to make the roads less safe? So that's my concern with this bill.
Yeah. Okay.
Therein lies the issue. Delegate Stinnett.
Thank you, Madam Chair. And that's what I'm kind of curious of, and I know that, and I'm sorry I forgot your name.
Oh,
sir.
Scott Messers.
Yeah. So I was saying, based on your testimony, do you have any data that you can, highlight to us as far as that will support what based on your testimony, would it support it?
On the correlation causation comment that I made?
Yes.
I don't have data. No, I don't have data. I don't have possession of a study. I can tell you anecdotally that, again, 25 plus years practicing on both sides of the courtroom, I can't recall an incident where a police officer was pulling someone over because of what they looked like.
And Delegate Sinet, I could just add on in terms of data. I don't have data either, but what I was thinking about is my concern with these is oftentimes these equipment violations lead to investigations that lead to the identification of drivers that are impaired or under the influence. And so that's my concern. And I was thinking back there in mine, I've been a prosecutor for almost 25 years. It's probably conservative to say that 4 times a year, I've seen DUI cases that develop out of equipment violations. So it's going to be a tool that's taken away from law enforcement when they're trying to make the roads safer when we have drunk drivers out on the road. So I see that a lot. I see the things start as an equipment violation leading to an identification of a drunk driver. So that's one of the specific areas I was concerned about.
So the straight line, the causal connection would be if someone said, I pulled you over because you are a person of color. How many times does that happen?
I mean, how many times has someone told me that?
How many times has anybody ever done that?
No one's ever told me that.
Exactly. That's why we don't have the causal connection. Delegate Val.
For being here. Mr. Culver answered my one question was, we talk so much about gun stops. These lead into confiscation of firearms, and you touched on how often it leads to DUI arrests, which I think is very often, if that's your understanding. But I wanted to ask about the equipment violation because so much has been talked about notification, electronic notification. But I'm trying to see if any of you can maybe help me out. How would that be made? Because one of these offenses under TA 13701 is driving without evidence of registration. How are we mailing a notification if we don't have a tag on a vehicle?
And that one's a concern. I heard there's an amendment.
That's one.
And I think that was talked about as an amendment that it would be after 4 months or something. But then, as someone pointed out, a lot of the driving unregistered are also driving uninsured. So you're still letting people drive uninsured for 4 months. And we see a lot of uninsured cases where it results from a motor vehicle collision. The person's charged with driving uninsured. And I had a case in September where a defendant was uninsured. The insurance company paid on the vehicle, but it didn't cover what was owed on the vehicle for the folks. So driving uninsured, it's not kind of a sexy offense, so to speak, but there's victims of that. There's people who are out of pocket a lot of money because people are involved in collisions when they're driving uninsured.
Yep. Okay. Delegate Valentine.
Thank you, Madam Chair.
Okay. Delegate Conaway.
Testify. So I think the question was asked, how often are people stopped based on their color or what they look like? But maybe 2 years ago, we had someone come in talking about they could tell who a person is by the type of car that they had in their neighborhood. So this committee did hear that. But Mr. Schellenberger, how you doing? I have an academic question. So because the other person, you're on Lock Raven, somebody's coming down Lock Raven, their left headlight is out. They go past the police officer. A few seconds later, a minute later, you hear the bang or crash, right? Then you said because the other person couldn't see the car or the left headlight, how come there was an accident? Why did the other car run into the car with the headlight that's out?
Well, as I pointed out, the road's very curvy up there at Lock Raven, and it's extremely dark. And all you'd have to do is slide over towards that line just a little bit, and you could very well run into that car. Either one of them could slide over to the line a little bit, and they could run into that car.
Okay, I will accept that.
Okay.
But also, is there another line on the right-hand side?
Yes, there is.
So therefore, the driver is not proficient enough to drive the vehicle, be in command of their vehicle when there's a line over there that they can follow that line?
Well,
To know that they're not in the street?
it may also be that because they don't have a left headlight, they can't really see it that well.
See the right line?
Well, no, you'd be able to see the right line.
I know, that's why I'm asking you this. You implying because you couldn't see the left line that there was no way that you could judge where your vehicle was on the road. But I know as a long-time driver, if a headlight goes out on the left, you can watch the line on the right.
Well, it's not just a question of being able to see the line. It's a question of the other person being able to see your car.
Well, they shouldn't come over that line, right? It's just an academic question. Thank you very much. Isn't that so?
Isn't that so? Yes.
Yes. Okay, Delegate Mangione.
Thank you, Mr. Schellenberger. And before my colleague said that, so I'm not directly making a point to contradict you, but I just found this fascinating when you said it because I had no idea, but about 50% of all U.S. traffic fatalities occur at night, despite only roughly 9 to 25% of the total driving vehicle mile traveled happening after dark. And that's the National Highway Traffic Safety Administration Fatality Analysis Report. So in no way not being able to pull over for traffic, I'm sorry, not traffic, for the headlight being out. I mean, in no way having that in there makes driving safer.
Well, Mr. Culver was one that had the stats, so I'll let him answer that one.
Well, not the stats, but without a doubt, when you add all those together, I mean, each one dilutes the safety of the roads a little bit. So I would certainly agree with that, especially with your statistic with the fatalities at night.
It'd be nice if we could add an amendment to this bill to get the registration costs down that they raised last year, but that's a different topic. But thank you.
Delegate Simpson.
Yeah, so the sponsor, first off, thank you very much for testifying favorably to my bill. Got that out there. So the sponsor said this is a research data-driven bill. So I would greatly like to know what is the connection between a headlight being out and drunk driving? I mean, do your headlights go out when you're drinking? Is that the new interlock?
No, but what it allows, it allows proactive law enforcement. So when the bar's let out at 1 a.m., you don't wait till somebody crashes their car before you stop them.
Well, wait a minute, with that logic, you're going to be pulling everybody over.
Well, if everybody's got a headlight out, then maybe you are.
Okay, wouldn't it make more sense to, and I think this is a separate bill, but wouldn't it make more sense to send work orders based on either the toll or the speed cameras, and they could upload a photo or fix it in a repair order? I'm sorry, I can't support the idea of you're searching for drunk drivers, you're searching for other things based on somebody having a broken taillight. If there's not a connection, I mean, if you can fix it so that the lights go out because I'm drinking, by all means.
Okay.
No, it has everything to do with safe roads. And that is, it's all about having safe roads. And if you have problems with your car, then that could be a problem with the way you drive on the road. They're not pulling people over in anticipation of finding a gun. What they're doing is they're pulling them over for violating a law. I mean, if we're going to go this,
Safety, doesn't it make more sense that wouldn't we get more headlights lit up, so that it's more safe if we did it based on a speed camera or based on a toll? And wouldn't it be more equitable if we did it based on either toll cameras or speed cameras? And then that way it's directly connected to the car, it's directly connected to let's get it fixed, it's directly connected to, and we find a way for people to prove it without just not randomly pulling individuals over.
well, I mean, if you're all willing to put the investment in for putting speed cameras on every road and putting red light cameras at every red light.
It's already, we already have them out there. So why would we need to do it on every road?
Because officers are mobile and they move around and they see different areas where there aren't speed cameras and where there aren't red light cameras.
I think there's like 300 and some cameras that are state-owned. And then if you add in all the locally owned, that's a lot of roads that are covered. And then you add the tolls, unless you have somebody who's really avoiding a toll, I think we're gonna fix a lot more headlights than having an officer at whatever hourly rate they are, pulling over each and every person thinking they're, or not, that's actually what we know is not, leaving me to drive around with my lights out, but someone else is being pulled over. Wouldn't it make more sense if we are trying to do safety, and we're going with your argument, is to find a way that actually works more equitable and that gets more lights lit up?
Well, Delegate Simpson, as Mr. Schellenberger said, in Carroll County, we have one small municipality who has speed cameras around the schools, but that's it. We don't have any other areas with speed cameras. We had one red light camera in Westminster, but I don't think that's around anymore,
I'm
so
pretty
we don't
sure
have the cameras.
90% of them leave Carroll County.
Sure, but they're still driving around unsafe in Carroll County.
Yeah, but, okay. Think it through. I think you'll figure out. I'm saying they drive on other roads outside of
Sure,
there.
I agree with that.
State roads, whether even we're looking at, clearing our roads or we're just watching it, you can see the people. And you can zoom in on that license plate, send a work order, get that light fixed.
Okay. Delegate Moreno.
Madam Chair, have any of you reviewed the impact of this type of legislation with any other colleagues around the country, or have any data to support your position?
I have not.
I haven't discussed it with anybody else in the country.
No, as I said,
Or others in the state, potentially?
Other than other law enforcement?
Yeah, I guess.
No, I mean, I've discussed it with, obviously, with our local law enforcement.
Okay.
Delegate Conaway, second bite.
Thank you again, panel. Well, I'm confused on how do you go from a legitimate broken headlight to you find that a driver has a handgun in the car? How do we go from a broken headlight to the gun in the car?
Well, you would need what we call obviously probable cause to be able to search the car. So it could be a broken headlight, you get the license, you want a record check, and there's an outstanding warrant. And if there's an outstanding warrant to arrest, then you can make the arrest and then hopefully be able to search the car. So if there would have to be another crime that you would be witnessing, which is why I brought up the odor of marijuana and how that took so many things away from how they did it. Because it used to be, go through a stop sign, pull them over, windows come down, bang, you get hit in the face with that odor of marijuana. It happened all the time. Now we can't take the next step with that. As far as that does not constitute probable cause to get into the car.
Okay, thank you so very much.
I still didn't quite understand the answer, and I hate to prolong us, but I didn't quite understand the answer, Mr. Schellenberger, about going from a broken headlight to, oh yeah, okay, you said that they would run the license plate and maybe there's something, okay, I got it.
Right, we would need probable cause
Right.
to prove that another offense had occurred.
Right, okay.
Thank you guys for coming. I really appreciate it. So I think we got a little off of the topic a little bit. Delegate Phillips' bill, the intention of the bill is to reduce the number of incidents, police-involved interactions. There's been a move across the country to do that. And we know why. Because more than likely, police-involved interactions between Black people end up not with a traffic violation, but with an unalived Black person. And that is fact. That is a fact we live with every day. This is a little bill, just a little piece of a bill that could possibly lessen the interactions that for some reason end up differently for us than it does for other people. And it just dawned on me, and I wasn't going to say anything. I hate when I say that, but because it's not true. But you just made that connection, and it just dawned on me. Madam Chair asked a question about the connection between the tail light or the headlight and the gun. And race. If someone, by chance, just anyone, believed that a black person is more apt to have a gun, his taillight looks different than Karen's. Do you understand that? So let's not act like it doesn't exist, that race doesn't exist, that racism in policing doesn't exist. Let's talk about the real problem that some of us live with, and very cordially presented it to this body, and we just kind of got off track with
So let's.
traffic lights and because that's not what's happening here.
Well, let's get on track.
Okay.
If you're in Baltimore County and that police officer sees that taillight, the first thing they're going to do is turn their body camera on. They're required to. And so we're going to have a audio and visual representation of exactly the interaction between the officer and the person. And so when they then pull them over, you will have already seen that the taillight is out. That will be proven through the video. When they walk up to the window, the officer will have to find probable cause to do more than just hand you a warning violation or hand you a ticket. And that is captured on video and audio. And so if the officer writes in the statement of probable cause that they looked in the passenger seat and they saw a gun, well, you're going to see that on video. We have to prove all of those things. And remember, all of these things that we're talking about can be challenged and have to be decided by an independent judge who could say, no, officer, you didn't act properly that time. So I think that we're putting in front a lot of good measures. I was actually against body cameras. Now I'm the biggest fan of them. I think they're the greatest thing we ever did. And I would encourage every jurisdiction to have them.
Thank you.
Thank you.
Thank you. And I have one more question, and that is with respect to the loss of life of law officers in traffic stops. Anyone want to address the insignificance of that?
We can't say insignificance with that. But
it's not. I'm making the point because the blanket is an unfavorable. We know we have amendments on the table. So my question is, we know we are losing our officers in traffic stops. I want to make sure that that part is brought home before we conclude this hearing.
And I think that's a fair thing to take into consideration. But I also think that some of these secondary violations also put people at risk, particularly with regard to the headlights and maybe the taillights. I think other things put other people at risk, and we need to balance those out.
Fair enough.
Yes, ma'am.
Those are good closing remarks, and I see no further questions. We are now officially concluding House Bill 81, and I'm going to knock out Delegate Schindler's bill really quickly, and then we'll get to Delegate Askerbell's bill. They've both been here for quite some time. We appreciate you. Delegate Anderson, we appreciate you from Environment and Conservation. Delegate Schindler, Tyler, and Tyler Zett, and is Dr. Cross still online? She gave up. Okay. All right, Delegate Schindler, whenever you're ready, get for House Bill 172.
Thank you very much, Madam Chair, Madam Vice Chair, honorable members of the committee, and Delegate McComas. For the record, I am Delegate Matthew J. Schindler, and I'm here to testify in support of House Bill 172. I'll be brief this evening because I know that you have a long day, and this is identical to the version of the bill that passed through the House last year due to the hard work of this committee. HB 172 is an enabling legislation simply allowing municipalities to authorize code enforcement officers to wear body-worn cameras if they choose. This legislation would allow municipalities to enhance transparency and ensure enforcement officers and constituents are able to access a record of their encounters. In my previous experience in local government, I witnessed many complaints or issues regarding code enforcement that could have been readily resolved if there was a digital record of the enforcement encounter. I believe this legislation will create a tool that can boost government trust, efficiency, and transparency. Body-worn cameras also act as a deterrent towards potential aggressive or confrontational interactions, providing safety for both the officers and the citizens. This bill carries no fiscal note and merely gives local jurisdictions another tool in their toolkit. With that, I thank you all for your time, and I respectfully urge the committee for a favorable report on HB 172.
Mr. Bennett?
Thank you, Madam Chair, members of the committee. For the record, my name is Tyler Bennett here on behalf of the city of Hagerstown in full support of House Bill 172. I know you've had a long day and you have a long night ahead of you. Thank you, Delegate Schindler, for putting this bill in again, and thank you for the work of this committee on the amendments last year, as he mentioned. This is in that same posture. And everything else, Delegate Schindler, me too.
There you go. The words I've been waiting for all night. Thank you very much. And Delegate Schindler, thank you for bringing us a no fiscal note bill. That concludes the testimony for... Delegate Conaway, do you have a question?
Chair, and thank you, Delegate and witness, for coming in to testify. Can you tell me what a municipal employee is?
Are you asking specifically about an enforcement officer or just blankly a municipal employee?
It says, okay, we're gonna go through this. Page 24 says law enforcement officer includes a municipal enforcement officer.
Yes, sir. So a municipal, I'm sorry.
Did I misspeak? Is they the same thing?
So a municipal enforcement officer would mean either a parking enforcement, traffic enforcement, or code enforcement officer.
Right, so that could be the person that's directing the traffic in downtown, let's say in Baltimore City, during the middle of the day saying, come on, run through the light?
Yes, sir.
Correct. Come on, run through. Yes, okay. Thank you so very much for defining that for me.
I appreciate it, Delegate. Thank you.
Thank you for defining that for him. All right, moving on. That concludes our testimony and our bill hearing for House Bill 172. Members of the public, we have been here for quite some time, so we may be getting just a little bit giddy. Delegate Acevedo, come on down. Thank you for your patience, Delegate. I know you have been here for quite some time. Do you have a preference of which bill you'd like for us to hear first?
We can start with the bills that are reintroductions. I'll just go through, sticking with the theme of brevity.
Okay.
We could just go through some of the reintros, and then we can do
with that said,
HB 699.
Okay. With that said, are we going to start with HB 794?
Yes, Madam Chair.
Okay.
Thank you, Madam Chair. I'll be very brief because, again, this bill is a reintroduction. I want to draw the committee's attention to an FBI report/assessment titled White Supremacist Infiltration of Law Enforcement. It is interesting. It is concerning, it's troubling, but it is an assessment that I think this committee needs to seriously consider when talking about who polices our streets and whether or not there is oversight and accountability. White supremacist infiltration of law enforcement is a problem, and this report that was published in 2006, 20 years ago, 2 decades ago, and I don't want to say it was hidden from the public, but it was certainly not shared with the public until Maryland Congressman Jamie Raskin had released the unredacted version of it. But essentially, the report says that, white supremacist infiltration of law enforcement in the United States is not just a problem in terms of intelligence and safety and security of law enforcement, but equally as important, it is a serious public safety concern for Black, Latino, AAPI, immigrant, Muslim, Jewish. It's a serious problem, Madam Chair. And so I brought this to the committee's attention. And the more that we failed to act on this report that is very glaring in terms of the findings, is the more we're putting our constituents and Marylanders in serious danger. And so the bill that I'm proposing is intended to be that first step to ensure that the Police Trainings and Standards Commission, which is responsible for this area in terms of not just vetting, but certifying law enforcement officials in our state, ensure that there is some safety, some process in place to ensure that those who are a part of or affiliate with white supremacist organizations are not certified, are not law enforcement officials who are policing our streets. This is not a report that I produced. It is not a report that I withheld from the public, and it's certainly not a report that I shared with the public, but it is a report that all of us need to take seriously. White supremacist infiltration of U.S. law enforcement is not a joke. It is not hyperbole. It is not some pie-in-the-sky accusation. This is very real. And so if we fail to act to address white supremacy in law enforcement, we're going to continue to see what we have seen for decades, whether it's communities feeling unsafe, over-policed, over-criminalized, and it definitely has a serious implications for public safety. So I urge a favorable report.
And you're not Deborah Levy, but are you here from the Public Defender's Office?
No, Your Honor, I'm sorry. No, Madam Chair, I'm actually here for House Bill 699.
Okay, got it. Okay, great. Members, do we have any? Delegate McComas.
Delegate Acevedo, could you just give me the site to look up that?
So, Delegate, McComas, if you were to just Google FBI, white supremacy, infiltration, law enforcement, you will find the 2006 report/assessment that was done by the FBI that details, that essentially says that one, yes, white supremacist organizations have infiltrated U.S. law enforcement. No state is immune, certainly not Maryland, and that it poses a threat to the protection of intelligence, particularly intelligence that police departments have.
Just get me more than I need. I just need can you email me the site?
Oh, just white supremacist infiltration, U.S. law enforcement.
All right, thank you.
That's literally the name of the report.
Do we have any other questions, members? All right, seeing none, we're going to move on now to House Bill 835.
Yes, Madam Chair. This bill is also a reintroduction. The bill seeks to end no-knock warrants, but really to continue the work that we had started with the Police Accountability Act of 2021. And in previous years, when I introduced the bill, we've heard from opposition testimony, a number of concerns around whether it's law enforcement safety, whether it's around the destruction of evidence. And I wanted to share with this committee some data, some qualitative research that I think not only answers those concerns, but really dispels any misinformation about ending no-knock warrants. And according to a 2023 peer review study published in the American Journal of Public Health examining national SWAT deployment data, forced entry warrant executions were associated with a 42% higher likelihood of a civilian injury compared to announced entries. The authors found no statistically significant decrease in officer injury rates associated with no-knock warrant tactics, meaning the elevated civilian harm did not correspond with improved officer safety outcomes. Another empirical study in 2024 published in Criminology and Public Policy, it analyzed more than 8,000 search warrants executed across several jurisdictions, to include here in Maryland. And the researchers found that in drug-related cases, which accounted for approximately 70% of entries, destruction of evidence occurred fewer than 3% of those incidents. Again, this is a 2024 study that was published in Criminology and Public Policy. More bedtime reading for folks on this committee. The study also further reported that no statistically significant difference in arrest rates or successful evidence recovery between no-knock and announced warrants. We've heard a good bit from opponents that no-knock warrants are already rare, heavily supervised, and limited to the most dangerous situations, and that eliminating them would place officers at greater risk or hinder investigations. Yet the research does not show this. Instead, it demonstrates increased likelihood of civilian injury without statistically significant gains in officer protection or evidence preservation. This bill is really about not just protecting civilians, but also about protecting law enforcement. Maryland would not be the first jurisdiction if we were to end no-knock warrants to do so. I will point to Republican states, more specifically Florida, that ended no-knock warrants. And the reason that they cited for ending no-knock warrants was law enforcement safety. And since doing so, there has been no increase in law enforcement officers being injured, harmed, and I think it really is telling for us in terms of not just the opponent's testimony around law enforcement safety, but also it's another reason why we need to be ending no-knock warrants, because it keeps civilians safe.
Mr. Kramer?
Thank you, Chair Bartlett, Vice Chair Davis, and distinguished members of the Judiciary Committee. My name is Hannibal Kemmerer, and I'm here on behalf of the Office of Public Defender to urge a favorable report on House Bill 835. That's Delegate Acevero's bill to ban no-knock warrants. The bill also limits warrant service to the hours of 8 a.m. to 7 p.m. No-knock warrants are only about as old as I am. They date back to the Nixon administration's war on drugs. The ostensible rationale for law enforcement to utilize no-knock warrants is to secure evidence that might otherwise be lost or destroyed, and for officer safety. You've already heard that officer safety is not diminished when states reduce or eliminate, no-knock warrants. One need not plumb the depths of history for examples illustrating why no-knock warrants are misguided and primarily deployed against minorities and people of limited means. For instance, on March 13th, 2020, Breonna Taylor was in her apartment with her boyfriend when shortly after midnight, Louisville Metro Police executing a no-knock warrant charged through her front door. Taylor was shot 6 times. One of the bullets that struck her was fatal and killed her within 2 minutes. Police were executing a search warrant for an investigation into a suspected drug dealer who police alleged had once received a package at Taylor's home. But the suspected drug dealer didn't live in her building and had, in fact, been arrested earlier that evening. No drugs were found in Ms. Taylor's apartment. As Ms. Taylor's tragic, unnecessary, and untimely death illustrates, people caught off guard by law enforcement, often in the middle of the night, can mistake them for intruders and try to defend themselves with catastrophic consequences. It's preferable and safer for law enforcement serving search warrants to announce their presence, the existence of a warrant, and an intention to enter the residence within a reasonable time, like 20 seconds. We urge a favorable report on House Bill 835.
Thank you. Members, do we have any questions? Delegate Ericon?
Thank you, Madam Chair. Thank you so much, Delegate, for...
I'm sorry, ma'am. I thought is this the bill you wanted to testify on?
No, Madam Chair.
699, right?
Yes, ma'am.
Okay, no, that's okay.
She's just hanging out.
This is a fun place to hang out.
Yeah, this is a fun place to hang out. Delegate Eric.
Thank you, Madam Chair. Delegate, I was trying to pull up the information about Florida's law, because I did find that, as you can imagine, very interesting. It's, holy crap, I don't understand their code real well, so this is like a real lesson for me. So if you have the details of what their law actually says and the carve-outs, I would be very interested to know, because as you know, we did change the law recently, so that now they have to, it has to be signed off by the state's attorney's office. And there's a sort of a limited scope, I guess, about what they're allowed to do with it. But I am very interested in what happened in Florida. So if anybody knows.
Yeah, Delegate, I'll say really quickly, and I'm happy to share some more information, but I just, based on my research, Florida generally prohibits no-knock warrants. And this is something that was passed, and again, as I mentioned in my testimony, what they cited for ending no-knock warrants is safety of law enforcement. No-knock warrants puts civilians and law enforcement in a standoff. You know there's another no-knock warrant bill that's been introduced by a good friend of ours, and I recall him sharing, a testimony about his own constituent that, but we won't get into specifics of that. But the whole point is that we are putting civilians and law enforcement in a standoff. It's just simple, and it's not a safe situation for civilians, nor is it a safe situation for law enforcement whatsoever. Anyone that's entering someone's property unannounced, and especially at a time when folks aren't expecting someone to be, showing up at their place, entering their home. We all know that this is a country where, one can legally have a firearm. And, when you have a situation where there's such a proliferation of guns in the United States, coupled with no-knock warrants, you're putting officers in dangerous situations, you're putting civilians in dangerous situations, and the data, because we got to come back to the empirical data, it just does not show that it keeps any of the people that I just mentioned safe, nor does it contribute to the overall goals of public safety. And I would also add too, we have technology that could be incorporated and have been incorporated in law enforcement to ensure that some of these things, searches, et cetera, could be conducted without having law enforcement showing up to someone's place unannounced, kicking the door in or whatever, and basically being in a standoff with civilians and whoever that law enforcement or law enforcement officials are.
And do you know when Florida changed their law?
I can double check. I can get that information to you, but what I do know is that in addition to banning it, law enforcement in Florida must announce their presence and state their purpose before entering a home. That was part of the law that was passed.
Yeah, I saw that a little bit. I'm just, yeah. So if you find their code is, man, you really appreciate your own code when you look at another state is all I got to say. Okay, God bless you, Florida, but this system is, woo, you make Maryland look real good right now. And with the roads. Anyways, moving on. All right, I really appreciate you, and any information you give me on Florida, I'd like to read.
Absolutely, Delegate.
Thanks.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So, Delegate, this goes back to my first bill 20 years ago. Does Florida have the castle doctrine?
What was I doing 20 years ago?
You were reading, I don't know.
But I'm sorry, what was your question, Delegate?
Does Florida have the castle doctrine?
I believe so.
What's the difference between Florida having the castle doctrine and Maryland not having it?
Well, I believe in Maryland, it's the right to retreat, or one has to essentially obligation to retreat. Right. There you go.
Well,
but
I didn't hear
in Florida,
I didn't hear what these people are saying. I know what my previous chairman.
So in Florida, essentially, it empowers the property owner to defend one castle, so to speak, or one's property, which includes defending oneself, whereas in Maryland, you have to first, I believe, retreat before you know.
Right,
Yeah.
so therefore, if you're upstairs and law enforcement kicks the door in downstairs and you have your carry permit and you have your weapon with you, then you shouldn't be going downstairs to confront law enforcement who kicked your door in, right?
We'll delegate, that's in an ideal world,
No,
but
that's
we
the
know that's
castle
not,
doctrine.
that's,
Isn't that the castle doctrine? If something happens upstairs, I went through exactly this because I asked the chairman, what am I supposed to do? And he said, if you're on the second floor, you're supposed to go out the window. That's what he told me 20 years ago, so now I'm gonna tell you today. I don't know how you feel about that, but that's what I was doing.
Yeah. Still puts folks in a stand. I think, you know, to me, the natural reaction of anyone who is in their home and someone comes in unannounced and they're armed, I am going to look for my weapon and I'm going to make sure that I'm keeping myself safe.
Wouldn't you agree that a person that doesn't know the law and is not aware of the castle doctrine most likely would confront the people that are coming into their castle?
I think you could say that.
Thank you so very much.
Thank you. Members, any further questions? Seeing none, we're going to go to unfavorable testimony now.
I'll shift 2 seats to this side.
Okay. All righty, Delegate, I'm sorry. State's Attorney Scott Schellenberger and Officer Chaz Ball.
Good afternoon, Madam Chair, Vice Chair Davis. My name is Chaz Ball. I'm not actually law enforcement, not an officer. I'm an attorney representing the State Fraternal Order of Police. I've represented law enforcement officers for 13 years, civilly, administratively, and criminally. Specifically, in this case, for the use of no-knock warrants are exceedingly rare in Maryland. This committee and our legislature in 2021 did sweeping legislation on police reform and specifically the Maryland Police Accountability Act. And as part of that, created a system in which the use of a no-knock warrant was exceedingly rare and very specific in the process that has to take place for a no-knock warrant to be executed. Specifically, not only does the officer have to make that decision that a no-knock warrant might be necessary, but his supervisor or her supervisor would have to sign off on it as well. Not only is it the officer and his or her supervisor, but the state's attorney for that jurisdiction. Not a designee, not a designee. The law does not allow for a designee. The state's attorney who puts their name on this decision to do a no-knock warrant, who puts an election down the road on a decision to do a no-knock warrant. And like any other warrant, a judge would have to sign off on it. As part of these warrants, no-knock warrants, it's detailed information is necessary as to the age of the people in the house, the number of the people in the house, whether they have a dog. All of that information goes into this process for a no-knock warrant. And they're exceedingly rare on purpose, but they're utilized for the safety both of the officers that are involved in it, as well as the people that are in the house, whether it be an individual being arrested or others that may be in the house. And they're done on these rare occasions and signed off on judges on these rare occasions because unfortunately, you don't want an officer to be hurt. You don't want the individuals in the house to be harmed either. Specifically, these other states that don't have no-knock warrants, they utilize, most of them are stand-your-ground states where there's no obligation to climb out of the window. And for that reason, I ask for an unfavorable review.
Thank you. Mr.
Good evening, Scott Schellenberger, State's Attorney for Baltimore County. So when all this started back in 2019, 2020, we all worked very closely together as a group to come up with the statute, Criminal Procedure 1203, that created all these protections for the very reason that you all wanted to make sure that you only use these warrants for very important purpose. And the important purpose is officer safety. And, you know, I heard someone mention that we now have the technology to be able to search a house without somebody being there. And I'm not exactly sure how that happens because I don't think we can do things that way. Please remember, it has to be probable cause signed by the officer. The officer's supervisor has to sign off on it. Then I have to sign off on it. And that means in the 2026 election, if I had signed off on one in the last 4 years and something bad had happened, you can imagine that people would be bringing it up. And that's the very reason why we put that provision in. We worked through all of that to make sure that we had all of that there because there needed to be what we called a political, some kind of responsibility to the person who actually does it. I have to sign a no-knock warrant. In my chair right behind me, I have a little briefcase with an iPad. That iPad gets internet everywhere. I carry that around everywhere because I have to sign no-knock warrants, including had to carry it onto a boat once when I went fishing with my high school buddies and got made fun of the entire time. But nonetheless, I think the provisions of CP 203 are very extensive. We worked hard on them. No knocks are needed. We don't want to get rid of them. They should stay.
Thank you. Delegate Ericon.
Thank you, Madam Chair. Okay, so you probably heard the back and forth that we had about Florida. Florida has a knock and announce rule. That's in their code, and the courts have ruled that preemptive no-knock warrants are not lawful in Florida based on the law. But case law does allow for exigent circumstances. So I'm wondering if this bill, or if you guys, if there was some marrying of ideas that could happen where there was, like in Florida, a carve-out included for exigent circumstances that were seen on the ground. So instead of coming to you early, they could make the call. Yes, there's destruction of property risk here, yeah, or destruction of evidence risk. Yes, there's, other types of exigent circumstances. It would get you on the boat, device-free. It would still allow for officers to use it in an emergent situation, but would not require this sort of preemptive thing that we created. This is a structure we just created. What do you think about that idea?
I think the structure that we created is really the best one.
Okay.
Because if an officer knows that their supervisor is going to sign off, the elected state's attorney is going to sign off, and then a judge is going to sign off, they have to have a pretty darn good reason for why they're doing it.
Okay.
And every one of these warrants that I read, and again, there are not many. They are very limited in how often they're using them.
How many would you say you use in a year?
I've probably signed less than 5 last year.
Oh, okay, okay.
And obviously, we're one of the larger jurisdictions. The reason we created it, the reason we have no knocks is because a regular search warrant is this. Police, we have a search warrant, we're coming in. That gives a person just enough time to pull the handgun out of the drawer that's next to their sofa. Exactly the amount of time that they need. And so every one of these no knocks that I read, there is always a recitation of the weapons that they have access to and the violence that is located in the person's background.
Gotcha. So, okay, and how have the 5 that you issued last year, how'd they go?
They went well. They worked well. They got in. They
No civilian issues?
No. I don't know if you remember in the statute, in these warrants, they even have to list how many pets are in the house.
Oh, that's right, yeah.
Because there was a case that somebody talked about, and I understand.
Yeah,
And nobody.
well, they shot the wrong, I think they shot the wrong dog.
Right,
So,
they did.
That'd make anybody upset.
So, but we have to list, or the officer has to list how many pets are in the house so that the officers who are going in know exactly what's in that house, what they're facing, whether any children are there, and even the best they understand about where people are within the house.
Okay.
So it's a very precise statute. Like I said, Baltimore County is a pretty big county, only used about 5 last year. I don't think many people are doing much more than that.
Okay, thank you, guys.
Yeah, thank you very much. I guess I'm I'm having trouble understanding how adding all these people who are signing these no-knock warrants keeps anybody safe. I mean, if you're not having the person who actually you're serving sign the warrant, how does that make the community safe? I don't really see all these extra people signing or what the purpose is of all these extra folks signing. I mean, I thought the goal of the bill, of course, is to just make everything safer for both sides.
It is. I believe when we had our conversation in 2020 and 2021, the idea was, the example everybody was talking about was the Breonna Taylor case, which is a terrible case. And the point was that if Schellenberger had signed off on that warrant and the same thing had happened, he would be held politically accountable for having done that. And I understand that you're making a long face and not quite agreeing with that, but I can assure you that someone would bring it up and try and hold people politically accountable. And I have to tell you, I really read these things. I mean, I read everything I write, I've signed, but these are, I pay very, very close attention to, sometimes me read more than once. And before I read it, one of my assistant state's attorneys has to have read it. So we're very careful about these, and we think they're very important to protect law enforcement.
Sometimes when you add more and more people that are reading something, less and less people actually read it. But that's not really the point, is it? So the concern, of course, in this, where's the statistics that say by having no-knock warrants that there are less police or people's deaths, or that you've done, that, I mean, you keep insisting this is so important, you have it, but where's the data that says this really, I don't know that, and I don't know how much I totally trust the data, but it just seems a little.
It puts more and more people's skin in the game. It's a supervisor that has his or her name on it. So if it goes wrong, if it goes left, which any situation can at any moment, that supervisor could be responsible for it.
The data, where is the data? Where is the data that says that this is more effective than something else? That there are more people who die because of a knock warrant than a no-knock warrant, or the efficiency. It's like, we are well past the time where we should be doing things data-driven and know if something is working or not working. And when someone has died, that is clearly data that's saying this, especially someone who didn't do anything wrong whatsoever. So I do not see, I'm sorry, you tell me you took 2 seconds to knock and say, hey, the police is here, and they're able to, same thing. If you come through my door, busting through my door, you think I'm not going to protect?
Well, and that's why they have to announce.
Okay, well, that's what we're saying with the no-knock. We don't want that.
Well, you
Because
don't announce from the outside, but you will once you're in.
But that doesn't mean that I haven't already, I figure it's someone else that's, just like anything else, you probably are it's more dangerous for you just to start busting through my door, and then I'm going to protect myself not knowing that you are the police.
I can tell you that in Baltimore County, the statistic I can give you is, with every no-knock I've signed and every no-knock that's been executed, no officers have been shot.
And we're literally talking about 5 years. This is 2021 that this legislation, this specific process went into place. So that's data that we're looking from specifically Maryland. There have not been issues with that issue. The officers are announcing once they're inside, but they don't give that individual that couple extra seconds to be able to get a firearm, whether it be to hurt themselves or to hurt others.
Who's fixing my door? Who's fixing my door? You got the wrong house. Who's fixing, even if you didn't get the wrong house, who fixes my door?
The jurisdiction. The jurisdiction actually does.
For your questions. Delegate Conaway, please.
Comment first. You could have a Stingray type phone or a Blueberry satellite type phone. Yep. and that works all around the world. But my question to you was, you said, how can police search a house without someone being home? What does that mean? I don't understand what that means.
I'm sorry, I thought I was referring to the testimony that was given earlier that mentioned that there are other ways to search a house without people going in. That's what I had heard.
Oh, okay. So I had read in the Baltimore Sun that some years ago that law enforcement was using infrared X-ray to look through the walls and see where people were there and all like that. But I guess because you asked that question, you don't understand the correlation between the two. Would you agree with that?
No, I would say that that does exist, but it's not the same as an actual search. You're just looking.
If you have a search warrant for somebody, right? And you know the address where the somebody should be, there is a way that you can look through the walls to know that the somebody is there because that was in the newspaper.
Well, that would end up being in the courts. They would have to.
No, I'm not asking about in the court. You just said, how can police search?
Well, I mean, if you saw the gun, you couldn't pick the gun up if you're not in a house. And that would have to be decided by the courts. If you use some kind of infrared, they would have to decide whether the Fourth Amendment applied to that or not, whether that was a Fourth Amendment violation or not. So that would be a whole new way of handling cases.
Right, but you do admit that you could find a person that you're looking for without going into the house. You could prove or pretty much know that who you're looking for, who the warrant is for, is the person that's in that house.
Well, that goes into the detail of the entire process. So there are processes to determine if somebody walks in the house, if they're in the house or not. As to the constitutionality of the use of the infrared, obviously that could potentially be a search and would have constitutional issues associated with it. But the whole part of this entire process is the attention to the details. And this legislature in 2021 had attention to the details. And the fact is, having a whole process into going into a no-knock unit where you're looking through every detail of who's in the house, how old they are, their educational background, their criminal background, any mental health issues. As you're going through all of that process, it helps to be able to utilize that tool. And it's a rarely used tool, but it's a tool. If there's a situation, instead of going in, having somebody be able to get a gun and commit what we refer to as suicide by cop or hurt somebody else in the house. All of that information goes into the basically research that the officers do in order to make this determination as to how to approach a situation. It's a tool bag. It's all kinds of different tools that they have, and this is one of the tools that, while not used often, is part of that tool bag to keep officers safe as well as the citizens that are in that house.
Thank you very much for your answer.
Thank you very much for your testimony. You've answered just about all my questions. I just want to confirm. So in 2019, we had the Breonna Taylor incident, which was tragic. And we made a decision here in Maryland to try to drastically narrow our no-knock warrant. And I was I worked you through very closely because we were really all about this and we wanted to make sure that it enabled you to still be able to protect us, but also narrowed it. Since that time, this goes back to Delegate Simpson's comments. Since that time when we passed this, I think it was it 2020 that we passed this?
2021
when we passed this. We have had, it sounds like about 5 a year. And is it true that, well, no police officers have been hurt? Has anybody had any problem? Have there been any problems at all since we've passed this?
Not to my knowledge.
Okay. And to your knowledge?
Not to mine either.
Okay. And we haven't had any problems with our no-knock warrant policy at all. And we have not seen, I lost my train of thought on my second question, but that's essentially that it seems to be working.
It does, and I remember being here late at night, trying to work on the details of this bill that we all worked on. And, you know, I'm not down here trying to change that. It's a well-developed system with checks and balances that I think protects both the police officer's safety and follows the law, and that's why I think we shouldn't be changing it.
All right. Okay, thank you.
Members, any other questions? Seeing none, that concludes our bill hearing for House Bill 835. We're going to move on now to House Bill 699. And this is Delegate Acevedo, Clyde Boatwright, and Ms. Rothwell. I'm assuming that Jamie Grace Alexander is not online, and maybe Dr. Cross is online? Okay, well then we'll just go with folks who are here in person. Delegate Acevedo, whenever you're ready.
Thank you again, Madam Chair, members of the committee. For the record, Delegate Acevedo here to present House Bill 699, which strengthens Maryland's use of force statute by establishing accountability when an officer intentionally fails to prevent excessive force or fails to render or request first aid after police action. At its core, HB 699 is about preserving life, strengthening accountability, and reinforcing public trust in law enforcement across our state. Maryland law currently requires police officers to intervene when another officer uses force beyond what is legally authorized and to provide or request medical assistance when someone is injured during police action. However, under current law, it does not include a clear enforcement mechanism when officers intentionally fail to meet these obligations. HB 699 was introduced to address this by establishing misdemeanor penalties for law enforcement officers who intentionally fail to intervene or intentionally fail to provide or request first aid. Under this bill, Maryland reinforces the principle that the sanctity of human life is central to policing. This bill, HB 699, maintains the existing requirement that officers use force only when it is necessary and proportional to prevent imminent harm or to accomplish a legitimate law enforcement objective, and that force must stop once the threat or objective ends. This legislation is needed because while Maryland has made significant progress in modernizing police standards with the Police Accountability Act of 2021, accountability must be paired with enforceability. Without enforceability consequences, requirements to intervene or provide aid risk becoming aspirational rather than operational. House Bill 699 ensures that these life-saving duties are treated as essential responsibilities and not optional actions. This bill also supports responsible law enforcement officers in our state who serve with professionalism and ensures that the integrity of their profession is upheld. By clearly defining expectations and consequences, HB 699 protects those officers by reinforcing professional standards and ensuring that misconduct by a small number of individuals does not undermine public confidence in the profession as a whole. Additionally, HB 699 strengthens protections for community members by ensuring that when excessive force occurs, there is a legal duty not only to stop the harm, but to preserve life through timely medical response. The need for this bill is also demonstrated by real-world cases where officers witnessed excessive force or delayed medical response but could not be held accountable under current law. I recall a few years ago there was a video that ended up going viral of a Baltimore police officer who was using excessive force while his partner stood right there. I'm not sure why he didn't intervene, but this is an example of all too many cases across our state and country where people think it is optional to intervene when excessive force is being used rather than it being an obligation. HB 699 supports families, communities, but also responsible law enforcement. And it is for these reasons, Madam Chair, I urge a favorable report on HB 699.
Thank you. Ms. Rothwell?
Thank you. Good evening, Madam Chairwoman and committee members. On behalf of the Baltimore City State's Attorney's Office, I'm here to testify in support of Bill 699. The Maryland Public Safety Article Section 3-524 was structured to affirmatively require certain actions by law enforcement officers when force is used. While subsections D1 and D2 appropriately limit when and how much force may be used and include criminal penalties for violations, subsection E, which mandates de-escalation, intervention to prevent excessive force, the rendering of first aid, and full documentation, does not carry a criminal penalty. As a result, these provisions, though mandatory in language, are currently unenforceable through prosecution. House Bill 699 addresses a separate but equally critical statutory gap by prohibiting an officer from intentionally failing to intervene to prevent or terminate excessive force and from intentionally failing to render appropriate first aid or request timely medical assistance for an injured person. The bill properly classifies such intentional violations as a misdemeanor punishable by up to 5 years imprisonment. This bill allows for human error, allows for appropriate use of force. It simply assigns a criminal penalty for intentional actions or inactions. The need for this clarification is not theoretical. In State v. Small, the Baltimore City State's Attorney's Office prosecuted Officer Zachary Small of the Baltimore County Police Department under Public Safety Section 3-524 for excessive force. During that incident, 3 additional officers stood by and watched, 2 of whom passively aided in the use of force. While the assaultive behavior was occurring, none of the 3 officers attempted to intervene. When the assaultive behavior ended, only 1 officer attempted to render medical assistance, and that effort was untimely. The state's attorney's office sought to charge all 3 officers for failing to intervene under subsection E2 and/or failing to render aid under subsection E3. However, because no penalty is attached to subsection E, we were unable to charge them with violating Public Safety 3-524. Although the statutory duties are clear, the absence of enforcement mechanism prevented criminal liability. House Bill 699 will correct this deficiency. Importantly, this legislation does not create new duties. Those obligations already exist in Maryland law. Rather, it ensures that all mandatory provisions of 3-524 are enforceable and aligned with legislative intent. The bill is narrowly tailored to intentional misconduct, safeguarding officers who act in good faith while reinforcing professional standards and accountability. Ensuring enforceability of the duty to intervene and render aid strengthens public trust, supports a culture of de-escalation within law enforcement agencies, and provides prosecutors with the tools necessary to uphold the full scope of Maryland law. For these reasons, the Baltimore City State's Attorney's Office respectfully urges a favorable report on House Bill 699.
Thank you. Mr. Boatwright?
Good evening, Madam Chair. Just for housekeeping, I'm opposed to this bill. Should I give my testimony now or I'll wait? I only came because you called.
We have you listed as favorable, and I was wondering, I was like, okay, that's all right. You sure you don't want to change your mind?
No, I'm following directions.
Okay.
You called me, I'm
I
here.
did call you, and it says favorable, but we'll wait until the next panel.
Yes, ma'am.
Thank you for bringing that to my attention. Okay, then we'll go right on to Councilwoman Cross, please.
Thank you so much, Madam Chair, and thank you so much to this committee for bringing this bill. I am Dr. Kashina Cross. It is favorable for me, and Madam Chair, I do apologize. I did have some amendments. After reviewing House Bill 699, I want to weigh in this with the record that I have for public safety and collaboration as a veteran of 20 years, United States Air Force, committed to accountability of governance. Clarity of definition and the intentional violation of insured officers in acting rapidly and involving dangerous circumstances are not subject to criminal liability and the reasonable judgment errors. The establishment of clear statewide training standards and funding support to ensure every department, including small municipality agencies, can meet the compliance requirement is necessary. Require that documentation and standards that distinguish between failure to act in situations where medical access and officer safety prevents immediate intervening or aid, and also include the implementation guidance to develop jointly municipal leaders and law enforcement command staff to ensure uniform application across our jurisdiction. I submit this testimony, Madam Chair, because Local governments depend on professional law enforcement to protect our residents while maintaining the legitimacy through transparency and accountability. I will say House Bill 699 reinforces the important principle that the preservation of life must remain central to public safety operations, and that requirement that officers intervene when excessive force occurs, render first aid for the injured, results and reflects expectation of this municipality and others. We must codify these expectations and strengthen our public confidence and affirm that accountability is applied at every level of authority. And in this same time, effective policy must recognize operational reality. We do acknowledge this and support a favorable with amendments.
Thank you. Members, do we have any questions? Delegate Conaway?
Thank you, Chair. Thank you, Delegate. To the last person that testified, were you testifying on the bill or the bill and your amendment?
Thank you, Delegate Conway. We're testifying on the bill itself, and I also would like to add those amendments. Unfortunately, of course, the system closes out at 6 p.m. I'm happy to provide those amendments to the body.
So you didn't discuss any amendments?
Yes, sir, I did. I discussed those earlier. The clarification of definition, the establishment of clear statewide training standards and funding support for the departments, and to require, departments standards to distinguish between failure to act in the situation where medical access and officer safety prevents immediate intervention or aid, and then fourth, including the implementation guidance developed jointly with a municipal leadership and the law enforcement command staff to ensure uniform application across the jurisdiction, sir.
Yeah, thank you so very much. Thank you for clarifying that for me. To the delegate, so on page 3, line 8, there's a mention of 10 years for drawing a gun or pointing a firearm. Now, am I correct that what this bill is doing is dealing with something else and it's making it a 5-year possible penalty? Is that right?
Repeat that. What provision of the bill are you citing?
On page 3, line 18, you see the 10 years for a police officer that violates this subsection, which deals with drawing the firearm and pointing the firearm at a person. But what this is doing is adding a penalty for these other related crimes or the other incidences, like not stopping someone from being hurt like that. Is that correct?
Yes.
Thank you so very much.
Thank you. Members, do we have any other questions? All righty, seeing none, then that concludes this panel. And yes, Dr. Cross, if you could submit the testimony, that would be great. Thank you. Now, Mr. Boatwright, if you want to come in, and Attorney Chaz Ball. I got it right this time. This is the unfavorable panel.
Good afternoon again. Thank you for the mini heart attack that you gave me a moment ago when the person I'm counsel for came up for a favorable when I had signed up for unfavorable. I would say under Maryland law, under current Maryland law, once again represent the state FOP, and I'm asking for an unfavorable bill. I've represented law enforcement officers, as I said, for over a decade, criminally, administratively, as well as civilly. Under current Maryland law, before the statute, an officer who fails to do something to render aid under certain circumstances or who fails to intervene can be criminally charged. Under Maryland law, now, we have what's called the common law misdemeanor of misconduct in office, which comes in 3 modalities. Malfeasance, which is doing something that's unlawful in and of itself corruptly. Misfeasance, which is doing something lawful in an unlawful manner. And nonfeasance, which is the failure to do an act which an officer is supposed to or is required by his or her duties to do. That's under current Maryland law. In the case of the Zachary Small, which was mentioned by Ms. Rothwell, the officer, not only was the initial officer charged but also the other officers that the state contended failed to do an act were charged as well. They were charged with misconduct in office for alleged nonfeasance. I'll note in that case, the officer who was charged with the assaultive action was found not guilty. I'll also note that the other officers, all of their cases were dismissed. Under current Maryland law, the government is already able to charge with this. They do charge with this. Not 2 years ago, the Baltimore City State's Attorney's Public Integrity Unit, which Ms. Rothwell is part of, charged an officer for failure to stop one civilian from attacking another civilian. So not even stopping another officer, stopping a civilian from attacking another civilian. It can be charged under current Maryland law. It is charged under current Maryland law, and a change to the law is not necessary for this process to take place.
Mr. Boatwright?
Good evening, Madam Chair, members of the committee. My name is Clyde Boatwright, President of the Maryland State Fraternal Order of Police. I just want to say that since the Maryland Police Accountability Act of 2021, we've made great strides across the country and across this state, particularly in the areas of police and community relationships. I think there was a time that we had some issues with policing, but I don't want to get into a position that we are taking a step back by criminalizing one particular profession. Just want to draw your attention to a study done by Johns Hopkins. The third leading cause of death by people in this country is medical malpractice. We're not trying to charge other doctors or nurses for standing by for a doctor committing medical malpractice. So why are we charging or attempting to charge police officers for not intervening and physically intervening when it's already against the law, as far as we believe it's against the law, because you can be charged with assault if you allow someone to assault someone in your presence, whether you're a police officer or not. It's against policy, and we've, again, made many great strides in this state regarding police and community relations, and I just don't want to get into a position where we're hindering or hurting our recruitment and retention issues based off of the fact that people feel like just by being a cop, you can be criminally charged and sent to jail. So with that, we urge an unfavorable report. Thank you.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, witnesses, for coming in. So just a real quick question, Mr. Boatwright.
Yes, sir.
You said if you stand in the presence of someone that's being assaulted, you could be charged?
Yes.
And what rule is that?
No, so if I'm a police officer, and this has happened.
You mean the police officer?
Yeah, as a police officer and another.
Not as a civilian, right?
No, as a police officer.
As a police officer. So if a police officer witnesses another person assaulting a third person, then they have to intervene.
You must intervene.
Okay. My question was, I see that we have this 10-year time limit. That's why I was trying to bring that up. So when we were talking about the misconduct in office, those 3 different charges, you didn't say what the time penalty was for each of those charges.
Misconduct in office is a common law misdemeanor, meaning there isn't a specific time period. Anything that's not considered to be cruel and unusual could be a sentence for misconduct in office.
Can I ask a question?
Oh, excuse me.
That's very eloquent and all, but are we talking it can exceed 5 years, it can exceed 10 years? You see, this bill has time periods in it, so you're just saying there's no time period?
There is no time period.
Well, that's why we have the bill.
Anything that's not a violation of the 8th Amendment of the United States Constitution could be the sentence for misconduct in office. So it can go beyond 10 years. It could go however long is not found to be a violation of the Constitution.
Could you see that this is one of the reasons that we need this bill so we know what kind of time we're looking at?
Well, the time doesn't only go for the maximum time that's necessary.
So the answer is no.
Well, no. It also goes to, we do have judges are given certain time periods for what's expected for different crimes. In the same way that second-degree assault has a maximum period of 10 years, that doesn't mean someone's going to get 10 years every time someone's charged with first-degree assault
What
or
about
second-degree assault.
misconduct in office?
Anything that's not found to be a violation of the 8th Amendment of the United States Constitution.
Okay. Thank you.
Members, do we have any other questions? I see none. So that concludes the testimony for this panel, as well as the bill hearing for House Bill 699.
Thank you.
Thank you. Glad we got that straight out. All right, we're going to move on now. Members, how is everybody? We're hanging in there? Do we need a stretch? We probably need a stretch. Get your stretch in if you need to get your stretch, and come right back. So House Bill 132, Delegate Grammer. Delegate Grammer, do we have Joyce King? I see Lori Ruth. Do we have Angel McBoyd? Angel McBoyd? Okay, great. And Jean Henningsen? Okay. And Lisa Jordan?
Sorry.
All right. Cooking with gas.
I'll get started when you're ready. All right, thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 132. House Bill 132 allows intercepted communication and evidence derived from the communication to be received as evidence in limited cases. What if your family member was a victim of a horrific crime? A crime that was recorded, a crime that objectively happened, but justice would never be served because the only evidence you had was a recording. And the only purpose of that recording served was to traumatize the victim over and over again. Maryland is an all-party consent state. That means it is illegal to record a private conversation, whether in person or via telephone, unless everyone involved in the conversation gives their consent. This leaves any recording, even the recording of a criminal infraction, inadmissible as evidence. House Bill 132 attempts to fix this problem, and it does so by allowing admission of recorded communication as evidence if a court determines that the communication is offered as evidence, the communication was not made as part of a law enforcement investigation, the communication is more probative than other evidence that can be procured through reasonable efforts, and it's in the interest of justice. In this limited case, any such communication must be provided to the adverse party sufficiently in advance of the trial. This bill is the product of 4 years of work, and we think this version is the appropriate solution. I would like to remind the committee of a shocking statistic revealed to us last session. Approximately 6% of all rape cases are prosecuted, and approximately 1% achieve a conviction. While those terrible numbers have many root causes, a significant cause is the fact that to prove the burden of the crimes requires evidence that only exists in the form of a recorded communication. We should reform this law with those victims in mind. Thanks for the opportunity to present House Bill 132. Be happy to take questions, and I'd ask for a favorable report.
Thank you. Whoever is next. Okay, I'm going to call it. Ms. Ruth, you're going to start.
Thank you, Madam Chair, members of the committee. For the record, Lori Ruth from the Maryland Network Against Domestic Violence. I'm here in support of HB 132. We've supported this bill with Delegate Grammer and across the street before, I believe. Just a brief correction from something I said this morning when we were testifying on, I don't know, 802 or 688, when Delegate Erican asked how 802 and 132 were different. That it is, 802 is civil and criminal, 132 is criminal only, and it's a crime against an individual. And I left that out, so I just wanted to say in front of everybody that that's the difference. You know, as we said earlier today, you've probably forgotten since then. We come and testify every year because something needs to be done for this type of evidence. It is irrefutable. It is very difficult to tell people you have this irrefutable evidence that you can't use. And so in the criminal arena, this would be really, really important for prosecutors to be able to do and grant immunity to their victim and witness to be able to use it. And for those reasons, we urge a favorable report. Thank you.
Yes. Good evening, everyone, Madam Chair, Vice Chair, in committee. Speak into the mic. Sorry. Well, my name is Angel McBoyd. I am a new mother who experienced intimate partner violence during pregnancy and custody. In my case, the abuse was not constant physical violence, it was coercive control. It was threats to have me jailed, threats to have my unborn daughter taken from me, contacting potential employers with false allegations in an effort to interfere with my employment, showing up at my home after being told no and saying, "Who's going to stop me?" Those threats were verbal, strategic, and isolated. And like many survivors, I was told to document everything. But Maryland is an all-party consent state. Recording those threats, the very proof courts often require, can expose survivors to criminal liability. And even when recorded, the evidence can be excluded entirely. That creates a dangerous imbalance. The person making the threat understands the legal technicalities of recording. The person being threatened is left with their word against someone else's, essentially a credibility contest. HB 132 provides limited defined discretion for courts to admit intercepted communications in certain criminal proceedings. This bill does not eliminate privacy protection, it acknowledges reality. In coercive control cases, the abuse often lives in words, threats, intimidation, manipulation made behind closed doors. And when those words directly impact safety and stability of a child, the court's ability to consider relevant evidence aligns with Maryland's longstanding commitment to acting in the best interest of the child. Admissibility can mean accountability. Exclusion can mean silence. For survivors navigating pregnancy, custody, and concerned safety, that distinction matters. I respectfully request a favorable report on HB 132. Thank you. Great job.
Perfect timing. Ms. Henningsen?
Yes. Good evening, Madam Chair, Madam Vice Chair, and members of the committee. My name is Jean Henningsen. I'm the Chief Communications Officer for Turnaround. Turnaround is the designated rape crisis center for Baltimore City and Baltimore County and a comprehensive domestic violence provider. Core components of our work include crisis response, survivor advocacy, legal referrals, trauma therapy, and community education. We're also the regional navigator for Baltimore County and Howard County, providing specialized services for survivors of human trafficking. So every year we support survivors as they navigate criminal investigations, prosecutions, and protective order proceedings throughout Maryland. It's he said, she said. So many survivors of sexual violence and domestic violence have heard these words and known that was the end of the line for their case or any hope for accountability. It's a line that we as a society continue to fall back on because often it's just too uncomfortable to pursue the truth in these cases. It's easier to blame the victim or cite a lack of evidence and move on. However, many survivors of these violent acts do have evidence. They manage to hit record on their phone in the midst of an assault or abusive incident, or their children recorded it while they were hiding in another room. At Turnaround, we've had dozens of cases of survivors with recorded evidence of their assault or abuse, all of which is inadmissible. In fact, the survivor could be charged with a felony for that recording. With House Bill 132, advocates are simply seeking to bring Maryland in line with most other states. Being able to access these recordings in situations where the best and most suitable evidence would give law enforcement more tools to solve some of the most egregious crimes of our society, while still ensuring the rights of the adverse party are protected under the law in line with other rules of evidence. We request a favorable report on House Bill 132. Thank you.
Good evening, Madam Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, the coalition of all the rape crisis centers across the state of Maryland and people who want to end sexual violence. We're here in support of House Bill 132. Delegate Grammer, thank you for continuing to champion this bill over years. Like Chair Bartlett, you are a leader in this area, and you have even come back to the Judiciary Committee from the foreign land of E&T. So this bill is one of three very similar bills that have been introduced in the General Assembly this year. You already heard the previous bill that was civil and criminal. There is a bill across the street that is this bill plus hate crimes. This one is the most narrow of the three bills that are being presented to you. It is only crimes, and it is only crimes against individuals. The word person is not used because persons would include corporations. This is really against people. So this is a very narrow bill. And from MCASA's point of view, I will again say what we've said for several years, and that is this is a real problem in Maryland. We have rape cases with you have two people alone in a room, which is the most common location for a rape, and we have an audio recording of the rape. And the juries are unable to hear the testimony, and it's the best testimony. This bill does not touch the criminal felony prohibition. against recording. Certainly, we support Delegate Simpson's bill to make that a misdemeanor, not a felony. But you could pass this bill and not change the criminal prohibition against recording, and then prosecutors would have to just advise the person about the penal risk and provide immunity. And that happens in other situations too. So this is a separate issue. It's something that you can pass. It's something that we really urge you to finally pass and address this issue in one of the 3 vehicles being presented this year. Thank you.
Thank you. Members, do we have any questions? Delegate Erickson?
Thank you, Madam Chair. Thank you, Delegate, for bringing this. My question's for Angel. Thank you so much for coming in, sharing your story. And you don't have to share anymore, but I'm curious what ended up happening with your case, if you want to share.
Yeah. Currently, we're going through a custody proceeding. He's just tried to seek sole custody of my daughter. Informed employer I was going for, told them I was a drug addict, I was angry, I was this disruptive person all the way around. So he's trying to do anything in his power to make sure I don't get any future employment as well as lose custody of my daughter.
I'm so sorry. Well, we really appreciate you coming and talking about your story with us.
Thank you.
Delegate Conaway?
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So, Delegate, can this bill be used in cases that are other than sexual violence?
Thanks. That's a great question, actually. So 4 years ago, this problem was presented to me this way. It was presented to me, the gentleman who came to emailed my office said, we have elderly folks with cognitive disabilities in retirement communities, and they can't communicate. And their families are coming in, and they have mental distress, they have evidence of physical abuse, but we couldn't determine what was happening without making a recording of that room. And so they subsequently would put a camera there, and they would hear the staff mentally, emotionally abusing that elderly person. But because they had a cognitive disability, they had problems communicating, the mom and dad, they couldn't communicate what was happening, and they relied on that recording to figure out the crime in question. So absolutely, the answer to your question is absolutely yes. There are probably, there are hundreds of crimes against individuals that this could be used to help solve. But as you hear, the folks, the victims that come back, because there's such a need to fix this problem, unfortunately, is the sexual abuse, the assault community. I think you can tell how important this issue is for them.
I can tell. I was just curious why you didn't limit it to that starting out, and then next year come back. If you come back next year.
If you recall, there have been several iterations of this bill, and this is either the 3rd or the 4th iteration. It started significantly different. This is a great version, and I have to admit I've leaned on the ladies on this panel to help me find a great way to do this, and I think this really is the best way.
This is a great bill, isn't that so?
Isn't that so? Thanks, boss. I appreciate you.
Members, do we have any other questions? Seeing none, that concludes this panel. That concludes
Thank you.
The bill hearing for House Bill 132. And Delegate Grammer, you're going to be right there for a minute. We're going to go ahead and move to House Bill 398.
I'll get started when you're ready.
Yep, if you could, that'd be great.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 398. House Bill 398 adopts a framework for the legal use of persistent aerial surveillance, including the constitutional check of the warrant requirement. When persistent surveillance systems started surveilling the city of Baltimore, it did so in a discrete agreement without any public awareness. The wide area live feed surveillance system was developed for wartime use. After being shut down in Los Angeles and Dayton over privacy concerns, the program was brought to Baltimore and authorized by Baltimore City Police. The Fourth Amendment is not a guarantee against all searches. What it does do is limit searches to only those found reasonable by law. The Supreme Court has long held that aerial surveillance does not constitute a search in considering the Fourth Amendment. However, the persistent monitoring makes aerial surveillance more equivalent to GPS monitoring, which the Supreme Court has already considered a search. It was on this premise that the Fourth Circuit Court of Appeals based its opinion when it ruled the Baltimore City program as unconstitutional. As aerial and drone-based surveillance expands in all realms of law enforcement, we should make the checks and balances around surveillance clear. We are lawmakers. We shouldn't rely on judges and case law to protect the Fourth Amendment. We should do our jobs and place statutory boundaries around this technology. Thanks for the opportunity to present House Bill 93. Be happy to take questions, and I'd ask for a favorable report.
398, right? Okay, good. I just want to make sure. The Vice Chair.
Thank you. Could you elaborate a little more on what is considered persistent aerial surveillance? Has that been determined?
Yes. So when you think of persistent aerial surveillance, think of a plane that flies constantly, recording some type of visual. It has a persistent visual recording, and that could be in the form of a camera or a set of pictures that is continually taken. And in the case of happened in Baltimore City, it was not the video, it was the set of pictures. They essentially had a high-resolution camera that took consistent pictures very quickly of the entire region.
Thank you.
Thank you.
Delegate Conaway, do you have another question?
Yes, thank you. Thank you, Chair. Thank you, Delegate, for bringing this bill. So just to be clear, aerial surveillance, does that cover the drones?
No, actually, that's a great question. It could cover any technology. It's really about the recording as opposed to the delivery. So it could be a drone, but more frequently it's some kind of plane that's operated without a pilot. And there's a little bit of a differentiation there.
Well, I don't understand that, but isn't that so? Thank you.
All righty. I think we have no more questions, and that concludes this panel. We'll move on to unfavorable. Scott Schellenberger. When you come see us, you really stay all day, don't you?
I do. Oh, we have pizza coming, great. So I'm here opposed to House Bill 398. The Supreme Court has ruled that everything that you put out in the public is not subject to the Fourth Amendment. The Fourth Amendment protects people's in their persons, houses, papers, and effects against unreasonable searches and seizures. In Katz versus United States, the Supreme Court ruled the Fourth Amendment protects a person where there's a reasonable expectation of privacy. But when you're putting yourself out there in the public, walking down the street, driving your car, or anything like that, that is not a reasonable expectation of privacy. And that's particularly true nowadays when we have so many visuals everywhere we go. You can't go anywhere without you being captured on a camera and recorded. 7-Eleven, outside here, everywhere you go, you're being captured. So the Supreme Court has ruled that an airplane can fly 1,000 feet over a person and record, and that doesn't violate the Fourth Amendment. They also said 400 feet with an airplane, a helicopter doesn't violate the Fourth Amendment. So the question is, do we need a law in the state of Maryland that goes farther than the Fourth Amendment, which was designed to protect us all to be safe in our persons, place, and effects? Right now, a police officer could just follow you around because they want to, and that would not be a violation of the law. I just don't think that the idea of not allowing any aerial surveillance over a period of time, a persistent period of time, is a good idea, particularly nowadays with drones. It goes out there to look for missing people, to look for suspects, and to look at things maybe like where police officers are going to do a search warrant. So I'm against House Bill 398 because I think there's plenty of protection with the Fourth Amendment.
Delegate Simpson.
So do you support drones finding HUD lights that are out?
You win.
Thank you.
All right, Delegate Conaway.
Thank you, witness, for coming in. Would you consider a drone to be aerial surveillance?
The way I'm reading the statute, I think it is.
And so if law enforcement, let's say we're looking over your privacy fence and they saw you growing more than 3 marijuana plants with the drone, that could be aerial surveillance too. Is that possible?
I think that's possible. I can tell you that in Baltimore County, we're certainly not going to spend our time on that.
Well, but you brought that example up when we were having the marijuana. I remember. I think you did.
I think that's an interesting example.
Isn't that so?
You have a good memory.
Yes, sir. Thank you.
Thank you. Oh my gosh. Delegate Arakan.
It's a long night. Thank you, Madam Chair. Thanks for being here. Okay, but let's just say it's not talking about drones. Let's say it's literally just talking about these spy planes that flew over the city. Don't you think it's a little creepy?
Creepy doesn't mean it's against the law. Creepy doesn't mean it violates the Fourth Amendment.
I agree, but we could still say it goes past the level of acceptable government creepy into why are you flying a plane over hundreds of homes and just snapping pictures for hours a day. I don't think it meets the criteria of reasonable use of a technology like this. I mean, it's just indiscriminately snapping pictures. It's almost like the Office of Pre-Crime. Do you know what I mean?
Well, you know, it may not be a wise use of resources, and that is certainly something can be decided on a different level or a different area. I just don't think the legislature should pass a law that says you can't do this. There might be a very good reason for doing it, and that's why I don't want it taken away.
But you don't use it.
No.
Okay.
In this day and age right now, we don't. But I can't tell you what's going to happen in the future or what might happen in a certain case that we might need. I'm thinking more in terms of flying over a large wooded area like the NCR Trail or something like that, if you were looking for something or people.
Well, if you had if there was a stated reason, but this is just indiscriminately flying a plane and snapping thousands and thousands of pictures of people just to see where are they going. There's no real reason sometimes. There's no real probable cause.
Well, they're trying to spot crime, and anything that you put out in the public is free game. Like I said, walk into the 7-Eleven and get my dinner as I'm leaving here tonight.
Oh, Lord, do not get your dinner there.
It's that bad.
Do not do that. Get
Delegate,
the sushi. I hear it's great.
Delegate Simpson has less respect for me than she did before.
Yeah, you're going down right now, sir.
But you know, anywhere you walk nowadays, you are on video. And all I'm saying with this bill, I don't want to make it wrong for the police to not have one more way to surveil and look at stuff if they need to.
But could we agree that there is a difference between being on video of my neighbor's door camera and the government surveilling me?
Well, if you're up in the air like that, we're not going to be able to tell it's you.
Oh, I believe they absolutely could tell it was me when they compare it with cell phone data and other things. But I appreciate you.
Okay.
I always appreciate you.
Thank you.
I have a question. Gosh, if I can remember it. Suppose there was an exigency exception.
I think that would help. That would get us closer to a good place as far as law enforcement goes.
Okay.
So like exigent circumstances could allow. So for instance, I would consider an exigent circumstance that if a child is missing and you're looking for the child.
Absolutely. Okay, thank you.
Yeah. And I'm going to save you all a lot of time on the bill that's left on the no-knock, 464. I'm just going to say the word ditto.
Great.
Yes.
All right, that concludes the testimony on HB 398, and next we have HB 464.
Thank you, Madam Chair. I know I'm sitting in the way of pizza here, so I'll be quick. Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 464. House Bill 464 discontinues the use of no-knock warrants in Maryland. On January 21st, 2005, a no-knock warrant was executed on a home in Dundalk, Maryland. The door was breached and a flashbang grenade was thrown. Woken from her sleep and fearing intruders, Cheryl Knoll grabbed a lawfully registered gun near her bed and held it pointed at the floor. When the SWAT team kicked open her bedroom door, Cheryl Knoll was shot 3 times and killed. In evaluating the use of force by officers, we make allowances for the fact that no-knock warrants can be exceptionally confusing and fast-moving, with officers required to make split-second judgments under suboptimal conditions. Therein, we judge officers under a more forgiving standard. What is seldom recognized is that those on the receiving end of a no-knock warrant are disoriented, off guard, and are completely unprepared in these circumstances. What frequently ensues is the worst-case scenario. The occupant pulls a weapon in defense. In these cases, there's almost always a fatality. This was the case in Cambridge, Maryland, when officers executed a no-knock warrant on Andrew Cornish, who emerged from his bedroom carrying a sheathed knife. He was shot in the face and forehead and killed. This was the case with Cheryl Knoll of Dundalk, Maryland, who was shot and killed. This was the case of Duncan Lemp of Potomac, Maryland. Judge Pamela Harris wrote in a related dissent, "This precise sequence of events, a surprise and defensive reaction by a resident to which the police respond with force, is exactly what the knock and announce rule was designed to prevent." Unfortunately, knock and announce and the castle doctrine has been almost completely eroded in Maryland. I believe we put both residents and law enforcement at heightened risk with the continued use of no-knock warrants. With this bill, we restore knock and announce and we commit to a less volatile issue of warrants. With that, thank you for the hearing for House Bill 464. Be happy to take questions and I'd ask for a favorable report.
Thank you. Delegate Conway.
So very much for bringing this bill. So what was your comment about the castle doctrine?
You know, the castle doctrine is actually, it's really important because in these kind of situations in Florida has the castle doctrine. They also.
I'm talking about Maryland.
In Maryland doesn't have the
right,
castle doctrine.
What did you say about the castle doctrine?
It's been completely eroded.
Here in Maryland?
Correct. We do not have the castle doctrine. We do not have stand your ground.
Okay. Thank you very much.
Thank you. Any other questions for this panelist? Thank you. That concludes the favorable. We have one unfavorable witness. Mr. Chaz Ball.
Yes, good afternoon again. I'll follow Mr. Schellenberger, and in interest of time, just reiterate my testimony from HB 835.
Does that mean we don't get to ask you questions?
If you'd like to.
That's, I seeing no questions. Thank you for being here.
Thank you all. Have a wonderful night.
All right. And that concludes the testimony on HB 464. And next we have HB 471 with Delegate Grammer.
I'll get started when you're ready.
You may. Go ahead.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 471. House Bill 471 adopts a constitutional framework for the legal use of drones in law enforcement. Drones change the balance between citizens and state. Unlike helicopters or traditional surveillance methods, drones are inexpensive, quiet, and capable of persistent monitoring. They can hover for extended periods, collect high-resolution video, and operate without the public even knowing they are present. That capability is impressive, but raises profound surveillance concerns. Drones remove the natural friction that once restrained surveillance. Helicopters are expensive. Long-term monitoring requires manpower. Warrants require judicial oversight. Drones eliminate those practical barriers. When surveillance becomes cheap and effortless, the temptation to use it more broadly increases. What begins as a tool for search and rescue or tactical emergencies can quickly expand into routine monitoring. We have seen this pattern before. Programs initially justified for narrow public safety purposes often expand over time without meaningful public debate. The disclosures made by Edward Snowden illustrate how surveillance authorities, once established, can grow far beyond their original scope. That history teaches us that guardrails must be built in at the outset. There are also serious concerns about the data retention and misuse. Drones collect vast amounts of high-resolution footage that can be stored, analyzed, and shared. Who controls that data? How long is it kept? Is it integrated with facial recognition systems? Without strict statutory limits, today's flight could become tomorrow's searchable database. Drones are associated in the public mind with military operations and battlefield surveillance. Normalizing their use in everyday policing risks deepening the perception of a surveillance state. A free society should not become accustomed to being watched from above as a matter of routine. Our approach to law enforcement should always be, first and foremost, pro-Constitution. Thanks for the opportunity to present House Bill 471. Be happy to take questions, and it asks for a favorable report.
Thank you. And Mr. Boatwright is on your, is listed, but I don't see him here. So members, do we have any questions?
Thank you so much.
Thank you. And for our final bill for the day, this is House Bill 1031. Is this the Hunter bill? This is one of many of the Hunter bills. Yes, everybody light those microphones. Okay. So presenting on my behalf for House Bill 1031 is our very own Hunter Marsh. Yay!
Ready when you are, Madam Chair.
Whenever you're ready, thank you.
Good evening, Madam Chair, Madam Vice Chair, and distinguished members of the House Judiciary Committee. For the record, my name is Hunter Marsh, and I have the distinct pleasure of serving as the Chief of Staff for the House Judiciary Committee, and I'm here to urge a favorable report on House Bill 1031 on behalf of Chair Bartlett. Simply put, with our proposed amendments, this bill applies Maryland's law enforcement use of force standards to members of any National Guard. If a National Guard member violates our state's use of force standards, this legislation would impose a misdemeanor penalty subject up to 10 years imprisonment upon conviction. I asked Chair Bartlett if I could present this legislation because throughout my career, I've had the honor to work side by side with several service members who not only taught me about service, honor, and commitment, but they also demonstrated in every aspect of their lives just how proud they were to wear those uniforms. Those uniforms that fought against tyranny, not for it. How a citizenry should feel protected by those in uniform, not fear them. In June of 2025, for the first time in nearly 80 years, the President of the United States deployed federal troops in a state against the will of the governor. This sparsely and grievously precedented measure was without legal sanction, but the President continues to threaten numerous cities and states with federal militarized intervention, including my hometown of Baltimore City. Our servicemen and women are held to the highest possible standards, but in recent months, we have seen an abdication of justice and a dereliction of duty from the federal government in prosecuting clear and obvious cases of abuse by members of the executive branch and law enforcement roles. Last month, Renee Good and Alex Preddy were summarily executed in the streets of Minneapolis. In both cases, the federal government has stalled and stonewalled state investigators while refusing to conduct their own investigations. While we have not seen examples of abuse like this in any recent National Guard deployment, it is clear that should a member of the National Guard deployed from another state against the wishes of our governor use excessive force against a citizen of this state of Maryland, the current federal administration is not interested in seeking justice nor punishing those who violate our citizens' civil rights. That is why we need House Bill 1031, to create a method of recourse that the state of Maryland can use to take action against federal abuses of power. The framers of the Constitution sought to establish a unified national government of limited powers while maintaining distinct autonomy in which state governments could exercise police power. That is why the National Guard is under the command of the state unless they are federalized. The Posse Comitatus Act limits the use of federal military personnel to enforce domestic law and does not apply to National Guard units under state authority. but House Bill 1031 focuses on National Guard units deployed without the consent of the state. When the president talks about the enemy within, we should be alarmed at his amorphous language. When our neighbors are being executed without due process, we should be alarmed at the speed at which the federal government dismisses accountability. In the face of manufactured chaos and federal overreach, we should be alarmed, but we do not have to be afraid. For our state, our country, and our republic, and on behalf of Chair Bartlett, I urge a favorable report on this legislation. I'm happy to take questions.
You have an hour to file if you want to run.
No, I'm good here, Delegate. Well.
Delegate Ericon.
Thank you, Madam Chair. So good to see you on the other side of the
It
table.
is great to see you, Delegate
Let me
Arcon.
toss you a softball.
Yes.
Can you tell me how this would not violate the supremacy clause?
Well, thank you, Delegate. I believe that's a great question for the courts to answer.
Oh, fail, come on, man, no, what? Lord almighty. No, on the advice of counsel, sir, you have not retained him. No, I do think that there could be a supremacy clause issue here. Have any other states done this?
Not to my knowledge, but we are no stranger to dealing with supremacy issues in the House Judiciary Committee.
We are also no stranger to passing unconstitutional laws we ask our Attorney General to defend.
Yet to be seen in court.
Okay, well, we'll find out if it passes, we'll find out in court probably pretty quickly that it is a direct violation of the supremacy clause.
And I look forward to it.
Do we have any other questions? I have one.
Yes, Madam Chair.
Oh, Delegate Cardin has one. Okay.
I mean, I don't know if you can any research on this, but if the National Guard is called up by the governor, then there wouldn't be a supremacy clause issue, would there?
Yes, I would agree with that. And also, there's an amendment that was sent out to you this morning. Just want to be clear on this amendment here. We struck the definition of National Guard from this bill. As you can see in the original bill, it references Title 32, Section 502. We struck that from the bill because we believe National Guard member is a common use term and it does not need to be defined. So that broadens the scope of it a little bit. But also, as you see in amendment number 2 in the amendment that was sent this morning, we inserted, this section may not be construed to supersede a more stringent use of force standard applicable to a National Guard member under the Maryland Code of Military Justice or other military law. So the way we drafted this was to basically focus on out-of-state National Guard units who were deployed into the state of Maryland without the consent of the governor.
Okay, and so the way it sounds like it's drafted, basically what you're trying to do is make sure that National Guard, non-Maryland National Guard folks deployed in Maryland have to actually observe Maryland law.
Yes, because under this bill, if it was a Maryland National Guard member, they would be subject to the Maryland Military Code of Justice, which out-of-state National Guards in most cases are not.
Thank you. Thanks for bringing the bill.
Thank you.
Any further questions, members? Delegate Conaway, do you have a question? Okay.
Second kinetic force. Thank you, Chair. Thank you for bringing this bill. So are we simply saying that if this military group comes in to the state of Maryland, that the National Guard can defend Marylanders? Is that what we're saying?
No, that is not what this bill is saying. This bill would simply apply our use of force standards to a National Guard member who commits a violation of our use of force standards that causes serious physical injury or death.
To a citizen of?
To a citizen, to anyone in the state.
To anyone in the state of Maryland?
Yes.
Okay, that's kind of what I said, but a little bit different. But I appreciate you. Thank you.
I appreciate you too, Delegate.
Isn't that so? Thank you.
Any further questions? All right. Seeing none, Hunter, thank you very much. Well presented.
Thank you very much. This was my first time presenting in JUD.
That was your first time ever?
Yes.
Ah. Okay. Well, members, we ended on a great note, and we ended, actually before I thought we would, but so we did pretty well. Thank you all for hanging in there with us, hanging in there as a group tonight, and we will have our voting session We just need to give a few minutes for setup, and we'll go into our voting session. So you have about, we're going to start at, we could start at 8:15. Is that okay with everybody? Okay, 8:15. All right, thank you. No.